But it's one of those fun things that you just get into that agreement. You got it? Kayla, right. You met, I just didn't see you. You were sick of bodybuilding.
That can survive. That can survive.
Yeah, we did. Were you going to do it? Oh, fitness.
Oh, okay.
That's
Texas.
That's the right answer. Because they are listening. Generally speaking, people who don't respond well are not good people. They have more problems than I do. Okay. Intake, please. Thank you, sir. Hello. Hey, CBS, how you doing? Hey, Wally.
This is Goss. Oh yeah, I'm going to break out of here about could you? The chicken guy is Secretary of Agriculture.
Good morning to everybody who's here, and especially those who have prepared for testimony today. We welcome everybody on what I think will be the final day of Judge Gorsuch's confirmation hearing. We've already heard 2 days of impressive testimony from the nominee. I think he's shown great command of the law, and I think he has showed humility with his humble delivery, and I think people learned a lot about not only our political system but our judicial system with what's going on the last 3 days. Today we'll hear from a number of outside witnesses. We'll hear from a number of distinguished witnesses, both in support and in opposition to the nominee. They will all speak to the qualifications to be a Supreme Court justice. I look forward to hearing from all the witnesses today. Let me modify this a little bit because I'm going to spend maybe 15 minutes at the Agriculture Committee because the nominee for Secretary of Agriculture is before that committee, and I'm a member of that committee, and I'll have somebody else chair. That won't stop the business going on. So that's the only time I should probably be away. Each of our witnesses will have 5 minutes to make an opening statement, and then we'll proceed to questionings if members have questions of the members. We'll obviously accommodate that. Now I'm going, oh no, do you have an opening comments? I'm sorry, I just about forgot you.
You didn't worry about that. I do not, Mr. Chairman.
Okay. Now we'll go to our first panel. We'll feature 2 representatives of the American Bar Association. You may come to the table. I'll start over again with the Standing Committee on the Federal Judiciary, Nancy Deegan and Shannon Edwards. Nancy Deegan is the chair of the American Bar Association Standing Committee on the Federal Judiciary, and Shannon Edwards is the 10th Circuit representative on the American Bar Association Standing Committee of the Federal Judiciary, and served as a lead evaluator on the Standing Committee's investigation of Judge Gorsuch. I would like to swear you, if you would let me. I don't know whether we have to stand. I guess we just do it naturally. Do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? No. Each answered affirmatively. We would now have you give your statement, please.
Thank you very much. It's a privilege to be here. I am Nancy Deegan from New Orleans, and I am very privileged to chair the American Bar Association's Standing Committee on the Federal Judiciary. And as you indicated, Senator, I'm joined today by Shannon Edwards from Oklahoma City, who is our 10th Circuit representative and was the lead evaluator on the Standing Committee's investigation of Judge Gorsuch. The Standing Committee has conducted its independent and comprehensive evaluations of the professional qualifications to the federal bench for the last 60 years plus. The 15 distinguished lawyers who make up our committee come from across the country representing every federal judicial circuit. They annually volunteer on a pro bono basis hundreds of hours to evaluate nominees to the federal bench, and we focus solely on a nominee's integrity, professional competence, and judicial temperament. We don't consider a nominee's political affiliation, philosophy, or ideology, and we do not solicit any information from any nominee with regard to how he might vote on a particular issue or matter that may come before the court. The Standing Committee's evaluation of a nominee to the Supreme Court is based upon the premise that a justice must possess exceptional professional qualifications. All 15 members of the Standing Committee participate in the evaluation of a Supreme Court nominee. Each Standing Committee member reaches out to a wide range of people within his or her respective circuit who may have information regarding the nominee's integrity, professional competence, and judicial temperament. Additionally, reading groups of scholars and practitioners review the written work of the Supreme Court nominee and advise the Standing Committee of their findings. The reading groups independently evaluate the nominee's analytical ability, knowledge of the law, application of facts to law, expertise in harmonizing a body of law, and the ability to communicate effectively. The academic reading groups involved in Judge Gorsuch's evaluation were composed of experts in their fields from the faculties of the University of Pennsylvania Law School and the Loyola College of Law in New Orleans. The practitioners' reading group included nationally recognized lawyers who have argued before the Supreme Court and served as law clerks to justices on the Supreme Court. These three groups read all of Judge Gorsuch's published opinions and many of his other writings. During the evaluation of Judge Gorsuch, the Standing Committee members contacted almost 5,000 people nationwide who might have knowledge of Judge Gorsuch's professional qualifications, and these included judges, lawyers, academics, and members of the general community. Circuit members then interviewed those who indicated that they had personal knowledge of Judge Gorsuch through their dealings with him as a judge, colleague, co-counsel, opposing counsel, teacher, organization member, and even classmate. We followed Judge Gorsuch's career from his time at preparatory school through his tenure on the 10th Circuit. All interviews were conducted in confidence to assure accurate information and candid assessments. Finally, as we do with every evaluation, we conducted a personal interview with Judge Gorsuch. Ms. Edwards and I met with him on February 27th and questioned him on a wide variety of topics. After our comprehensive evaluation was complete, our findings were assembled into a detailed, confidential written report, which included the written reports of the academic reading groups and the practitioners' reading group. And this report was approximately 1,000 pages long. Each member of the Standing Committee then studied that final report and individually evaluated Judge Gorsuch using 3 possible rating categories: qualified, well qualified, or not qualified. To merit a Standing Committee rating of well qualified, a Supreme Court nominee must be a preeminent member of the legal profession, have outstanding legal ability and exceptional breadth of experience, and meet the very highest standards of integrity, professional competence, and judicial temperament. The rating of well qualified is reserved for those found to merit the committee's strongest affirmative endorsement. Having examined Judge Gorsuch through this lens, the Standing Committee members unanimously voted that he deserved the well-qualified rating. On March 19th, we submitted a written statement further explaining our process and our rating, and we respectfully request that it be made a part of this committee's official record. Thank you.
Thank you. Ms. Edwards is not going to say anything, is that right?
We are pleased to answer any questions that the committee may have.
Yeah, I think I have a couple questions. They're somewhat repetitive of maybe some of the things that you said, but I'd like to have that emphasis. But before I give a short statement, I would like to compliment anybody who serves on evaluating these judges at all levels, and probably at the level of the Supreme Court, it's much more difficult and elongated, as it probably should be. But I know David Brown, Des Moines, Iowa, who does this with a lot of judges and takes it real seriously.
Yes, sir.
And you almost, when you visit with him about the work he does, you almost think it's a full-time job, and he's obviously got to go make money someplace else, so he must have some time to practice law, but he really seems to me like he puts a lot of time into it.
It's an honor, sir.
So for both of you, I would compliment you on what you do. As you noted in your testimony, the American Bar Association awarded Judge Gorsuch its highest rating of well-qualified by unanimous vote. The statement explaining the rating states this, and you've said this already, but let me repeat it. The rating of well-qualified is reserved for those found to merit the committee's strongest affirmative endorsement. In other words, the rating of well-qualified is not given lightly. Would you agree with that?
Absolutely.
Okay. Now I just want to mention a few points from the report. First, the standing committee found that, quote, Judge Gorsuch enjoys an excellent reputation for integrity and is a person of outstanding character, end of quote. In fact, one of his colleagues on the bench said, let me quote, I have known and interacted professionally with Judge Gorsuch since his appointment to the 10th Circuit Court of Appeals. In my experience as a judge, I cannot identify a person more qualified in every sense of the word to serve as an Associate Justice of the United States Supreme Court. Judge Gorsuch would be an invaluable addition to the High Court, end of quote. Second, the committee found that the judge's professional competence exceeds the high criteria reviewed by the committee. In fact, the committee report stated, given the breadth and diversity and strength of the feedback that we receive from judges and lawyers of all political persuasions and from so many parts of the profession, the committee would have been hard-pressed to come to any conclusion other than Judge Gorsuch has demonstrated professional competence that is exceptionally outstanding. Time and again, those with whom he has worked and those who have been involved in cases over which he has presided have applauded his intellect, thoughtful discernment, and written clarity, end of quote. On the judicial temperament, the committee found that lawyers and judges alike overwhelmingly praised his judicial temperament. And finally, on judicial independence, the committee found, quote, that Judge Gorsuch believes strongly in the independence of the judicial branch of government, and we predict that he will be a strong but respectful voice in protecting it. And one person interviewed for the report stated, quote, in addition to his outstanding academic credentials and brilliant mind, Judge Gorsuch's demeanor and written opinions during his tenure on the 10th Circuit demonstrate that he believes unwaveringly in the rule of law and judicial independence. In my opinion, he is exceptionally well qualified to serve as a Justice of the Supreme Court of the United States. I wholeheartedly agree with the American Bar Association's assessment of Judge Gorsuch. And I have one question, but before I do that, I think we had 2 days of about 20 hours total that people had a chance, if they were watching, to view some of those things that you said about his belief in the rule of law and judicial independence. In fact, if there's any one thing that I heard in answer to so many questions that somebody wanted either a yes or no, what they really got is, I'm going to follow the law, and I believe in judicial independence and following precedent. Now, So I think being a little bit repetitive, but this is my last question. Would you describe once again for the committee the scope of review that allowed you to come to these conclusions? And then I'll go to Senator Feinstein.
Yes, sir. To merit the Standing Committee's rating of well-qualified, we found, sir, that he was a preeminent member of the legal profession, that he has outstanding legal ability and exceptional breadth of experience, and that he meets the very highest standards of integrity, professional competence, and judicial temperament. And we did this in connection with reaching out to those who had personal knowledge about Judge Gorsuch's integrity, professional competence, and judicial temperament. And we did that by interviewing many people who not only encountered him as a judge, but also as an opposing counsel, as a co-counsel, as Principal Deputy Associate Attorney General for the United States, as a private practitioner, as a law clerk for the Supreme Court and the D.C. Circuit, and through personal dealings with him. So the scope of our investigation was deep and broad and involved all 15 members of our standing committee, in addition to those 26 professors from those 2 law schools and the 14 very well-recognized practitioners who have appeared before the United States Supreme Court and who previously acted as law clerks. So that is the scope, Senator, and as I said before, we do not give the well-qualified rating lightly, and I can assure you that every member of the Standing Committee reviewed intently the 997 pages that were compiled, from the interview notes to the analyses by the law professors and the practitioners, in order to each independently reach that rating on a unanimous basis.
Senator, if I might add, our task Could you turn on your mic?
Yeah, thank you. You sure can, Ed. I think for no other reason than all your relatives back home ought to hear something.
Some of them are up pretty early. Our task was to cast a wide net, and that's what we did. So we made contact with over 5,000 individuals. I personally contacted 344 and received comments from 82. So every one of the committee members did likewise, and that's why our report's 944 pages long.
Okay. Now, Senator Feinstein.
Thanks very much, Mr. Chairman. I want both of you to know that I very much respect what the American Bar does in these events, and I've read your reports now for some 24 years, and very much appreciate your work. Let me ask you a question, and then I just want to make a comment. Did you review the documents that cover his performance at the Department of Justice?
These are documents that were recently submitted to the committee. Is that right, Senator? When we received our information from the Department of Justice, on which we started our analysis, what we call the PDQ, which is actually called the Senate Judiciary Questionnaire, the responses to that, we got those on CD-ROM, and we got a stack of materials, and then there was a supplement. We did not receive the responses that were recently submitted to the committee. I did take a quick look at what that encompassed just from the description on the website of the Senate Judiciary Committee, and saw that it involved some 170,000 pages. And I sat in some of the, Ms. Edwards and I sat in some of the hearings, and we heard some of the questions that the committee members asked of Judge Gorsuch, and it appeared from his answers that these materials were prepared in his role as a Principal Deputy Associate Attorney General, and that he, in answering the questions, indicated that he was acting as a lawyer, and at one point I believe, Senator, you may have asked him about some handwritten note, and he said, I don't have any independent recollection of that, but if I wrote it, it's because I got that from my client, his client being the federal government. We did not have an opportunity to review those materials. We would base our information on the personal knowledge of those who dealt with Judge Gorsuch, and if he was acting in his capacity as a lawyer to anyone, that may be protected by the privilege.
okay.
But we are happy to review that if necessary in order to determine if we need to adjust the rating. But based on what I heard, I don't believe that it would change the opinion of the committee.
I appreciate that. And the documents, I just want to clear, aren't 150,000 pages. The documents I'm referring to are much smaller in number, maybe a stack like this.
Oh.
But what they do indicate are some of his personal thinking on subjects of great concern, namely torture. And in a way, I regret I didn't ask more questions. I will do some written questions in that area. I happen to hold the view that a member of this government is held to a different standard than an attorney may be in private life. That if you think something is wrong, you have an obligation to do something about it, not just say, well, my client wanted, my principal wanted this, and so I did it. And we have too much of that in this area. But I also want you to know that I think the work you do is very fine. I read it with care. Let me just say one other thing. And I'm going to do this because for many of us, what has happened this past year has been very painful. And you have also done an evaluation of Judge Merrick Garland, who was not given the privilege even of a committee hearing. So I would just like to read some excerpts from your report on him. Garland's integrity is off the scales, page 5. Garland is the best there is. He's the finest judge I have ever met. There's no one who is his peer, page 5. Judge Garland has no weaknesses, page 6. He may be the perfect human being, page 6. He is unnaturally blessed with brilliance. Things come to him quickly, page 9. In my opinion, there is no better federal judge than Chief Judge Garland, page 10. Garland's integrity is flawless, his competence terrific, page 16. I know no one, bar none, with more integrity and more commitment to truthfulness and accuracy than Judge Garland, page 17. There never has been a better candidate than Chief Judge Garland, page 18. I have never heard anyone say anything bad about Judge Garland, page 18. I read this simply to dispel anybody's thinking that this man was not worthy of this committee's hearing. So thank you very much for the work that you have done, and it's very much appreciated.
Thank you, Senator.
Thanks, Mr. Chairman.
You bet. And I think Judge Gorsuch made very clear yesterday and the day before his feelings about the competency of Garland as well. But the other thing is, maybe when I was talking about David Brown, I was trying to compliment you all without saying we appreciate your work very much and know you work hard at this. But I know how David Brown does it, and I assume I've got some understanding of what you go through, although I've never done it and will never have an opportunity to do it. I'm going to look right here and then left. Is there anybody on our side that wants to be recognized? Senator Graham? Anybody else that wants to be recognized on our side? Okay, but I'll get a Democrat before I come back to you.
Thank you both very much for the work you do. Is it fair to say that the people you called was a group beyond the Federalist Society?
Yes.
Okay.
I don't think we knew if they were in the Federalist Society or not.
I don't know how many members there are, but the odds of all of them being called are probably pretty limited. Would you say that he's a mainstream judge?
Well, Senator, it depends on what you mean by mainstream. We believe that he meets and exceeds the highest standards of integrity, professional competence, and judicial temperament. So if that's
Probably-
mainstream, the answer is yes.
Well, let's put it this way, if there's a stream, he's on the quality end of the stream, right?
He's fishing in it.
He's fishing in it, there we go. Are you from South Carolina?
I'm from Oklahoma.
Close enough. Would you say he's a reasonable judge?
Absolutely, based on the feedback we received.
Would you say he's lived a good life as a person?
I'll let you answer that.
My answer is yes.
Okay. Did you hear his testimony that he believed the Detainee Treatment Act outlawed waterboarding?
We were here yesterday.
I can't say that we did actually hear that, Senator.
No, I remember hearing that. Okay. So I just want to thank you for the service you provide to the committee and to the country, and I hope people are listening to your evaluation as to Judge Garland. Everything you said is absolutely true, and I'll talk more about the way the process in the Senate works. But thank you both. You did the committee and the country a great service.
Thank you. It's been an honor.
I'm looking to my left, and I didn't say I'm looking at the left. Anybody over here have a question?
I don't.
Okay. Then I'll go back to Senator Kennedy. Well, I thought you didn't raise your hand.
I just want to say one thing.
Oh, then it's your turn.
I'll defer to Senator Hatch.
I'll be happy to defer to you, Senator Kent. I just want to thank you for the work that you've done. I agree that Merrick Garland is a wonderful person and a very good judge. I went to see him personally. I helped him to get through back 19 years ago, maybe more than 19 years ago. And that was a problem. There's no question about it. But now that has been resolved, do you see any reason why we should not totally support Judge Gorsuch?
Well, the ABA has given Judge Gorsuch its highest rating, and so that is the most affirmative endorsement for him as we can, so no, sir.
And that's hard to get, I have to admit. So I appreciate the really hard work that you folks do, and it's very meaningful to the committee at this time. Thank you, Mr.
Thank
Chairman.
you.
Senator Blumenthal? Okay, now Senator Kennedy.
Thank you, Mr. Chairman. Thank you, Ms. Deegan and Ms. Edwards, for all your hard work. I know how exhaustive your analysis is. How many grades are there, the different levels of qualification?
3, qualified, not qualified, and well qualified.
Okay. So it's basically A, B, and F.
I will add that some of the people that we talked to asked us if there was an extremely well qualified.
Really? An A+. And Judge Gorsuch received an A.
He did, well qualified.
And how many people contribute to this evaluation?
Well, the 15 committee members all participate, and in addition, we had 2 academic reading teams read all of his published opinions and other writings, and that was about 26 additional lawyers, academics who are experts in their fields, in the fields that they reviewed. So if it was a securities law case, the securities law expert read those opinions. And additionally, practitioners, which include those who regularly appear before the Supreme Court, that was 14 additional. So if you add all that up, if my math is right, I'd say that's about 55 people or something like that, and all very distinguished lawyers and academics.
These 55 attorneys, are they all Republicans?
No, sir.
They all Democrats?
No, sir. Very varied. Big firms, small firms, Democrats, Republicans. In fact, we don't even, we don't get into a political affiliation, Senator.
Good for you. Is it a gender diverse group?
Very gender diverse, diverse, every kind of diverse you can imagine.
Okay, and it's racially diverse?
Yes, sir.
You probably don't even ask this question, but in terms of religion, is your sense is that it's diverse?
Our sense is, but we don't ask that question.
Okay. And this group together gave Judge Gorsuch an A, well qualified.
Yes, sir.
Okay. All right. And some asked to give him an A+, is that right?
Yes.
Okay. Well, I just want to say for the record, I don't know Ms. Edwards, I just had the pleasure of meeting you today. My dad was from Oklahoma. I love Oklahoma.
Thank you.
But I know Ms. Deegan, and she is one of the most prominent lawyers in Louisiana, Mr. Chairman. She's an undergraduate graduate of the University of New Orleans. She's an honors graduate of Loyola. She's a former adjunct professor at Loyola. She practices law with Baker Donaldson, one of the premier law firms, not just in Louisiana, but in the world. And I trust her judgment. And my experience with Ms. Deegan has been that she calls it like she sees it. She's joined here today. I'd be remiss if I didn't recognize, I'll call him her lesser half. Lesser half, but still substantial. Mr. Sid Deegan, who is another very prominent attorney. He went to UNO. He went to Tulane to law school. He founded his own law firm, and he is here today volunteering his time. I know them both well, and I trust their judgment. If they tell me that Judge Gorsuch is the best, you can take it to the bank, you can take it home to mama, because it's true. And I thank you.
Thank you, Senator.
I believe that that's the last of the questioning for the committee and for the American Bar Association and for the country. We thank all of the people that participated and will continue to participate in this that you have reported. Thank you very much.
Thank you.
We'll take 30 seconds for staff to give the names of the new people. And I would ask the new people to come and stand behind their chair. And then I'll swear you before you sit down. I'm going to go ahead and start the introduction anyway. The next panel will be Judge Tacha, Ms. Massimino, Judge Henry, Mr. Jaffer, Judge Kane, Mr. Perkins, Ms. Brasch, and Mr. Calamine. And if I pronounce anybody's name wrong, correct me when you testify. Let's see. I don't think we should. Oh, I'm sorry. I thought maybe you're moving properly now. I thought maybe you weren't here. Okay. You're obviously here. Yeah. Okay. Would you, do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
I've seen positive response. So I think, please seat. And we never get everybody to honor the 5-minute rule, and I don't expect you to stop in the middle of a syllable or anything like that, but if you see the red light come on and you can summarize in about 30 seconds or so, it'd be very much appreciated, because I'm sure that there'll be some questions of some of you, and so we want to move things along. But I think I'm going to do it in the way you're seated there, from my left to my right. So would you start out, Judge Tacha?
I'm pleased to do so, and good morning to the distinguished members of this committee. It's a privilege to appear today to support the nomination of my former colleague and my friend, Neil Gorsuch, as an Associate Justice of the United States Supreme Court. I served with Judge Gorsuch on the United States Court of Appeals for the 10th Circuit, and I was privileged, actually, to be chief judge of that circuit when Judge Gorsuch was appointed in 2006. In my brief time today, I will touch on 3 aspects of Judge Gorsuch's qualifications, all of which I consider very, very important for judges at every level in the judiciary. First, Judge Gorsuch, the judge. Judge Gorsuch brings to the bench a powerful, powerful intellect, combined with a probing and analytical approach to every issue. He brings to each case a strong commitment to limit his analysis to that case, its facts, the records, and the law cited and applicable. He does not use his judicial role as a vehicle for anything other than deciding the case before him. The, quote, case or controversy requirement for jurisdiction is, for Judge Gorsuch, a guiding principle for his judicial role. He is a student of constitutional structure and of the Federalist Papers, and he takes very, very seriously the appropriate roles assigned to each of the 3 branches of government. He is an elegant and accessible writer. In my judicial writing classes, I assign some of his opinions to demonstrate the importance of narrative to every case before the courts. His jurisprudence is informed by textualism, originalism, and precedent, but not in a formalistic or rigid way, only as the lenses through which to seek an appropriate resolution of an issue or a case. Judge Gorsuch is a case-by-case-by-case judge whose dedication is to serving litigants and the 3rd branch of government. Second, Judge Gorsuch, the colleague. On a multi-judge appellate court, it is my view that one of the most important characteristics of an effective and efficient court is the level of collegiality among its members. This is not at all about getting along to get along. It is about improving the quality of the work of that court by careful and respectful listening to varying and divergent views, participating and engaging in robust internal debate about procedures and cases, and factoring in and listening to the diverse views of each of the other judges. Judge Gorsuch is such a judge. His attention to the views of his colleagues informs his work. He has an acute sense for identifying those circumstances where reaching consensus is the highest value, and on the other hand, those decision points where personal conviction and reason dictate individual judgment and independent decision-making. Judge Gorsuch believes in the court as an organic and flourishing entity, where the views, the backgrounds, and the perspectives of all the judges on the court are important to the quality of his work. Finally, Judge Gorsuch, the person. Neil Gorsuch is my friend. He has been from the day he took his role as my colleague in 2006. I want to say that again and say it advisedly, because it means something that despite the many differences in our life experience, in our backgrounds, in our education, and in our interests, Judge Gorsuch immediately and always affirmed me, both as a person and as a colleague. I have watched him with all kinds of people in the courthouse, in social settings, and in the rough and tumble of judicial travel and duties. He is unfailingly kind. He's thoughtful, and he's empathetic to all people. His is the kind of dignity that reflects the dignity he accords to all people. Judge Gorsuch lives according to his values. For him, faith, family, community, nation, and his beloved Colorado define who he is. He is, for me, the gold standard in public service. So for all these reasons, I urge the committee and the full Senate to confirm Judge Neil Gorsuch as an Associate Justice of the United States Supreme Court.
Perfect.
Massimino. Thank you, Mr. Chairman and Ranking Member Feinstein and members of the committee. It's an honor to be here today as you consider the nomination of Judge Neil Gorsuch. I speak on behalf of Human Rights First, an independent, nonpartisan organization dedicated to advancing American leadership on human rights. My focus today is on the dangers that arise when the executive branch claims unfettered authority in the name of national security. When presidents override constitutionally mandated checks on their power, they threaten fundamental rights, the rule of law, and democratic ideals. They also undermine national security. This is not a hypothetical concern. Indeed, now would be an especially perilous time to promote to the Supreme Court a judge who wouldn't stand up against presidential power grabs. The president has advocated torture and other war crimes, banning people because of their faith, deporting refugees without due process, and he's done all of this largely while bypassing Congress and expressing contempt for judges and the judiciary itself. So the key question you should ask of Judge Gorsuch is this: how would he respond in the face of what may be unprecedented threats to basic rights, separation of powers, and the rule of law? In our nearly 40 years, Human Rights First has never opposed a judicial nominee, and we do not do so today. Nor do we question Judge Gorsuch's credentials, which are exemplary. I'm here simply because his record raises concerns that I think you should address before moving forward with his nomination. The stakes are too high to get this wrong. Our concerns arise from the public record of Judge Gorsuch's time at the Justice Department. They fall into three areas: subversion of congressional authority, restricting judicial review, and torture. On all three of these issues, Judge Gorsuch is not a blank slate. As a political appointee at the Justice Department, he was directly involved in defending the Bush administration's claims that the president has extraordinary power to disregard laws in the name of national security, and that the judiciary either cannot or should not review such actions. These claims constitute a frontal assault on the integrity of our constitutional order. Not surprisingly, they were rejected by the courts. With respect to Judge Gorsuch's role on congressional authority, after photographs surfaced in 2004 showing horrific abuses at Abu Ghraib, Senator McCain spearheaded the Detainee Treatment Act, strengthening the ban on torture, which passed the Senate with 90 votes. Judge Gorsuch pushed for his presidential signing statement, saying the president could disregard that law to the extent it conflicted with his authority. Judge Gorsuch argued that the law was, quote, best read as essentially codifying existing interrogation policies, policies that included waterboarding and other forms of torture and abuse that Congress specifically intended to prohibit. Second, on judicial review, Judge Gorsuch repeatedly sought legislation that would strip courts of habeas jurisdiction, including for people who were tortured or unlawfully detained. He also played a lead role in the litigation strategy in the Hamdan versus Rumsfeld case, where the government argued that the president has the power to disregard the Geneva Conventions and that the courts are powerless to review that decision. The Supreme Court ultimately rejected these efforts to restrict the right of habeas and denied detainees the protections of the Geneva Conventions in the Hamdan and Boumediene cases. Third, on torture and standing up for human dignity. Some people, including political appointees in the Bush administration, like then General Counsel of the Navy, Alberto Mora, were horrified when they discovered that our government had a policy of torturing prisoners, and they tried to stop it. Judge Gorsuch, by contrast, seems to have devoted his energies to defending it. These were the defining legal debates of our time, and Judge Gorsuch was on the wrong side of them. Policies he promoted and defended violated American ideals and inflicted unnecessary suffering, and they didn't strengthen our security. On the contrary, these policies compromised America's global standing, alienated communities who support our country needs to fight terrorism, and handed our enemies a PR victory. Given this record, it's essential that you probe Judge Gorsuch's views on executive power, on torture, and the appropriate roles for Congress and the judiciary as co-equal branches of government. Did his actions at Justice reflect his legal philosophy or his desire to be a team player? Did he disagree with positions of the administration on torture? And if he did, why didn't he follow the example of others and speak out? The Senate must get to the bottom of these questions, because sooner or later, and with this administration it is likely to be sooner, the Supreme Court will be called on to protect fundamental rights, judicial independence, and separation of powers from a president who treats the rule of law as an annoyance rather than the foundation of our democracy. Thank you.
Judge Henry.
Thank you, Senator Hatch, Ranking Member Feinstein, members of the committee. It is a pleasure and an honor to be here today, and I thank this committee for its wonderful service to the third branch over the years. I'm Robert Henry, President and CEO of Oklahoma City University, a former state legislator and a former Attorney General of the state of Oklahoma, and a former Chief Judge of the United States Court of Appeals for the 10th Circuit. I held that court position from 1994 to 2010, and the last 4 years of my service, I was a colleague of Judge Gorsuch. Based on my personal experience working with him and my maintained contact through circuit conferences, correspondence, and judicial gatherings, I'm here today to speak in support of his nomination. In Federalist 78, Publius, and in this one, that would be Alexander Hamilton, described the nature and virtues of the federal judiciary. As the least dangerous branch would have neither sword nor purse, care would have to be taken to protect its vital independence. Permanency in office would be required, both to promote independence and to allow for the mastery of the voluminous, strict rules and precedents, in Hamilton's words. The granting of permanence, the importance of integrity, and the long and laborious study required to master the judicial craft led Hamilton, whose star gratefully has ascended of late, to observe, hence it is that there can be but few who will have sufficient skill to qualify for the station of a judge. And this is why the committee is, of course, gathered today. Fortunately, you have before you a candidate that I believe our judicial branch's architect, Hamilton, would warmly embrace, and not just because they both attended Columbia. As one who served with Neil, decided cases with him, traveled and dined with him, discussed our families together, including the menageries his daughters have maintained over the years, agreed and disagreed with him, I can attest to his truly remarkable intellect, his oft demonstrated integrity, his mastery of Hamilton's rules and precedents, and his fine judicial temperament and collegiality. Now, I believe the subject of intellect speaks for itself and needs but summary mention. His honors degrees from Columbia and Harvard Law School, his Marshall Scholarship to Oxford, an honor he shares with Justice Stephen Breyer. That resulted in a Doctor of Philosophy degree, and his corpus of work, which includes outstanding service awards from the State Department, from the Truman Foundation, scholarly writings, some 900 opinions that lawyers have described as straightforward, learned, well-reasoned. Deserving special mention is The Law of Judicial Precedent. This book, which Judge Gorsuch joined with Brian Garner, America's foremost lexicographer and legal rhetorician, and several distinguished circuit judges of quite diverse backgrounds, to develop a remarkable work of legal scholarship. Impressively, all of these eminent judicial co-authors of different political and occupational backgrounds produced a single volume written with a single voice and no signed sections. As to integrity, I've never found Neil's integrity to be questioned. His career has subjected himself to various reviews of his public service. He served as a law clerk to two Supreme Court justices, the late Justice Byron White, a highly esteemed judicial figure in the 10th Circuit, where the courthouse is named for him, and not just because of his football records, by the way, as well as clerking for Justice Kennedy. And this committee has reviewed him before as a circuit judge. All of this also speaks to Neil's mastery of the law. He has some unique qualifications, though. In the 10th Circuit, we have a lot of cases from the great American West. We have our cases involving our Native American nations, cases involving land and water that are important, and his experience in these areas will be helpful to the court. I will skip judicial temperament. It's discussed in my written remarks. I'm running low on time, and I want to talk about one thing that is especially important to me. When Judge Gorsuch and Judge Timkovich and Judge Lucero were in Santa Fe hearing cases one summer, they were very distressed by the quality of legal representation of those charged with the most difficult cases that federal judges must deal with, habeas death penalty cases. Because of that concern, and I have to say that most of the cases come from Oklahoma, and our bar was not adequately doing the job. Judge Gorsuch and Judge Timkovich volunteered. They came to the circuit. They created seminars, symposia. They brought the circuit in to hear cases. They met with these lawyers and helped them, trained them, and have had one lawyer, defense lawyer said, instrumental effect in improving the advocacy, Senator Hatch, of this most important area. Thank you.
Well, thank you, Judge. Mr. Jaffer.
Chairman Grassley, Ranking Member Feinstein, members of the committee, thank you for inviting me to testify. I don't think this committee has any task more important than the one it's been engaged in this week. If Judge Gorsuch is confirmed, he'll likely play a key role in shaping American law and society for 2 or 3 decades or more. I think it's clear that Judge Gorsuch has the professional competence to serve on the court. I agree with Ms. Massimino, though, that Judge Gorsuch's service in the Bush administration raises important questions about his views on executive power and the role of the judiciary in the sphere of national security. At the time Judge Gorsuch served in the Justice Department, the Bush administration was advancing extremely broad claims of executive power in the service of unlawful policies relating to surveillance, detention, military prosecution, and interrogation. Judge Gorsuch was closely associated with those claims. It would be a mistake to confirm him without ensuring that he will defend individual rights as well as the authority of Congress and the judiciary in the context of national security. I want to recognize at the outset that Judge Gorsuch might approach issues relating to executive power differently as an associate justice than he did as a Justice Department lawyer. At the Justice Department, Judge Gorsuch was a lawyer with a client. He says he regarded himself as a scribe or a scrivener. With respect, I'd encourage the committee to bring a degree of skepticism to that characterization. Judge Gorsuch sought out a high-level position with the Justice Department in the fall of 2004, just 7 months after the publication of the Abu Ghraib photos, and only 5 months after the Washington Post published one of the torture program's foundational documents. That was a memo written by the OLC stating that interrogation methods would be lawful unless they inflicted the kind of pain ordinarily associated with organ failure or death. It was a chilling document then, and it remains an astonishing document today. It's also worth noting that Judge Gorsuch appears not to have registered disagreement with any of the policies that he defended, though other officials did. Nor is there evidence that he registered discomfort with any of the broad arguments that the Justice Department advanced in support of those policies, though again, others did. The documents provided by the Justice Department suggest that Judge Gorsuch was comfortable with the policies and with the Bush administration's defenses of them. It was challenges to the policies that troubled him. Senator Durbin asked Judge Gorsuch about an email in which he had criticized lawyers who represented prisoners held at Guantanamo. I thought the answer that Judge Gorsuch gave to that question was a good one. He said that he regretted having sent the email and that the email was, quote, not his finest moment. I hope you'll give Judge Gorsuch an opportunity in his answers for the record to respond more fully to broader concerns relating to the positions he advanced at the Justice Department. Questions relating to executive power are presented especially sharply today. President Trump has issued an executive order banning Muslims from 6 countries from traveling to the United States. He said that he'll consider prosecuting U.S. citizens in the military commissions at Guantanamo. He's promised to intensify surveillance of minority communities inside the United States. If Judge Gorsuch is confirmed, he'll be called on to consider the lawfulness of some of those policies, and his conclusions will have far-reaching implications for the lives of millions of Americans and others, and on the relationship of the United States with the rest of the world. So I urge you not to confirm him without fully exploring his views of executive power. This should not be a partisan issue. We all know that the powers abused today by a Republican president may be abused tomorrow by a Democratic one. The question the committee should ask is whether Judge Gorsuch will safeguard individual rights and the separation of powers, whoever occupies the Oval Office. Thanks again for giving me the opportunity to testify.
Well, thank you. Judge Kane.
Thank you, Senator Hatch and members of the committee. I'm the only trial judge that is appearing in these hearings. I would like to say, Senator, I have no reason for you to remember this, but I appeared before you 39 years ago, and I was honored to be here then, and I'm honored to be here now.
Well, we're honored to have you.
Thank you. Judges are no different from anybody else. Like you, we have social, political, and religious views, whether the product of culture and upbringing or the result of education, predilection, or intellectual or philosophical pursuit. To don the robe, however, is to surrender the freedom to act on those views so that justice may be served. The discipline of deciding irrespective of one's personal beliefs is the essence of judicial integrity. Being consciously aware of one's views and setting them aside at the start of every case is no easy task, nor should it be. The question for any nominee is, does he or she have the discipline to do that and decide each case according to the rule of law? I believe Judge Gorsuch does, and his opinions prove it. Long ago, I gave up identifying judges as liberal or conservative because those words seem to mean whatever the user wants. They have no common understanding and provoke no further analysis. However one might pigeonhole either of us, the fact is Judge Gorsuch and I share few of the same social, political, or religious views. In evaluating fitness for the bench, the real question is, does the nominee embrace the discipline of the robe? Do his or her opinions reflect any sort of ideological basis? Is the judge fair? Judge Gorsuch is not a monk, but neither is he a missionary or an ideologue. I read a great many appellate opinions from circuit courts throughout the United States. To the extent that a judge can be judged by his opinions, the ones written by Judge Gorsuch tell me a great deal. His are clear, cogent, and mercifully to the point. I have been both affirmed and reversed by him, and each time I thought he was fair and right. He treats the parties and the trial judge's rulings with respect. He does not ridicule them or take cheap shots, nor does he insult or demean other judges who might disagree with him. His writing is filled with grace and wit, but does he know the difference between his personal views and those of the court? Judge Gorsuch is the only judge of whom I am aware who has written both majority opinions and concurring opinions in the same case. The majority opinions were the opinions of the three-judge court. The concurring opinions were his separate, additional perspectives. He has done this at least twice. He knows the difference between speaking for a court and for himself. Judge Gorsuch's opinions also make clear his concern for the separation of powers and his keen awareness of the judiciary's independence. He has written that legislation belongs to Congress and adjudication belongs to the courts. He has disagreed with the late Justice Scalia by suggesting there is far too much adjudicative activity in the executive branch's administrative agency rulings. He has questioned the values of the Chevron doctrine, which asserts the judiciary should defer to agency interpretations of statutes. The Chevron doctrine intrudes equally upon the authority and prerogatives of the legislative branch. As is often the case, Justice Oliver Wendell Holmes said it best. In his decision in Lochner versus New York, Justice Holmes wrote, and I quote, "The case is decided upon an economic theory which a large part of the country does not entertain. If it were a question whether I agreed with that theory, I should desire to study it further and long before making up my mind. But I do not conceive that to be my duty, because I strongly believe that my agreement or disagreement has nothing to do with the right of the majority to embody their opinions in law." Like Justice Holmes, Judge Gorsuch knows that his social, political, and religious views have no place on the bench. In embracing the discipline of the robe, dedicating himself to the separation of powers, and consistently devoting himself to being fair, Judge Gorsuch has earned the right to be considered by you for the highest bench in the land. I hope you will judge him with the fairness and integrity with which he himself has served.
Well, thank you, Judge Kane. Mr. Perkins, we'll turn to you.
Mr. Chairman, Ranking Member Feinstein, and members of the committee, thank you for the opportunity today to give voice to my son Luke, whose access to an appropriate education and thus to a meaningful and dignified life was threatened by views of Judge Neil Gorsuch. Luke was diagnosed with autism in 1996 at age 22 months. An intensive early education program taught him letters, numbers, and colors, but he struggled with speech. He developed a restricted diet, an erratic sleep cycle, and intolerance to sounds. When overwhelmed, he would tantrum and often injure himself. Luke's care became too much for my wife and me alone. His older siblings and hired caregivers helped. My parents moved next door to assist. It was clear that his education program was failing, and Luke began to regress significantly. Teachers were reinforcing inappropriate behaviors, and he was not participating in meaningful educational activities. Moreover, his program failed to address his profound inability to generalize. Luke might learn a skill in a particular classroom with one teacher, but be unable to perform it in any other setting. While such learning might check off a box on an education plan, it provided no meaningful benefit. Multiple experts agreed that he needed an intensive program with wraparound services to address his educational needs. We made many unsuccessful attempts to address these deficiencies with the school district. Since the needed services were not available locally, we were left with the agonizing option of sending him 2,000 miles away to a specialized school for autistic children in Boston. When Luke enrolled in Boston Higashi School at age 9, he was not toilet trained, ate only a few foods, could not sleep in a bed, could not eat with utensils, and did not interact with his peers. Within months of enrolling, Luke was toilet trained. He ate healthy foods with proper utensils. He was sitting calmly in a classroom with peers. He participated in group activities such as rollerblading. When Luke visited home during breaks, we could shop, eat at restaurants, and even attend church together. But this improved life for Luke was costly. Despite my comfortable income as a physician, Luke's education costs rapidly depleted our reserves. My parents contributed from their retirement savings. In 2005, we requested reimbursement for Luke's education under the Individuals with Disabilities Education Act. At a due process hearing, the independent hearing officer found in our favor. The decision was upheld both by an administrative law judge and a U.S. District Court judge. But when the school district appealed to the 10th Circuit, Judge Gorsuch authored the decision overturning these previous rulings. His legal reasoning set a new low standard of education required under IDEA as merely more than de minimis. De minimis, lacking significance or importance, so minor as to merit disregard. Judge Gorsuch felt that an education for my son that was even one small step above insignificant was acceptable. Despite Luke's inability to meet 3/4 of his educational goals or to use any of these skills outside the classroom, his education was judged appropriate. That left us only one real option. One of Luke's parents would have to move to a school district that would better accommodate Luke's educational needs. After much prayer and thought, my wife decided to permanently relocate. Thankfully, the Dedham School District acknowledged Luke's extraordinary needs, allowing him to finish out his time at Higashi. Now aged 22, Luke will always need support in a world that still seems perplexing and threatening to him, but his quality of life after 13 years of appropriate education is vastly better than it would have been otherwise. He cooks and does household chores. He is able to shop, work, eat, and play in the community. And he has developed a new passion, Legos. Luke's mind is uniquely attuned to this plastic brick world. He constructed this particular model this January. His present life would not have been achievable without an appropriate education. Thankfully, Luke is unaware of the price paid for his education. The financial cost pales in comparison to the human sacrifice. His mother separated from her 13-year-old daughter. His parents' marriage broken. He is also unaware of the key place that one judge, with his radically restrictive interpretation of law, played in the fight for his right to a free and appropriate public education. In his 10th Circuit ruling, Judge Gorsuch eviscerated the educational standard guaranteed by the IDEA. His interpretation requires that a school provide an education to a disabled child that is just above meaningless. His minimalistic interpretation of federal law in Luke's case has been used to deny an appropriate public education to countless other disabled children in the 10th Circuit over the last 9 years. Legal philosophy and case law aside, such an interpretation clearly fails the common sense test. Why would Congress pass a law with such a trivial intent? And why would a parent settle for an education for any of their children, regardless of their abilities or challenges? To quote Chief Justice Roberts from yesterday's Supreme Court ruling, when all is said and done, a student offered an educational program providing merely more than de minimis progress from year to year can hardly be said to be offered an education at all. On behalf of all children, disabled, typical, and gifted, I urge you to deny confirmation of Judge Neil Gorsuch to the Supreme Court of the United States. Thank you for providing me this opportunity, and I ask that my full statement be included in the record. I look forward to answering your questions.
Your full statement will be included in the record. We appreciate your testimony. Ms. Brasch, we'll turn to you.
Mr. Chairman, Ranking Member Feinstein, and other members of the committee, I am deeply honored to have the opportunity to address the committee today and talk about one of my mentors, Judge Gorsuch. Senator Feinstein, I grew up in California, where you and Senator Boxer were my home state senators, and my family still laughs that there was a time when I believed that only females could be senators. Of course, when I left for college, I moved to Maine, which also had 2 women senators, so take from that what you will. I served as a law clerk to Judge Gorsuch from 2009 to 2011. I'd like to direct my remarks to how Judge Gorsuch approaches cases. His commitment to assess each case from all points of view and never make up his mind until every point of view has been considered is the quality I respect most about him. First, Judge Gorsuch is truly independent. In deciding cases, he doesn't care what politicians or parties want. He only cares what the law says. In the 2 years I worked with him, never once did politics influence a decision he made. I saw the government win cases. I saw the government lose cases. I saw each private litigant receive the same meticulous analysis of its arguments. Judges like Judge Gorsuch are the keepers of our independent judiciary. Second, Judge Gorsuch works together with judges from all different points of view to build consensus wherever possible. In my 2 years clerking for the judge heard many cases together with other judges whose judicial philosophies differ from his. Yet the great majority of those cases were decided unanimously. And that is no coincidence. It is a reflection of the judge's deep respect for the opinions of his colleagues and commitment to craft decisions that benefit from their reasoning. In my experience as a law clerk, the judge always pushed me to research all sides of a case, question the reasoning underlying each party's position, and give all arguments exhaustive consideration. That process more or less consumed my life for 2 years. It's a cornerstone of how Judge Gorsuch works, and he won't accept anything else. Third, there's no question that a Supreme Court justice wields significant power. But having worked closely with Judge Gorsuch, I am confident that a change in title from judge to justice will not change him. His judicial philosophy is based on the idea that the future of this country will be decided by elected representatives like the members of this committee, not by him, and that will never change. On a personal level, some of my fondest memories of my clerkship with Judge Gorsuch were the afternoon runs that he led us on through Denver. Weaving in and out of the city streets, I questioned the judge's description of these events as jogs, when to me they felt much more like a sprint. While it was easy to begin the run discussing cases with the judge, the true test was whether you could continue to communicate about the cases 20 minutes later when the judge was doing just fine and most of the clerks were out of breath. I now think of those runs as a metaphor for the experience of working with the judge. His relentless drive pushes everyone around him to try harder and reach higher. In casual conversation in chambers, the judge always wanted to hear about our experiences exploring the Colorado outdoors. I still remember the morning ritual of quizzing clerks on their adventures over the weekend. One weekend while hiking in Rocky Mountain National Park, I found myself within a few feet of a beautiful red fox. And I knew I would have the ace come Monday when the quiz occurred on Monday morning. We all know the saying that you are judged by the company you keep. One of the greatest gifts of clerking for 2 years for Judge Gorsuch is my co-clerks, whose humility, intelligence, and diligence mirror the qualities I admire so much about the judge. Many of the judge's clerks, whose political views span the spectrum, have traveled to be here for this hearing, and we have uniformly recommended him as an extraordinary judge. We believe he is a judge of whom all Americans would be proud.
Mr. Chairman and members of the committee, my name is Jody Calamine. I'm General Counsel of the Communications Workers of America. We're a labor union representing hundreds of thousands of workers across this country. Thank you very much for the opportunity to testify. Our concern about Judge Gorsuch ascending to the Supreme Court is about as fundamental as it can get. His jurisprudence is a threat to working people's health and safety. This hearing has already paid some attention to Judge Gorsuch's dissent in the Trans Am trucking case, and that attention is justified. That dissent, issued just 7 months ago, reveals an anti-worker bias and features a judicial activism that will ultimately put workers' lives at risk. At issue in Trans Am trucking is a law that protects truck drivers who refuse to operate a vehicle out of safety concerns. When driver Alphonse Madden refused to operate his truck and trailer in the manner his supervisor directed him, which was to keep the truck parked and hitched to a disabled trailer in sub-zero temperatures while he froze to death waiting hours for help, and instead finally drove his truck to safety, he was exercising that right to refuse an unsafe operation and could not be fired for it. Only one judge at any level of this case ever dissented from this view, Judge Gorsuch. He found that when Mr. Madden drove his truck to safety, he was not refusing to operate his truck, he was operating it, and therefore could be fired for disobeying orders. Judge Gorsuch has said that the result he reached might be unkind, forcing Mr. Madden to choose between dying or losing his job. But he contends he's merely applying the unambiguous text of the law to the facts of the case. Far from it. To reach this result, Judge Gorsuch had to choose one particular definition of the word operate from the dictionary. As it turned out, there are multiple definitions of operate in the dictionary. Judge Gorsuch chose the definition that allowed him to rewrite the law. After he was done, a worker's right to refuse to operate would mean only refuse to drive. That's not judicial restraint. And the rewrite of the law, in this case, leads to absurd, deadly results and fewer rights for truck drivers. As we know, Judge Gorsuch is no fan of agency deference, and so we have every reason to expect his judicial activism will narrow other worker rights beyond the Surface Transportation Assistance Act at issue in Trans Am trucking. Our union members are typically not truck drivers, but rely on other safety laws to protect them on the job, like OSHA's rule allowing us to refuse hazardous work. On a very frequent basis, a worker that we represent will identify a hazard in the workplace, and the union will stand with him and others to stop the work until the hazard is abated. Just a few weeks ago, one of our technicians in Detroit discovered significant asbestos contamination where he was supposed to do telecom work in an underground vault directly below a manhole on a public street. He told his supervisor. His supervisor repeatedly told him to blow fresh air into the vault, which would not only expose this technician to friable asbestos floating in the air, but expose the public on the street above as well. So the technician refused to do the hazardous work demanded by his supervisor, and he and the public are safer for it. We take these actions knowing the law is on our side. To us, health and safety are not, as Judge Gorsuch dismissively puts it, ephemeral and generic. Now, the right to refuse hazardous work under the OSHA Act, unlike the statute at issue in Trans Am trucking, is a product of agency interpretations of the statute. If Judge Gorsuch takes a sledgehammer to workers' explicit statutory rights as he did in Trans Am trucking, imagine what he may do to rights stemming from agency interpretations. More workers will die on the job. Judge Gorsuch's dissent in Trans Am trucking, in our view, is disqualifying. Ignoring agency interpretations, legislative purpose, common sense, and instead picking the narrowest definition one can find in the Oxford English Dictionary to redefine our rights That is not applying the law to the facts. It is a form of judicial activism. It's said that our health and safety laws are written in the blood of working people. Please do not allow Judge Gorsuch to repeal these laws from the highest bench in the land with his brand of judicial activism. We urge the Senate to reject this nomination, and thank you very much for your time.
Well, I want to thank all of you for being here today and for your testimony. I just have one question for you, Judge Tacha. By the way, welcome. You're a great judge in our circuit out there, and I really appreciate your leadership over the years. Judge Tacha, this hearing has been somewhat of a civics lesson, with the separation of powers being a prominent theme throughout this week. This was the first of three aspects of Judge Gorsuch's qualifications that you described in your testimony. As you put it, he, quote, takes very seriously the appropriate roles assigned to each of the three branches of government, unquote. Now, this is a critical principle, but it can sometimes seem a tad detached or even cold when the facts of the toughest cases are presented. I'm sure you wrestled with this when you were on the 10th Circuit. Now, how important is it for a judge to, as Senator Schumer put it in 2009, stick to the law, even when it means ruling against sympathetic litigants?
And I appreciate your kindness and this full committee. And I might say I was a part of the 10th Circuit, and now I'm working in Senator Feinstein's native California at Pepperdine University. So I'm pleased to be both places. Your question is to the heart of what a judge does. And let me just say, in response to Mr. Perkins, as a parent and as a human being, my heart goes out for the facts that you've laid forward that were in Luke P. But as a judge, to your point, Senator Hatch, the judge must look at the law as he or she sees it at that moment. And in particular, in the Luke P. case, Judge Gorsuch was following very long-standing precedent. This committee, has heard Judge Gorsuch repeatedly say, precedent is important. Precedent stands. It is an important piece of the lens that I referred to that a judge looks at a case through. And to be absolutely specific, Judge Gorsuch was applying precedent that went all the way back to 1982 in the Supreme Court decision of Board of Education versus Raleigh. So with all my heartstrings with the family, what Judge Gorsuch was called on to do was apply that very long-standing precedent for our circuit. Let me also say it wasn't just our circuit. I believe it was all but two circuits. All the rest of the circuits in the nation were following the same standard in interpreting the IDEA. Further, I can say with some authority that he was following not as dicta, but as a holding in his case, what I wrote in the Urban case, which he was following, and all wrote that the statute as interpreted must be more than de minimis. So there is a lot of discussion, but it's important to know that that was long-standing precedent from a long time back. Now, I will say, circuit judges are really glad when the United States Supreme Court clears up circuit conflicts. And so what happened in that case that was issued yesterday was two circuits had chosen one standard, and the rest of us had chosen the other standard through long-standing precedent on interpretation of the IDEA. So yesterday, the Supreme Court carried out its very important function of clearing up what the standard would be. I have not had time, I have to say, I have not had time to thoroughly review the opinion from yesterday, but I know for sure that the Luke P. case was based on the Urban case that I wrote, and it said standard is must be more than de minimis.
Well, thank you so much, Senator Feinstein.
Thank you very much, Mr. Chairman, and thank you, Judge, for making that clear. I think you made a very cogent statement. I gather the standard the court passed yesterday would have covered Mr. Perkins' son. Is that correct?
Well, I will not opine on how the law would be applied to particular facts, but it does appear to me that the standard that we had been using is changed.
Thank you. And Mr. Perkins, I just want to thank you for being here. That display you presented is very telling. And one question, when did he do this?
He did this in early January of this year, ironically about 2 weeks before Judge Gorsuch was nominated to the Supreme Court.
Well, that's quite amazing because it's quite a complicated building of the Capitol and very much appreciated. So thank you for being such a good parent. It's very much appreciated. I wanted to go to Mr. Jaffer, if I could. And I feel remiss because I wanted to ask some of these questions yesterday and didn't have an opportunity to do so. So let me throw out a question and ask you your view on it. The judge acknowledged that he worked on the Graham Amendment, which sought to eliminate habeas for Guantanamo detainees. And he also acknowledged that in December of '05, after the Detainee Treatment Act was passed, there were different factions in the administration advocating different versions of a signing statement. In an email Judge Gorsuch sent to Stephen Bradbury and others, here's what he said, and I quote, and this is in the document: "Along the lines proposed below would help inoculate against the potential of having the administration criticized sometime in the future for not making sufficient changes in interrogation policy in light of the McCain portion of the amendment. This statement clearly and in a formal way that would be hard to dispute later puts down a marker to the effect that the view that McCain is best read as essentially codifying existing interrogation practices," end quote. Now, this is in December of '05, 9 months after the Bradbury memo had concluded that waterboarding, stress positions, sleep deprivation, and other techniques were not prohibited by the standard applied under Article 16 of the Convention Against Torture. My question to you is, what do you make of this email? Inoculate against being criticized in the future for not making sufficient changes in interrogation policy.
So I think that this is a really important question. So in May of 2005, the Office of Legal Counsel wrote memos that concluded, as you mentioned, Senator Feinstein, that concluded that certain interrogation methods, including waterboarding, did not constitute cruel, inhuman, or degrading treatment. And my understanding of the email that you quoted is that Judge Gorsuch believed that the signing statement, that the way the administration should interpret the law is to essentially ratify those interrogation methods that the Office of Legal Counsel had signed off on in May. So I think one really important question is, what did Judge Gorsuch know about the interrogation methods that the CIA was using at the time he urged that President Bush issue a signing statement interpreting the DTA in the way that he ended up interpreting it? I think that's a really important question, and I don't think it's been answered yet in this hearing.
Thank you, thank you. Thank you very much, Mr. Chairman.
Thank you, Senator Graham.
Well, thank you. I remember the debate well, and here's what Senator Kane said about his amendment, which I supported vigorously. The amendment I am offering simply codifies what is current policy and reaffirms what was assumed to be existing law for years. In light of the administration's stated commitment, it should require no change in our current interrogation and detention practices. What it would do is restore clarity on a simple and fundamental question. Does America treat people humanely? Inhumanely, my answer is no, and from all I've seen, America's answer has always been no. So that was Senator McCain's view of what we're trying to do here. The Graham Amendment, I can't remember how the bill was passed, but it was overwhelming. What I tried to do is say that the Combat Status Review Tribunal system within the military would be the primary way of determining enemy combatant status, but we'd have judicial review of that at the D.C. Court of Appeals. I think the Supreme Court said in a 5-4 decision that the CSRT is not an adequate substitute for habeas, and that's the law of the land today. We basically redrafted the Military Commissions Act, and I feel good about where we're at. Ms. Jaffer, is the current system that if you're alleged to be an enemy combatant, you can be held as such, but you get a habeas hearing in federal court. Is that correct?
That's right.
Okay. And the government has to prove by preponderance of the evidence that you're in fact an enemy combatant to be held.
That's right.
And if you are an enemy combatant, you can be held without, under the law of war indefinitely. Is that correct?
I'm not sure about indefinitely. I think that's still an issue in the courts, but yes, you can be held.
Well, there are people at Guantanamo Bay who are being held as enemy combatants, and they've been there for years. Is that correct?
That's right.
President Obama left them in that status.
Some of them, yes.
Yes,
that's
I
right.
think there's 48
That's right.
that have been determined too dangerous to release. So under the Obama administration, at least of those 48, they're being held under the law of war as enemy combatants.
That's right, Senator Graham. As you know, hundreds of prisoners have now been freed from Guantanamo.
Right.
I don't know how many of them would have been freed
Right.
under the rules that Judge Gorsuch was proposing.
Right. Do you also know about 30% have been freed, have gone back to the fight?
I don't think that figure is accurate, Senator.
How many do you think have gone back to the fight?
I don't know the number, but it's
How
much
many of
less than that.
Americans have been killed and others been killed by people released at Guantanamo Bay?
Senator Graham, the
Do you know?
detainees who are, I don't know the number.
Okay, how about, let me help you here. You got to take some risk because you can't hold people without due process. Do you agree with that?
I agree with that.
I guess the safest way is to never let anybody go, but that's not the right way.
It's
Need-
not the way that the Supreme Court has,
Right.
has proposed that the law should be. Has
Well,
said
no,
that the law
no,
should
the
be,
Supreme
right.
Court says they've never said you can't hold anybody indefinitely. You just got to give them due process.
That's right, Senator Graham.
Okay, so I'm all for due process, and sometimes you make mistakes. We've actually been aligned more than most people would think. I don't believe that waterboarding was ever an appropriate technique to gain information, and I'm sure you agree with that.
I do, Senator Graham. I think the question is whether Judge Gorsuch agreed with that at the time he was in the Justice Department. And my interpretation of that email is that he didn't.
Well, is it fair to say that Judge Gorsuch, who I interacted with a lot, said that waterboarding is illegal under the Detainee Treatment Act? He said that before this committee.
I read that. I was pleased to read that. I don't think that's
You
the
know
view
why?
that's
You know
took in the
why he
Justice
said
Department.
that? Because I interacted with him a lot. He never bought the idea that waterboarding was consistent with the Geneva Convention. He's never bought the idea that it was consistent with other laws. Some people had that view, and I'm just here to tell you that he said before the country that waterboarding is now illegal without any question. And I brought up the situation of the current president, that if he decided, and I don't think he will because of General Mattis, to go that road, he would be, in my view, violating the law. And Judge Gorsuch said no man and / woman is above the law. So I hope that gives some comfort to people that Judge Gorsuch understands that the purpose of the Detainee Treatment Act was to outlaw waterboarding and other type techniques. He acknowledged it for the country, that no president can just seize the law because of national security concerns alone. Ms. Massimino, do you agree we're at war?
I do.
And this is a complicated endeavor in terms of how you fight the war, because there's no nation state to fight, no Air Force to shoot down, no Navy to sink.
It's quite complicated.
But we need to adhere to our values, but also realize that intelligence gathering is an essential ingredient of the law of the war.
It is. It's been a huge challenge for us.
Thank you all very much. You've done the country a great service.
Well, thank you, Senator Durbin.
Thanks, Mr. Chairman. Thanks to the panel. Just to follow up on Senator Graham's line of questions, at the time of the memo that was sent by Judge Gorsuch on this issue, in which he said that McCain is best read as essentially codifying existing interrogation policies. I am told that waterboarding was part of the existing interrogation policies of this country. Is that correct?
That's correct.
He could not remember that email nor any details surrounding it. But we clearly, through the McCain amendment, or the McCain legislation, which I supported, we clearly wanted to outlaw waterboarding and any form of cruel, degrading, and inhumane treatment of prisoners. So there was a built-in inconsistency here.
I think that's exactly right.
Codify existing procedures, which included waterboarding, and address that as a signing statement on the McCain Amendment, which would have prohibited waterboarding. A clear distinction, which Judge Gorsuch, because of a variety of circumstances, did not directly answer. Let me move to another issue, and I don't know if it's Dr. or Mr. Perkins. Thank you for being here. Thank you for your touching story about Luke and his travels and journey and all that you and your family have done to bring him to this point in his life. When Judge Tacha, did I pronounce your name correctly? Tacha. When Judge Tacha talked about the 10th Circuit standard, she left out one word: merely. Merely. I'm trying to draw an analogy, and it may not be the best one. But if I said when it comes to hungry children, the law requires you to provide them more than just a little bit of food, that is a lot different than saying when it comes to hungry children, the law requires you to provide them merely more than just a little bit of food. Difference? One word has made a big difference. It has taken de minimis lower. That was the express statement by Judge Gorsuch, which expanded what was the 10th Circuit standard when it came to your son. It was the express phrase, merely more than de minimis, that the Supreme Court unanimously struck down yesterday, saying that means no education at all. When you saw that opinion, what was your reaction that Judge Gorsuch said he was just following 10th Circuit precedent?
Well, I was devastated. At the time the opinion came out, Luke had been at Boston Higashi for 5.5 years. I knew what he had accomplished in that time, all the progress he had made, and to realize that Judge Gorsuch had, by this subtle wordcraft, taken what seemed to be making a statement that seemed to be saying he was following precedent, but actually further restricting an already restricted precedent, with, unfortunately, my son in the bullseye of that decision. It was very hard to take.
Mr. Calamine, did I pronounce your name correctly?
Calamine.
Calamine. Mr. Calamine, I'm sure the Chicago Tribune this morning chided me, and I'm sure many of the committee members will be chided, that we spent so much time talking about a frozen truck driver. What in the world's going on here? We're talking about the Supreme Court. Why should we be talking about Alphonse Madden and whether he was facing hypothermia or frostbite? But whether we're talking about one young man, young boy with autism, or one truck driver, we're really trying to figure out this judge and what makes him tick and what his values are. And all we can rely on are really important decisions, not the routine decisions, they come and go, but the ones where you really have a moment where you have to make a call with the law and the facts that really defines you. Many of the arguments that I've heard here today, I've heard over and over in this committee, and that is, this is programmatic. Here's the law, here are the facts, here's the judge, case closed. We know better. We know better because Merrick Garland is not sitting at the table, or wasn't yesterday. The decision was made that it would be Neil Gorsuch, for fear that Merrick Garland, an Obama appointee, would come in and say exactly the same thing. That really tells us that there's more at stake here than just this programmatic, robotic application of the law. There is something much more fundamental here. I thank you for coming and speaking on behalf of working people. Thank you, Mr. Chairman.
Thank you very much. Mr. Jaffer, I just wanted to find out whether you're familiar with the column that came out in the Wall Street Journal yesterday, an article by Jess Bravin, talking about the fact that former Justice Department official John Bellinger corroborated Judge Gorsuch's account to the effect that he pushed back against advocates of waterboarding and other cruel interrogation techniques during the Bush administration. Are you familiar with that?
I'm not familiar with the column, but I'm glad to hear that, and I think that if you have the opportunity to ask questions for the record, it would be great to get more information about precisely what Judge Gorsuch did to push back against these interrogation methods. It's great to hear if he did that, but it would be good to get that on the record.
In the email that's been referenced, dated Thursday, December 29, 2005 at 4:57 p.m., it is worth noting, I think, that I don't think he's saying there were no changes being made. He used words like sufficient and essentially, talking about sufficient changes and whether they essentially codified existing law, not suggesting that there were no changes at all that were made by the law. Would you dispute that?
No, I think that's another good line of inquiry. I think it would be it would be important to ask Judge Gorsuch again what he knew of the interrogation methods that were being used at the time, and what adjustments he thought the administration was going to make as a result of the DTA. I think those are important questions that haven't yet been answered.
Thank you. Judges Tacha and Henry, it's very good to see both of you. And I do have to say it's a little bit more comfortable standing on this side of a stand rather than the other side. I'm used to seeing you in an elevated position with both of you in robes, so thank you for being here. On the point, Judge Tacha, about the use of the word merely, when you're looking at what circuit precedent already demands, and you're trying to evaluate whether or not that precedent has been satisfied, the use of the word merely, as I see it, could mean, and ordinarily would mean, if I'm not mistaken, this law does not require everything. It does not require 100% if we're measuring this on a 1 to 100% basis. It requires merely X%. Ordinarily, when a judge would use such language, a judge wouldn't necessarily be meaning to denigrate or minimize what the law requires, but indicate that the law requires X and nothing beyond X. Would that be how you would normally use that as a judge?
That's exactly right. I can't opine. Thank you, Senator Lee, for those kind words. I can't opine what order the adjective and everything came in the sentence. But what it does is merely define very existing precedent, which was our standard more than de minimis. So yes, how that word was used is probably exactly as you describe, which was there is a standard here, there is a standard here, there is a standard here, and this one is the standard that is selected by the circuit and followed Supreme Court precedent since 1982.
And as an Article III judge, even a powerful judge, at one point you were the chief judge of the 10th Circuit, it's not your job to write the laws.
It definitely is not, and I will add to that Judge Gorsuch is meticulous in that, and you will find throughout his opinions, this is not our job, this is Congress's job, or this is the president's job, or whatever. He is so meticulous about the roles of the three branches of government. And in fact, he and I have actually had these conversations. One of the things that's probably not seen, although you understand it in committee work, is that in an appellate court, there's a lot of back and forth among the judges on panels and in bank sittings. And I have heard Judge Gorsuch on many occasions say, it is so important for us to be absolutely meticulous about what the role of each of the branches is. And as I said in my written comments, he is a student of the Federalist Papers and of the founding documents and really believes in that separation of powers.
And it's that separation of powers that recognizes that in our constitutional republic, it's the people who are sovereign. And the people's branch is the legislative branch. That's the branch of government where there is the most accountability to the people at the most regular intervals. I see my time has expired. Thank you, Judge. Thank you, Mr. Chairman.
Thank you, Chairman. Mr. Calamine, you represent a labor union?
Yes, sir.
I'd like to read you from a New York Times news story that relates to the Abood case, which is a precedent of the Supreme Court that controls when labor unions like yours can charge non-members for services that they render in the collective bargaining process. Here's what Adam Liptak, the writer in the New York Times, wrote. In making a minor adjustment to how public unions must issue notifications about their political spending, Justice Alito digressed to raise questions about the constitutionality of requiring workers who are not members of public unions to pay fees for the union's work on their behalf, the Abood issue. Justice Sonia Sotomayor saw what was going on. To cast serious doubt on long-standing precedent, she wrote in a concurrence, is a step we historically take only with the greatest caution and reticence. To do so, as the majority does on our own invitation and without adversarial presentation, is both unfair and unwise. End quote of Justice Sotomayor. The story continues. Michael A. Carvin, a leading conservative lawyer, also saw what was going on. He and the Center for Individual Rights, a libertarian group, promptly filed the challenge Justice Alito had sketched out. Indeed, Mr. Carvin asked the lower courts to rule against his clients. I'll interject into the story my own addition that that's a rather unusual behavior for a lawyer, so that his clients could hightail it to the Supreme Court, the article continues. Last year, Justice Alito wrote a second majority opinion attacking the central precedent in the area, a 1975 decision called Abood v. Detroit Board of Education. But the majority in the new case, Harris v. Quinn, stopped short of overruling Abood. By now, the story in the New York Times continues, everyone saw what was going on. Readers of today's decision will know that Abood does not rank on the majority's top 10 list of favorite precedents, and that the majority could not restrain itself from saying and saying and saying so, Justice Elena Kagan wrote in dissent. Last week, the article continues, this is some time ago, the court agreed to hear Mr. Carvin's case, Friedrichs v. California Education Association, and it may soon complete the project Alito began in 2012, that of overruling Abood. End of my quotation of the New York Times story. As we know, the Friedrichs case did in fact come forward. It was expected to be a body blow to unions, according to reporting at the time. The passing of Justice Scalia put the court back to 4-4, so the Friedrichs decision came in 4-4 and went back to the Ninth Circuit, which had, whose decision was upheld because it was a tie. Could you just react to me as a lawyer who represents a labor union on that series of events and what you, how that makes you think about this particular court and its 5-4 decisions?
Certainly, my concern is based on the quotes you read from the Times article, is that there is a project underway to harm workers' rights, a project underway to harm workers' organizations so that workers don't have the ability to exercise the bargaining power that they all have and win a better deal for themselves at work. The notion that there are signals being sent for cases rather than waiting for the case or controversy to arise is very concerning. And it's one of the reasons why, in the case of Judge Gorsuch, there's been a lot of talk about, all he has done is apply the law to the facts in the Trans Am trucking case. What he did was he picked out the narrowest definition in the dictionary for the word operate, and it had a particular result. There were other definitions in the dictionary that could have been chosen. And once you saw multiple definitions, perhaps you should defer to the agency, because maybe they know how the law can work effectively on the ground given their expertise. He chose the most narrow definition, and the result was absurd. And the result, if it had carried the day, would have made life a little more dangerous for truck drivers. Kinds of absurd results you get out of that particular definition are things like, if the word operate only means to drive, then if a trucking company told a truck driver to go over the speed limit or speed up, go faster, sometimes they can see the trucks on the computer and see how fast they're going. And the truck driver reports back, I can't, I'm in a construction zone full of traffic. But the trucking company persists and says, go faster. That trucker, if he went the speed limit, complied with the law, he would not be protected under Judge Gorsuch's version of that statute. He could be fired for going the speed limit because he's driving. He would have to completely stop the truck on the highway to protect himself for disobeying that order. And you can imagine the traffic that could cause if that's the way this statute was carried out. Those are the kinds of absurd results. In fact, I think Judge Gorsuch's dissent is Exhibit A for why we should have Chevron deference, because instead of picking out a dictionary definition, look at the agency and see how the experts, had figured out how this law works in the real world.
Yes, sir. Thank you, Mr. Chair. Mr. Perkins, I first want to probably just say something. I don't know if you'll need to respond or not, but probably I don't know of anybody on Capitol Hill that's actually ratified bills that were sympathetic to families and persons with autism. As Speaker of the House, we had our state employees' health care plan cover autism treatment, which included psychiatric care, psychological care, pharmacy care, and adaptive behavioral treatment. And I know if you've studied autism, you know how those are critically important. We went on against the insurance industry's wishes to include an insurance mandate in North Carolina to do the same thing. And the court case yesterday, on the one hand, I'm happy that it provides other people that are going through your condition with an option. But in reality, it's a failing on the part of legislators. Now, you live in Colorado still?
Yes.
Promise me you won't vote for a Colorado legislator that won't support a mandate and won't support opportunity scholarships for children with autism. You don't have to make, I may have just broken a law or a rule or whatever. But look, these folks there are 9 states in this nation. North Carolina is one of them. We've gone probably about as far or maybe further in some cases than any other. But this is an example of where I'm going to support Judge Gorsuch. And my guess is that Judge Gorsuch, the individual who separates his jurisprudence job from his personal feelings, is just okay with what the Supreme Court did yesterday. But in reality, the whole need for that lawsuit is a failure on the part of the states to solve the problem. So in a state like North Carolina, you don't have to get into a conflict and a lawsuit with the school system, because it's still going to be difficult to do. You're still going to have to probably hire an attorney and work through all the complexities. They're going to push back. So I hope, and I'm glad to hear that my colleagues on the other side of the aisle, all of whom are from states who haven't done this, but they're okay with the fix the Supreme Court got, because I'm going to try and move legislation to make it easier for people like you to get the care you need. But it is a classic example of legislators. Last night I used an analogy of a bear skinner and a bear hunter. I won't use my time here. But we need to actually skin that bear here, not have the courts do it. And I do think that what Judge Gorsuch was doing was saying, fix the problem. He said, and something I will repeat time and time again to a question here before one of my colleagues on the other side of the aisle, it's not my job to do your job. I think that was a very insightful thing for him to say. In our case, if legislators did their job, you would not be before us today. Your family situation would be better, and Luke would be probably further along. And one other thing I want to tell you, we may need to get Luke to come to my office because we're actually putting that same Lego model together and my staff are struggling. But thank you for being here. If you have a brief comment, then I have one other question, Mr. Chair.
I would just like to comment briefly. I would say that the Congress had indeed passed the IDEA, and
They did, but let me just
based on my reading of Judge Gorsuch's
Mr. Perkins,
opinion.
I don't mean to interrupt you, but I want to get one last comment in. I may just have submitted to the record. But here's the problem with the IDEA and relying on the vagaries of the IDEA to fix the specific problems back in the state. I'm already reaching out as a result of that court opinion yesterday, saying, how do you actually provide clarity that puts the benefit in the hands, or the benefit of the doubt in the hands of the parent? The way you do this properly is structurally, after an IEP and the parent's judgment is failing to allow a child, in your case, to generalize the skills they're learning at school back at home, how do you grant them the power to, after just a year, move somewhere else? How do you make sure that the state funding follows the child? How do you make sure that federal funding follows the child? How do you make sure that the parent doesn't have to go into a courtroom or an arbitrator or all the other things that they'll still have to do with that court decision? How do you get the members here? And I'm thrilled to hear that we have such support on the other side of the aisle. How do you get us to provide more specificity in the IDEA so the burden's not on you? You have your own burden with your beautiful child. You shouldn't have to do it. It's a failing of Congress. It is not a failing, in this case, of Judge Gorsuch. And I hope that people understand that I am so glad to hear in states, none of whom have stepped up and done it, are prepared to actually go with me to those states and convince them to do it, because we can solve the problem. And I will submit my other questions for the record. Thank you, Mr. Perkins.
Senator Tulsa, may I have the opportunity that you offered me to briefly respond? The IDEA is not a perfect law, but the fact of the matter is Judge Gorsuch, in his opinion, shrank and minimized the requirements of the IDEA such that they trivialize this law. And as the opinion yesterday characterized, current law provides much more significant protection to disabled children than Judge Gorsuch's ruling offered.
But it doesn't provide enough, and it's because of a failing of legislators and congressmen, not the courts. Thank you, Mr. Perkins.
Thank you, Mr. Chairman. Judge Tacha, in your testimony, you're talking about Judge Gorsuch as a judge, and you said his attention to the views of his colleagues informs his work. He has an acute sense of identifying those circumstances, I'm reading from your testimony, where consensus is the highest value. And on the other hand, those decisions where personal conviction and reason dictate individual judgment and independent decision-making. Personal conviction.
That is about whether consensus should be built on the decision or whether the judge should write independently, either as a concurrence or dissent or whatever.
But he says, you're saying that he takes, that what's important to him is what his colleagues believe, but also his personal conviction.
About how he reads the law.
His personal conviction about how he reads the law. Because what basically he wouldn't tell us are any of his personal convictions.
Because he would not bring those to cases. He would be...
Well, I'm sorry. This is what bothered me, is that he said his personal convictions didn't enter into his decisions. And we spent 3 days here hearing that back over and over and over and over again. My personal convictions don't matter. But now, from someone who's endorsing him, say that they do matter. And
this is what I worry about, that we were not allowed to hear any personal convictions, and yet now I'm hearing that those matter a great deal.
Senator, could I explain
Please,
that?
May I have more time then?
Go ahead.
Thank you, Mr. Chairman. I belonged to 4 labor unions before I got here. It's really important. Friedrichs is an important case. We couldn't get any personal convictions on anything, basically. What is your, Mr. Calamine, what is your read on, from what you see from his decisions, on how you feel about he will rule on Friedrichs? What's your?
I think this Trans Am trucking dissent is only 7 paragraphs long, and I think it's worth reading it closely because of what it shows his judicial philosophy being capable of, which is rewriting law, not just applying the laws written by Congress, but rewriting it. That's why one should pay attention to that decision as a guide on how he might treat other workers' rights laws, and then you pay attention to what he says in that decision and the way he treats the workers' perspective in that case. For example, he describes the option that the supervisor gave to the worker to illegally drag the trailer down the highway as being maybe sarcastically offered. In other words, he's excusing the boss's outrageous order. When it comes to describing the option of staying at the truck and freezing, suffering hypothermia, he describes that as merely unpleasant. And I'm adding the word merely there. He describes it as unpleasant. And he describes, creates an analogy for this situation involving an office computer rather than a truck and freezing to death. That analogy, I believe, shows a bit about what the real concerns are here, which again is from the boss's perspective.
The
I think
hostility to the worker here.
Yes, sir. If you let Mr. Madden drive his truck to safety, well, the next thing you know, we'll have to let him drive the truck to the beach, is the sense one gets from it. So we are concerned about his ability to look at things from a worker's perspective.
I know I'm out of time. I just want to say one thing about that, which is that it wasn't about discomfort. He had hypothermia. He had fallen asleep with hypothermia, but only was woken up when his cousin called him. And the way you freeze to death is you fall asleep and die. So he was really given a choice between dying, possibly dying, or unhitching that cab and driving off. And this says to me a lot about the man's judgment. So, thank you, Mr. Chairman, for your indulging.
Judge Tacha, I'd take a few minutes to say what you wanted to say, and then we'll go to Senator Kennedy if he has. Do you have questions, Senator Kennedy? Yeah, go ahead.
Just very briefly, to the question of personal conviction. What I meant there, and what perhaps I didn't get clear, is each judge brings to his or her reading of the law their own intellect, their own interpretations, their history, their precedent. And so and I'm going to give you an example here because it's really important. Judge Gorsuch and I disagreed in a very, very important case. I won't bother you with all the details, but we read the law, it happened to be First Amendment law, quite differently. We tried to reach consensus. We were in lots and lots of conversations. Judge McConnell was in on this too. And note, all 3 of us appointed by Republican presidents, when we all three had very different views on this very important First Amendment case. Finally, it came to the point where my reading of the law was different from Judge Gorsuch and Judge McConnell's. Now, I ultimately became convinced that I was wrong after the Supreme Court reversed me 9-0. But it was a wonderful exchange and a wonderful way to bring different judges' perspectives onto the interpretation of whatever the case or the law is.
Senator Kennedy.
Thank you, Mr. Chairman. Mr. Jaffer mentioned a few cases that Judge Gorsuch had worked on at the Department of Justice, and I note in one of those matters the government actually continued the litigation during the Obama administration. In fact, it filed a cert petition, made the same argument as the Bush administration had made, and the Solicitor General who signed the brief was now Justice Elena Kagan. Of course, she was serving as Solicitor General at that time. I'd like to make the briefs a part of the record, Mr. Chairman, in the case of United States Department of Defense et al. Petitioners versus American Civil Liberties Union.
Without objection, it's included.
All right. Just because of the nature of our job, my guess is the person on this panel who's been around the judge the most in the shortest period of time is Ms. Bresic. Am I saying your name right? Okay. And I believe you joined the judge right out of law school. Why don't you turn your mic on?
I apologize. I clerked on the Southern District of New York and then went to clerk for the judge on the 10th.
Okay. And you finished Vanderbilt Law School? You
Yep.
first in your class?
I was.
Order of the Coif?
Yes.
Okay. You were with the judge probably about every working day, right?
Absolutely.
Yeah, it's just the nature of being a clerk.
That's correct.
Tell me what he's like.
The judge is an incredibly caring person. I think sometimes when we read his opinions and we hear, and we get these characterizations of that he's very robotic, I think that misses the essence of the judge, which is he takes very seriously his job of interpreting the law correctly. And he also obviously also has great sympathy for the litigants that appear before him, and he has deep respect for the litigants. And I think anyone who's appeared before him, as well as his clerks, understand that. So I think that the sense that I had to respect everyone around me, I think, was really solidified in that year of clerking. And I think he's an individual who is not only brilliant, but very humble in the way that he approaches his important task of applying the law to the facts of a particular case, but also clearly understands that the litigants in front of him are real people.
Okay, and I appreciate all that. Tell me what he's really like.
Well,
what's in his heart?
He's a very caring man. I think that on a personal level, he always wants to know what his clerks are planning to do after their clerkship. He takes very seriously the choices we make, whether we go into public service, whether we go into the private sector. He cares when you have personal events in your life, whether you get married, whether you have a kid. And I think that, but beyond just the intelligent judge, he's just an incredible human being.
Is he political?
Not when we're deciding cases, no. I mean, again, when we approach cases, we're just looking at the arguments that have been made by the litigants, the law before us, and the facts of the case. And politics has no place when we're looking at a case in that way.
Did you ever see him decide a case based on one of the litigants' wealth or status or power?
No.
Okay. Did you ever see him approach a case in terms of, here's the result I want, now let me figure out how to get there? Or did he approach it from, let me look at the law and see what the law says, and then that'll determine who wins the case?
The latter. What he does is he approaches the case. He looks at the arguments that have been made by the parties. He looks at the applicable text, whether it's a contract, a statute, or the Constitution, and then he sincerely takes his task very seriously of attempting to figure out what Congress meant by the words of, for example, a statute, or what the parties meant by the words of a by the words of a contract, and that's how he figures out the result that is required by the case, not based on the identity of the parties before him, government or individual litigant.
Did he read the briefs, or did he give them to you and say, summarize them for me?
No, we read the briefs, and then he read the briefs, and then we talked about the briefs.
So you both read the briefs?
Absolutely.
Okay. Did you ever see him render decisions that he felt the law required, but he wasn't necessarily happy with the result?
Absolutely. I mean, the job of a judge is a very difficult job. I think sometimes there are very sympathetic parties that appear before him, but he takes very seriously his oath to apply the law before him, and sometimes that means results that are not in favor of very sympathetic parties, but that doesn't mean that he lacks sympathy for them. He simply takes very seriously his oath to apply the law.
Thank you, Ms. Brasch. Thank you, Mr. Chairman.
Sure.
Thank you very much, Mr. Chairman. I think I'll just start with you, Mr. Perkins. Thank you so much for being here and for sharing your son Luke's experience with us. This was a matter of discussion yesterday at the hearing, as you probably heard, in light of the Supreme Court's 8-0 decision rejecting the standard that had been used in your son's case and that denied him the help that he needed. What did you think when that opinion came out yesterday? How did you feel about it?
Well, I guess the first thing was just I was very happy for Andrew F. and his family having gone through what they went through to ultimately have that vindication. And I think for ourselves, although belatedly, we did feel vindicated. We felt that ultimately when a very similar case made it to the
I've been
Supreme
asked
Court.
to have you speak into the mic, please.
Okay. When this case was decided, I mean, we felt in a sense, although indirectly, Luke's case and Luke's situation was being vindicated.
You know, my mom taught second grade till she was 70 years old and worked a lot with kids with disabilities in public school. And as a parent of a son who's benefited from the IDEA, could you quickly talk about what the law's mandate, which is to help students achieve, quote, full participation, independent living, and economic self-sufficiency means to your family?
It's huge. Luke, without an appropriate education, was in a very restricted situation. He basically lived his life in his house and in a special needs classroom in school, and that was it. That was the only context that he could be in. And behaviors and lack of tools to deal with his disability really restricted him. Now he has a good life. He enjoys what he does. He is able to get joy out of interaction with peers, with his family. It's a huge difference in his life.
Thank you so much. Mr. Calamine, just again, briefly, we have little time. I questioned the nominee a lot on the Gutierrez case, which is the concurrence that he did to his own opinion regarding the Chevron doctrine. And as you know, Chevron allows some deference to administrative decisions by agencies. Could you just briefly talk about how the uncertainty this would create for safety rules in your industry if this was overturned?
Well,
for workers.
As I mentioned earlier, the rule that allows us to refuse hazardous work, to do hazardous work, is a rule that isn't explicitly in the OSH Act. It's been developed through agency interpretations of the statute. So this creates an opportunity. If the courts are not going to follow Chevron deference, it creates an opportunity to just strip those kinds of rights away. And those rights, as we speak, are saving lives right now. That's what's at stake here.
Thank you very much. Last, Ms. Massimino, thank you so much for being here. You talked about in your written testimony about the importance of checks and balances. The Constitution gives the president certain powers as commander-in-chief, but those powers have the potential to be abused if they are unchecked. How should the Supreme Court approach, in your mind, with your background with human rights, how should the Supreme Court approach the balance between national security and civil rights? And what does a judge's record suggest about how he would assess presidential assertions of executive authority?
Thank you. Well, it's often said that there needs to be a balance between security and liberty, but we know from long experience now that respect for human rights and individual dignity is the foundation of peace and security in the world. That was the wisdom of the Universal Declaration of Human Rights that Eleanor Roosevelt pushed forward, and it remains true today. I heard Judge Gorsuch testify the other day that no man is above the law. And that's an important tenet for our democracy. But unfortunately, we know from sad experience, fairly recent, that that's not enough. When the Bush administration authorized torture and other abuse against detainees, torture was already a federal crime. And the problem was that the administration, and in particular many of its lawyers, had a different view of the law. So it's not enough to say that no man is above the law. According to the legal memos that were prepared at that time by Bush administration lawyers, they believed that the law against torture allowed torture. This is sort of an Alice in Wonderland kind of situation that we were in. And that's why I find that email that Senator Feinstein pointed to from Mr. Gorsuch while he was at the Justice Department one of the most troubling things about his record. He was basically arguing there that the Bush administration ought to interpret the McCain Amendment. That was one of the strongest and most bipartisan pieces of anti-torture legislation that this body has ever enacted, as actually codifying and legalizing torture rather than prohibiting it. And when he was asked, when Judge Gorsuch was asked the other day in the hearing whether there were any circumstances in which it would be lawful for a president to authorize torture or to authorize an act that was specifically prohibited through an act of Congress, he didn't answer that question. And I think it's very important, particularly in this environment where we have a president that is asserting these kinds of powers. Each branch of government has to play its role, and it's going to be particularly important that the Supreme Court is willing to stand up to executive overreach in the era that we're in now. So I urge you to really get clarity from Judge Gorsuch about his specific views on those issues.
Thank you very much.
Thank you, Mr. Chairman. And I appreciate all of you being here. I have a question for Mr. Jaffer. I grew up in a family that believes very strongly in the Constitution, especially the First Amendment. They had owned a small weekly newspaper and then a printing business. They said, right to practice any religion you want or none if you want is important. The fact that you could say what you want is important. If you guarantee all that, you guarantee diversity. If you guarantee diversity, you guarantee a democracy. But you also have to have an independent judiciary. I'd asked Judge Gorsuch to give me a clear answer to basic questions. I asked him whether the First Amendment prohibits the president from imposing a religious litmus test, an entry into this country. I thought it'd be a fairly easy question. He said it's currently being litigated, so he couldn't discuss it. I meant as a softball. So, does the Constitution allow the president to impose a religious litmus test for entry into the United States? Your microphone.
Yeah, of course not, Senator Leahy.
And does it concern you that he wouldn't answer that question?
You know, I think that there's a bigger concern here you know, some of the responses that Judge Gorsuch gave to questions like this, including in response to questions about executive power, I think were very abstract. And I don't think it's enough, for example, to say no person is above the law in response to a question about the Youngstown framework. You know, the dispute 10 years ago over torture was not a dispute between people, you know, on one side who said we should follow the law, and on the other side, people who said we shouldn't follow the law. Everybody claimed to be following the law, including the Bush administration officials who authorized torture. So really, I'm hoping that in questions for the record, the committee will be able to get Judge Gorsuch to speak more specifically about the role he envisions for the judiciary in the context of national security.
Hope springs eternal, but don't hope too much that he might. I was thinking of what Miss Massimino. You'd think with my Italian background, an Italian mother, I could pronounce that correctly, but you'd raise the action of the Justice Department, and I'm very concerned that he declined to answer any questions regarding his role there, what his views were on it, even though documents indicate they helped the Bush administration justify torture, indefinite detention, warrantless surveillance. Should we be concerned about that work?
I think you should. And, you know, that period of time in our history was so important to our democracy. And we talk a lot here about the law, but, you know, it turned out that the lawyers were actually, in many respects, even more important than the law, because they were the ones who were trying to interpret what the law meant. And, you know, there were other people at that time, government lawyers, who were extremely troubled when they found out what was going on, and they tried to stop it. And from the record that we have here, it does not appear that Judge Gorsuch was one of them.
Well, it is a great expansion of executive power that many of us question. And in my remaining time, I know Mr. Perkins, I listen and know about the story of Luke. And, you know, I'd hate to have been in your shoes, but I think I would have felt the same way. But we found out yesterday, Judge Gorsuch's application of the Individuals with Disabilities Education Act was turned down by the U.S. Supreme Court. They said the standards are markedly more demanding than the standard that Judge Gorsuch created in your son's case. How did you feel about, what did you think when you heard the Supreme Court?
I was very happy that they reversed a trend that clearly Judge Gorsuch and the 10th Circuit have been part of, to water down the standards for progress such that they were of minimal practical benefit. And because even with these very watered-down standards that were part of Luke's education program, he was only meeting 25% of his objectives. But I really appreciated the fact that that Judge Roberts, or Chief Justice Roberts, used words like, every child should have the chance to meet challenging objectives. That indeed is the case, and when that can happen, even a child with severe disability can make tremendous progress.
Thank you very much. Thank you, Mr. Chairman. And I thank the senator from Wyatt.
Senator Hirono, I mean, sorry.
Thank you, Mr. Chairman. Thank you all for being here. Mr. Perkins, yesterday was a good day for your family with the Supreme Court's decision. IDA is what I would call remedial legislation meant to protect a class or a group of people in this case, people with disabilities. And generally, remedial legislation, not even generally, remedial legislation should be broadly interpreted to effect its purpose. So when you were before Judge Gorsuch and you saw that opinion, do you think that Judge Gorsuch did, in fact, do that, broadly interpret IDEA to effect its purpose in your son's case?
Absolutely not. In fact, he did the exact opposite. He took precedent that, frankly, in light of yesterday's decision, was already inappropriately narrow or restrictive, and further restricted that interpretation, such that I really wondered why would Congress even bother if that's really what IDEA meant.
So do you think that if Judge Gorsuch had looked at the legislative history, perhaps, of what was behind IDEA, that he may have issued a more expansive ruling than what than his dissent showed?
I would hope so. I know that his picture of what he felt the law said was a huge distortion of what the actual intent was. And so I would have hoped that if he had looked into it some more, he might have been able to see that he had reached a wrong conclusion and maybe backtracked in his judicial reasoning and come to a more appropriate conclusion.
So I understand that your family had a lot of resources. You are a doctor, you had parents who helped you. You did different things to accommodate the needs of your child. And I'm wondering whether, as you sat there before Judge Gorsuch, and knowing that your family is one of literally thousands, hundreds of thousands in our country who have children who look to the IDEA for the kind of educational support that they required, what did you think about all the families who don't have the kind of resources that you have, and what Judge Gorsuch's ruling would have done to their ability to do the best for their child with disabilities?
Actually, that is probably one of the most frequent thoughts that we had through this whole legal process, is just realizing how overwhelmed we were with all of the resources, financial, family support resources that we were blessed with. We were overwhelmed, and to think that the people out there, I mean, many of my patients, I think, how in the world, if they had had Luke in their family, could they have done this? It's having a child with a severe disability is completely overwhelming, and sometimes it may seem impossible. I mean, even for us with our resources, we felt at many times that this may be impossible because the law apparently isn't on our side.
Thank you. With the brief time that I have left, I'd like to ask Mr. Calamine. We have concerns about how Judge Gorsuch would rule in cases relating to workers' rights and unions, and I refer to his decision in NLRB Community Health Services. Is that a decision you are familiar with?
Yes. Now that I've looked back at my
familiar
notes here.
enough.
A little bit.
So he had a dissent there that really disadvantaged these workers who had been illegally denied longer hours, and it affected their pay, so they had to get another job. Would you share your thoughts on Judge Gorsuch's dissent and his overall judicial record on workers' rights, really briefly?
Briefly, the dissent in that case involved, I believe, Judge Gorsuch saying that these hospital workers who had been unlawfully, their hours had been reduced unlawfully, they went out and got other jobs to try and make up for their loss of income. What Judge Gorsuch wanted to do in his dissent was to subtract the money that they earned from those outside jobs from the total back pay award, which meant, it does not recognize, it's an example of not recognizing what life is like for somebody working for hourly pay, trying to make ends meet. Just going out and getting another job itself is a big problem. You've got new schedules, you've got family issues.
So my question really was whether you think that on the Supreme Court he would continue to
That is the
a very
concern.
restrained view of workers' rights.
That is the concern we have, that the workers' perspective isn't going to see a fair shake here.
Thank you, Mr. Chairman.
I have one question, then I'll turn to Senator Feinstein, and when she's done, we'll bring on the next panel. Judge Kane, I bet this is the first time since 1977 since you've been before this committee. Is that right?
That's correct, Senator.
This is, you've been a judge for 40 years, but before that, you were a public defender. When you were a public defender, did you adopt every position of your client?
Well, I represented a number of murder defendants, and I didn't agree with them on that.
So you can represent somebody without agreeing with them, just like Judge Gorsuch, when he was in the DOJ, could also represent his superiors as their counsel.
Absolutely.
Okay. Senator Feinstein.
Your Honor, I would just say, this is just my view, that for those in government, the standard has to be a little bit different. You have to do what's right. And this goes up even to the launching of a nuclear bomb. I asked someone who was in a position once, if you thought the president was absolutely wrong in what he was doing, would you deny a launch? And the answer was no. And that caused me to think about the obligation that we have as service in government to do what's right as far as we know it. And I think that even affects attorneys who have bosses, because in this case, lives are a real problem. In any event, I would like just quickly, and then to put in the record, the Supreme Court's opinion in the IDEA case. And I'd like to just quote a few lines. To meet its substantive obligation under IDEA, a school must offer an educational improvement plan reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. The reasonably calculated qualification reflects a recognition that crafting an appropriate program of education requires a prospective judgment by school officials. So I would like to put that in the record, if I may, Mr. Chairman.
Without objection, so ordered.
The second thing, in response to my friend and colleague who spoke about the Detainee Treatment Act, Senator Graham, I was McCain's co-sponsor on his bill, and I would like to read from his statement on the floor on February 13th, 2008. And in this, he makes clear that his view of the Detainee Treatment Act in 2005 outlawed waterboarding. He says, and I quote, "I stated during the passage of that law that a fair reading of the prohibition on cruel, inhumane, and degrading treatment outlaws waterboarding and other extreme techniques," end quote. So I would ask that this statement be part of the record as long, and also the opinion in this case.
Without objection, so ordered. Now, should I go to Senator Blumenthal?
Yes.
Senator Blumenthal?
Thank you, Mr. Chairman, and thanks to the members of the panel for sharing your insights and experience with Judge Gorsuch. I have a question for Mr. Calamine, but others are free to answer it as well. As you know, the importance of our consideration here is not only the results. In fact, even more important than the results, the judge's method of reasoning, his approach to analysis in cases. And a couple of cases I think are illustrative in Compass Environment, Inc. versus OSHRC. Judge Gorsuch voted to overturn a fine that was imposed by the Department of Labor against a company whose failure to properly train a worker actually caused a death. In Trans Am Trucking versus Administrative Review Board, as we all know now from the discussion that took place when he testified here, he voted to reverse the judgment of both an administrative judge and the Department of Labor, which held that a truck driver had been improperly fired in violation of federal law. Truck driver abandoned his truck, sub-freezing weather, when the heater in his cab failed to function, and did so, in essence, to save his own life. I wonder if you could comment about the purpose of the laws that he was interpreting here and why you have reservations about his analytical approach, his method of reasoning in approaching these laws, and other cases that have the same effect. And I open the same question to others on the panel.
Thank you. So the purpose of the laws in the two cases that you just mentioned, Compass Environmental and Trans Am Trucking, the purpose of those laws is to protect workers' health and safety. And one of the most alarming things about one of those cases is Judge Gorsuch describing those purposes as ephemeral and generic. In other words, there's not enough concrete there to allow those purposes to guide how we interpret these laws. So instead, we turn to things like the Oxford English Dictionary, which he did in that particular case. Another concern from the other case, from Compass Environmental, is his description of OSHA's powers as being remarkable. And in that case, the worker had been electrocuted to death, and the remarkable power imposed by OSHA was a $5,550 fine, just a $5,500 fine on the employer. And that is described as remarkable. And that is a concern because workers in this country rely on that agency and other agencies to enforce their rights every day. And we have come to rely on those interpretations. We want to know what the law is. We don't want the second edition, 1989 Oxford English Dictionary to suddenly be pulled out to change that law. And that's what almost happened in Trans Am Trucking, a rewrite of the law.
Any other members of the panel?
If I might, Senator.
Sure.
I'm comforted to hear that you specifically note that we're not going to just look at the results of cases in judging Judge Gorsuch, because obviously he's been on the bench for 10 years, so we're focused on certain cases in which he may have ruled against certain workers, but there are a number of other decisions that I believe the committee is aware of, where he ruled in favor of workers. And I believe that the approach he applies in all of those cases, irrespective of the result, is to look at the text as was passed by Congress and apply it fairly to the facts before him. And I believe that it's that process that does not change. It's the results that change based on, obviously, the facts of the case before him as applied to the statute.
And the reason I asked about the reasoning and analytical approach is precisely the answer that has just been given. To regard a worker protection statute or the concept of health and safety as ephemeral and generic is, in my view, a gross understatement of the purpose of these laws, which are basic to people who leave their homes in the morning, say goodbye to their families, expecting to come home at the end of the day without having been injured, maimed, or killed. That's the purpose of these laws. That purpose is not generic or ephemeral. It is urgent and important. And Mr. Calamine, I think, well stated the reservation I have based on his use of that language. And by the way, I've been here for 7 years. I've never heard any United States senator quote the Oxford Dictionary for the meaning of a term. Never. Not once. And yet Judge Gorsuch uses it very, very abundantly in his opinions to seek a definition for how he's going to apply a statute. That's not a real-world approach to health and safety. And it concerns me. And that's why I asked the question. But it's not the result alone. In those cases, I was concerned about the result. He probably has ruled for individuals, and we've been throwing around this term, the little guy. It doesn't matter whether it's a big or little person or group of people. It's more the concept of preserving worker safety that is important. Thank you.
You bet. Thank you, Senator Blumenthal. Thank you all for your presentation, more importantly for your preparation and for informing the committee. Thank you very much. And will the second panel come? But while the second panel come, and please don't sit down until I swear, but I want to inform the members.
Swear you in, you mean? You're not just going to swear.
Yeah, swear in, yeah. Here's what I'd like to have the members think about. We will not get through this panel presentation at 12:25 is when the vote starts, so I think we're going to go with this panel till 12:35, and then we'll recess, and I'll vote at the end of the first vote, and then vote on the second vote immediately. So that means we'd probably reconvene this panel about 1:05 or 1:10 in that period of time, and then we'll have the rest of the panel presentation and the questions, and then we have yet one more panel, I believe one more panel after that. So do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. I'm going to do something that I forgot to do, and it was very wrong of my not doing it. I didn't say anything about the last panel individually. Jeff Lampkin is a founding partner of Molo Lampkin, and he clerked for Justice O'Connor. Heather McGee is president of Demos. Is that how you, Demos? Okay. Professor Lawrence Slocum is a Carmack Waterhouse professor of law, Georgetown. Fatima Goss-Greaves, senior vice president for program and president-elect of the National Women's Law Center. Professor Jonathan Turley is on TV all the time. That doesn't say that here, but I can say it. Is the J.B. and Maurice C. Shapiro Professor, Public Interest Law, George Washington U. Pat Gallagher is Director of Environmental Law Program, Sierra Club. Karen Harnan is Executive Director, the National Federation of Independent Business, Small Business Legal Center, and Eve Hill is partner with Brown Goldstein Levy. She previously served as Deputy Assistant Attorney General for the Civil Rights Division from 2011 to 2017. We'll start there and we'll go until we see how this vote goes.
Thank you, Mr. Chairman. Ranking Member Feinstein, members of the committee, for the opportunity to speak to you about Judge Gorsuch. Since clerking for Justice O'Connor in 1992, I've had the honor of arguing 23 cases before the U.S. Supreme Court, many of those as an assistant to the Solicitor General, first under Seth Waxman, who was President Clinton's Solicitor General, and then later under Ted Olson, who was President Bush's. I've known Neil Gorsuch, Neil as I've always known him, as a colleague and a friend for more than 20 years. My wife, who's here today, has known him even longer because she went to law school with him. I like to think I helped recruit Neil to Kellogg Huber after his Supreme Court clerkship and his time at Oxford. I think I may have edited the first brief he ever wrote as a young lawyer. I understand he's improved substantially since then. And I can tell Senator Sass that he'd never once used the word bigly in a brief. Of course, from the outset, it was always clear to all of us that he was not only smart and thoughtful and a great writer, but he had great judgment. In both a literal and figurative sense, he had gray hair from the beginning of his career. But I want to speak to you about something other than Judge Gorsuch's legal acumen. I want to speak to you about his kindness, his compassion, his generosity of spirit as a person, and why those values are integral to who he is and what we should expect to him from the bench. Since I first got to know Neil many years ago, he's been one of my dearest friends. We both have 2 daughters, his a bit older than mine, and he's always been there for me to listen, to advise, to commiserate about the trials and travails of the often difficult project that's being a parent. I have vivid memories of standing in Neil's backyard in Colorado after he became a judge, talking about what then seemed to me about a very difficult moment. As we spoke, we scooped up horse manure while his family's pet goat Nibbles tried to ram the judge. I honestly never understood what they saw in that goat. Neil's kindness resonated throughout his family, excluding the goat, of course. His daughters were always so sweet to my children, even though my kids were considerably younger. I remember Neil and his kids repeatedly leading one of my kids through one of life's adventures by the hand, whether trying to balance on skis or trying on hats at a department store. If something happens to me and my wife, Neil stands in line to inherit my children. Some people say, if you want a friend in Washington, get a dog. Those people never got to know Neil Gorsuch, his wife Louise, or his family. Simply put, Judge Gorsuch is a thoroughly decent and kind person. So why does that matter to this body as it's considering his nomination? As a former colleague of mine from the Solicitor General's office told me, if you have someone who's that good a person, it means he listens. It means he truly hears. It means he can be persuaded. That is, to my mind, the most essential attribute for a Supreme Court justice. The Supreme Court has an argument calendar, but the printed list of cases and counsel the court prepares for each session is called the hearing list. It's the chance for people to be heard. When the Chief Justice calls each case, he says, "We'll hear argument in case number," and then he gives the case number and the case name. The key words there are hear argument, not just have argument, but hear it. I know that everyone who appears before Judge Gorsuch, before Neil, will be heard, genuinely heard, regardless of who they are, who they represent, their position, or the nature of the controversy. His kindness and his humility make him place an extraordinary value on listening to the lawyers, to his colleagues, and to those with backgrounds different from his own, who may come at the matter from a different angle or insight born of different experiences. I've heard a lot of speculation over the last few days and months about how Judge Gorsuch might rule on this matter or the other. I don't know how he might rule. I don't think he knows. These are often really hard cases. That's why they get to the Supreme Court, because they're hard, because the judges disagree. But I do know that Judge Gorsuch will struggle with those hard cases. He will immerse himself in the law, in precedent, in the context, in the record, in the briefs, in the arguments. He'll listen to the litigants, listen to his colleagues, to history, to experience, and its lessons. And he will decide the cases based on where those things lead him at the end of the case, based on the force of the better argument, not based on a pre-existing intuition that may predate the case's beginning. That, I believe, is precisely what we should all hope for from our judges and justices. That's true whether you consider yourself a Democrat like me, or a Republican, or an independent. If the Senate believes that as well, I believe that Judge Gorsuch should be confirmed. Thank you.
Ms. McGee.
Chairman Grassley, Ranking Member Feinstein, members of the committee, thank you so much for the privilege of testifying here today. My name is Heather McGee, and I'm the president of DEMOS, a public policy organization working for an America where we all have an equal say in our democracy and an equal chance in our economy. What's at stake is not just the critical issues that you've heard about over the past few days, but the way that we, the people, make decisions about all of the issues that we face as a nation, and whose voices are heard in that process. Judge Neil Gorsuch has the potential to be the deciding vote to destroy the few remaining safeguards against big money corrupting our politics completely. His troubling record on money and politics requires this committee to reject his nomination to the U.S. Supreme Court. I'd like to make 3 basic points today. First, that the way that we fund our campaigns in the U.S. enables wealthy individuals and institutions to take their economic might and translate that directly into political power. Second, the Supreme Court's activism in striking down democratically enacted safeguards is what has brought us to this perilous place in our history. In the world's oldest democracy, nearly 9 out of 10 Americans have lost so much faith in our system that they think a total overhaul is needed. Senators, we are near a breaking point. 9 out of 10. It's hard to imagine things getting worse, and yet the prospect of a lifetime seat for Judge Gorsuch has given us a glimpse. Fortunately, there is an overwhelming bipartisan consensus supporting pro-democracy reforms, even though Neil Gorsuch is far outside of that consensus. Your constituents want you to stand up to big money, and your vote on this pivotal Supreme Court seat will be one of the best chances you will ever have to do so. Leading political scientists have concluded that our government now resembles a plutocracy more than a representative democracy. Just 25 individuals pumped more than $600 million into last year's elections. Less than 1% of the population provides the vast majority of the funds that determine who runs for office, who wins elections, and what issues get attention from elected officials. They say that he who pays the piper calls the tune, and so, of course, our public policies are skewed towards the wealthy and away from working-class families and people of color, who remain massively underrepresented among top donors and in the halls of power. The role of the Supreme Court in creating this crisis can't be emphasized enough. Last week, DEMOS released a report calculating how much extra money has flowed into politics because of Supreme Court rulings striking down campaign finance laws. We found that in the 2016 election cycle, court decisions were responsible for nearly half of all the big money spent. Still, it's not too late to reverse course. The Roberts Court's campaign finance rulings have been 5-4 decisions in which the majority's basic assumptions about politics have been proven false, including the idea that so-called independent expenditures are actually independent of candidates and therefore can't be corrupting, and that disclosure laws would be effective. With a Supreme Court that was responsive to the facts rather than ideology, we could end the super PACs that the court created and begin to restore our democracy. But Judge Neil Gorsuch would have been with the majority in Citizens United. His overall record puts him to the right of Scalia, and on the question of money in politics, he would take us even further down the Roberts Court's extreme path. Judge Gorsuch has had 2 directly relevant cases. In Hobby Lobby, he voted to expand First Amendment rights for corporations, building on Citizens United's troubling logic. In Riddle v. Hickenlooper, he went out of his way to signal openness to applying the harshest possible standard of review to campaign contribution limits, which would deem a wealthy donor's check worthy of more constitutional protection than the court has consistently offered for our most precious right to vote. Judge Gorsuch was given an opportunity in this room to distance himself from one of the most unpopular court cases in American history, and he failed to do so. Thankfully, outside of the Beltway, this is not a partisan issue at all. 91% of President Trump's own voters thought it was important that he appoint someone to the Supreme Court who'd be open to limiting big money in politics. 70% of Republicans say that Congress should reject any nominee who, quote, will help the wealthy and the privileged wield too much power in our elections. The American people are demanding change to a political system that favors the already wealthy and well-connected. So we urge you to vote against Judge Gorsuch's nomination and to tell your constituents that a key reason you did so was to stand with them over big money. They will thank you, and I thank you.
Thank you very much. Professor Solum.
Thank you very much, Senator. Ranking Member Feinstein. I voted for you in 1992, and it's a pleasure to appear before you today. My statement concerns an aspect of Judge Gorsuch's judicial philosophy, originalism. And over the course of this hearings, I think we've learned several things about originalism, and there are still some things I think that might be cleared up. What is originalism? It consists of three basic ideas. The first idea is that the meaning of the Constitution should be its original public meaning, the meaning of the words and phrases in context to we the people. The second idea is that that meaning is fixed, not that the law is fixed, but that the meaning of the words is fixed at the time they're written. And the final idea is that that original public meaning should constrain what judges do. That judges, the president, the members of this august body are all bound by the original public meaning of the Constitution. Over the course of the past 3 days, we've learned some other things. We've learned that there are a number of myths about originalism, and I think that those myths have, for the most part, been cleared up. Originalism does not ask the question, what would Madison do? A very silly question when we try to apply the Constitution to modern circumstances. We've learned that the words of the Constitution can be adapted to new circumstances. At the time the Constitution was adopted, California did not exist. It was not a state. But we have no problem concluding that nonetheless, California is now a state and entitled to 2 senators in this body. We've learned that Brown v. Board, one of the most important decisions in the history of the Supreme Court, is not inconsistent with the original meaning of the Constitution. As Judge McConnell demonstrated in 1995, Brown v. Board was required by the original meaning of the Constitution. And we've learned this very clearly, that originalism is not inconsistent with precedent. What I'd like to say today, most importantly, is that originalism is in the mainstream of American jurisprudence. Originalism in the mainstream of American jurisprudence because throughout our history, for the most part, with some important exceptions, the Supreme Court has been an originalist court. But originalism is in the mainstream for another reason. Originalism can and should be endorsed by both Democrats and Republicans, by progressives and conservatives. This point is important to me personally. I'm not a conservative. I'm not a libertarian. I'm not a Republican. But I do believe in originalism. Why is that? It's because I'm convinced that giving power to judges to override the Constitution, to impose their own vision of constitutional law, is dangerous for everyone. If you're a Democrat and you know that the next justice to the United States Supreme Court will be appointed by a Republican president and confirmed by a Republican Senate, would you prefer that an originalist like Judge Gorsuch be appointed, or would you prefer a conservative justice who's a living constitutionalist, who believes that their values are an appropriate ground for modifying or overriding the constitutional text. There's a final reason that originalism is in the mainstream. The Supreme Court has never claimed the right to override the Constitution. There are cases where the Supreme Court did, in fact, depart from original meaning. But in all of those cases, the Supreme Court either strained to make its decision consistent with the text or ignored the text altogether. I support Judge Gorsuch's nomination because he is an originalist.
Thank you, Professor Solum. Ms. Graves.
Thank you, Senator Ranking Member Feinstein and the committee. My name is Fatima Goss Graves, and I am Senior Vice President for Program and President-elect of the National Women's Law Center. Since 1972, the center has been involved in virtually every major effort to secure and defend women's legal rights. I thank you for your invitation to testify today and ask that my full written testimony be submitted. Over the past few days, Judge Gorsuch has talked a lot about how he follows the law rather than his personal views or his feelings, and that he applies the law to facts. But a review of his record shows that time and again, his approach to the law gives the benefit of the doubt to employers, to politicians, to other powerful entities, rather than the vulnerable individuals who rely on the law for protection. And time and again, this approach disadvantages women. If you take the case of Betty Pinkerton, an administrative assistant whose sexual harassment claim was dismissed, Judge Gorsuch ruled against Ms. Pinkerton on the grounds that her failure to report the harassment she faced for all of 2 months was unreasonable. During that period, she had to listen to her boss ask about her breast size, ask about her sexual habits, and under Title VII, these sorts of remarks only become a pattern of harassment as they add up over time. If she complained too early under Title VII, she'd have no claim. And waiting 2 months, under Judge Gorsuch's approach, again, she had no claim. This is an approach that ignores the workplace realities that the law is designed to address and the very nature of workplace harassment. Or if you take the Hobby Lobby case, in which a corporation challenged the Affordable Care Act's birth control benefit, which requires health insurance plans to provide birth control without cost sharing. Access to contraception means for women the ability to plan their lives, to plan their futures, and the birth control benefit relieves women of a steep financial burden, which can run as high as $1,000 in upfront costs. Judge Gorsuch joined the 10th Circuit holding under the Religious Freedom Restoration Act that an employer's religious beliefs could override an employee's right to birth control under the Affordable Care Act, including an especially extreme holding that promoting gender equality and public health, the very goals of the birth control benefit, were not compelling government interests. His concurring opinion was stunning in its refusal to even acknowledge the health impact and the financial burden on women who would lose insurance coverage under his approach. Ultimately, the case reached the Supreme Court, and unlike the decisions joined and written by Judge Gorsuch, the Supreme Court instructed that as a part of RFRA's balancing test, courts must consider the impact on women. Judge Gorsuch's record also shows hostility to the Constitution's protections of the most personal and intimate decisions, which is the basis for the right to birth control and the right to abortion. Yesterday, Judge Gorsuch declined to say whether Roe v. Wade was correctly decided, merely acknowledging that it is actually precedent of the court. And he refused to answer key questions about other areas of the law that accord to women's lives. When he was questioned about letters from former students who claimed that he had suggested companies can and should ask women and only women about their pregnancy plans and their family plans. Even in explaining this incident, Judge Gorsuch shockingly refused to acknowledge that such behavior would violate Title VII. And to be clear, statements like these are wildly at odds with the very letter and the very purpose of Title VII and the Family Medical Leave Act. Finally, we reviewed Judge Gorsuch's record against a highly unusual backdrop, including promises made by President Trump that his nominee would overturn Roe automatically, and that he would be selected from lists approved by the Heritage Foundation and by the Federalist Society, a really highly unusual occurrence, to say the least. When you put these extraordinary promises together with the judge's record and his refusal to provide anything but platitudes about his judicial philosophy to this committee, there is only one possible conclusion, and it is that Judge Gorsuch should not be confirmed.
Thank you, Ms. Graves. And to the remaining witnesses on the panel and the members of the committee, we are about halfway through a vote, and we are all going to need to take a recess to go vote. So what we will do is also give a few extra minutes to that recess so that folks can get a bite to eat if they can. And we will, in fact, do we have two votes?
I'll be back here about 1:10 to take up the
Okay,
gavel
so
again.
we will recess until 1:10 and continue our deliberations at that point. The committee's in recess.
It's not possible. It's like really short. I don't feel like I need longer than that though, but I guess maybe I do. Yeah. What's weird is you get people that pull you away. You get people that pull you away, you get people that ask questions, and it's like, before you know it. Just hang out in the back.
I'll let them know.
So, you know, Dee, she did this with the modern she lives we're scrambling to figure that out. And I run a legal center, so.
Started at 120.
We start off as five.
We could get, we can get done.
Youngest boy, very interesting. There was for you. Yeah. It's funny. Right. That we were the only one. Oh, there you go. So we were the only one. And then we're like, I hope not. But then since then, I also testified. But, so, all right. Sure, that's
I will abrogate the recess, but I want to explain something. This vote that we thought would get 2 votes done by 1:10, the first vote's not going to end until about 1:20. So I'll have a chance to get through the 4 people testimony. And then if we have hopefully a Republican, Democrat votes, and they're over here, so I can go finish voting. If you wonder about the importance of voting for me, I haven't missed a vote since 1993, so that's about 7,900 votes without missing a vote, and I don't intend to miss another one. Professor Turley.
Thank you, Chairman Grassley and members of the Senate Judiciary Committee. It's an honor to appear before you today to discuss the nomination of Judge Neil M. Gorsuch for the United States Supreme Court. I believe that a nominee should be extraordinary to merit the distinction of being one of 9 on our highest court. I should state at the outset that I do not agree with all of Judge Gorsuch's legal views. However, I believe that Judge Gorsuch to be an exceptional choice for the court. While many have focused on replacing a conservative with another conservative, the primary concern should be to replace an intellectual with another intellectual. Judge Gorsuch is precisely that type of nominee, who has the intellectual reach and vigor to sit in the chair of the late Antonin Scalia. One of the primary complaints regarding past nominees has been a lack of substantive writings or opinions on major legal issues of our time. Such individuals can make for good nominees. They do not make for great justices. Judge Gorsuch is a refreshing departure from that trend. He has a record of well-considered writings, both as a judge and as an author. So this is not a blind date. We have a very good idea of who Judge Gorsuch is and the type of justice he will be. In my written testimony, I focused on 2 aspects of the nomination. First, I've addressed the criteria often used to evaluate a nominee, and second, I've looked at the cases by Judge Gorsuch, and with a particular emphasis on separation of powers, agency review, and Chevron. Every president and senator has expressed a commitment to placing the best and the brightest on the court, though few would agree on the qualitative measures needed to guarantee that. Historically, the record is not encouraging, to be frank. Our respect for the court often blinds us to the fact that our justices have ranged from towering figures to virtual nonentities. To be blunt, we've had more misses than hits when it has come to appointments onto the court. Top candidates are often rejected due to writings and views that might attract opposition. The result is a preference for nominees with clean records that have no public thoughts challenging conventional theories, not even raising particularly interesting ideas. That is not the case with this nominee. Judge Gorsuch has actively participated in debating some of the toughest questions of our time. This is, in other words, a full portfolio of work at the various highest level of analysis. On the basis of all the criteria I discussed in my testimony, Judge Gorsuch is a stellar nominee. I realize that many do not welcome a conservative nominee any more than they welcomed a conservative president. However, President Trump has every right to nominate someone who shares his jurisprudential views. To put it simply, Neil Gorsuch is as good as it gets, and he should not be penalized for engaging in the policy and academic debates of our time. In my written testimony, I discussed some of his opinions. There are many, 2,700 or so. The jurisprudence reflects, not surprisingly, a jurist who crafts his decision very closely to the text of a statute, and in my view, that is no vice for a federal judge. The exception, as I talk about, is Chevron, in terms of the consistency of his views with those of Justice Scalia. There, we've seen a lot of discussion of cases, which I would be happy to go into. The confirmation hearings bring almost a mythical aspect to this process as people try to predict who a justice will be decades in advance. Of course, nobody knows that, except perhaps the nominee, and if history's any judge, even the nominee doesn't know that. These hearings often remind me of a story of Supreme Court Justice Oliver Wendell Holmes, who was traveling by train to Washington, D.C. when a conductor asked him for his ticket. Holmes looked in all of his pockets, and the conductor finally stopped him and said, "Don't worry about your ticket, Mr. Holmes. We all know who you are. When you get to your destination, just send us the ticket." And Holmes responded, "My dear man, the problem is not my ticket. The problem is where am I going?" Most nominees are in the same position as Oliver Wendell Holmes. They're not quite sure where they're going. People of good faith can evolve on the court. I do not expect Judge Gorsuch to be a robotic vote for the right of the court. While conservative, he's shown intellectual curiosity and honesty that I think is going to take him across the ideological spectrum. But in conclusion, I would simply say, we're not looking for the best imitation or facsimile of Justice Scalia. We're looking for someone who can be an intellectual court on the court in his own right. That person, in my view, is indeed Neil Gorsuch, who just might eclipse his iconic predecessor. Won't be the same. He's going to bring something new. In the end, what I can say about Gorsuch's destination, unlike Holmes's, is that, well, I suppose they have this in common. He'll go where his conscience takes him. It might be a track to the left or to the right, but he'll follow his conscience. And I can't say what the final terminus will be, but it'll be exciting to watch. And it is therefore my honor to recommend the confirmation of the Honorable Judge Neil Gorsuch for the United States Supreme Court.
Thank you, Professor. Now, Mr. Gallagher.
Chairman Grassley, thank you for the opportunity to testify here today on behalf of the Sierra Club and its 2.8 million members and supporters nationwide. A Supreme Court justice holds considerable power over the laws which safeguard the very air we breathe and the water we drink, and the integrity of our democracy. Unfortunately, Judge Neil Gorsuch's ideology threatens both bedrock environmental law and the rights of American citizens to a fair and equal voice in our democracy. For these reasons, the Sierra Club respectfully opposes Judge Gorsuch's confirmation to the Supreme Court. Judge Gorsuch has displayed a consistent willingness to close the courthouse doors to citizens while holding them open for corporate interests. Think for a moment of the child in Bakersfield, California, struggling to breathe as a result of the oil and gas operations right outside her home and school, or of the family who may not be able to take their annual camping trip to the Wayne National Forest in Ohio because of fossil fuel drilling operations at that place, or of the families right here in Washington, D.C. who continue to suffer from the lead contamination of their drinking water. I presume that everyone in this room would agree that every single one of these people deserves access to the federal courts to remedy these wrongs. Unfortunately, Judge Gorsuch's writings and judicial record show that he would shut the courthouse doors on many of these people who want nothing more than to protect their air, water, public lands, and their families. In 2005, Judge Gorsuch authored an article in the National Review entitled "Liberals and Lawsuits," where he criticized those who seek to remedy injustices in the federal courts when the executive branch fails to do its job. While Judge Gorsuch has reportedly stated that he wishes this National Review article would just quote-unquote disappear, his judicial record continues to reflect this philosophy as he has repeatedly denied environmental plaintiffs access to the courts. where citizens must jump through multiple, often insurmountable hurdles just to get inside Judge Gorsuch's courtroom, corporations have been able to walk right in. Let me cite two examples. In 2013, the Sierra Club moved to intervene in a lawsuit that an off-road vehicle group brought against the Forest Service, challenging the closure of certain forest trails to off-road vehicles. The court granted us intervention, but Judge Gorsuch dissented, concluding that we should have been excluded from the case. Tellingly, neither the government, the off-road vehicle group, nor the majority of judges objected to our participation in that case. Second, in 2005, a coalition of citizens groups, including the Wilderness Society and the Sierra Club, challenged a Utah county's attempt to take over Red Rock wilderness areas that were managed by the Bureau of Land Management by claiming that they were county highways. Judge Gorsuch ruled that the citizens did not have standing to sue. They did not get into the courtroom. In an emphatic dissent to Judge Gorsuch's ruling, one that echoes my testimony here today, Judge Lucero, also of the 10th Circuit, stated, quote, "A citizen's right to protest and be heard on the supremacy of federal rules and regulations is ignored." Not only has Judge Gorsuch limited access to the courts, he has stated open hostility to the Chevron doctrine, a long-standing precedent of the Supreme Court that ensures scientific integrity is respected as our public servants implement clean air and clean water regulations. The Chevron doctrine ensures that the laws on the books are carried out by career public servants using the best available science. Here's the most troubling issue. Judge Gorsuch's opinion that Chevron deference violates the Constitution echoes the current White House's extreme anti-agency demagoguery. 1 month ago, Trump's senior advisor Steve Bannon gave a speech to the Conservative Political Action Conference in which he professed that a White House priority is the quote-unquote deconstruction of the administrative state. Trump's massive budget cut for EPA was the next hammer to fall. Sadly, Judge Gorsuch's ideology will further this agenda, hamstringing the EPA's ability to enact pollution safeguards and incentivizing corporate polluters to challenge the EPA at every turn, thereby forcing federal judges to second-guess agency scientists. In closing, we now stand at a precipice in history. How will we deal with climate disruption? How will we lift up our communities who lack access to clean drinking water and clean air? How will we leave a safe and livable future for our children? America cannot afford the appointment of yet another justice whose ideology disfavors citizens groups, favors corporate interests, and leads to the degradation of the environment and our democracy. This is why the Sierra Club respectfully opposes the confirmation of Judge Neil Gorsuch to the Supreme Court. Thank you very much.
Thank you, Mr. Gallagher. Now, Ms. Harden.
Chairman Grassley, on behalf of the National Federation of Independent Business, I am honored to testify today in support of the nomination of Judge Neil Gorsuch to be an Associate Justice of the United States Supreme Court. NFIB is the nation's leading small business advocacy organization with hundreds of thousands of members across the country in every industry and sector. As the lead plaintiff in the historic challenge to the Affordable Care Act, NFIB versus Sebelius, NFIB understands firsthand the importance one justice can have on the ability of small businesses to own, operate, and grow their business. After reviewing Judge Gorsuch's articles, decisions, and public statements, we are pleased to see a judge who both applies the actual text of the law and the original meaning of that text at the time it became law, rather than changing it to fit his personal views and preferences. Specifically, small businesses are encouraged by three qualities Judge Gorsuch has brought to the bench. His opinions are clear and often provide bright-line rules. He has a deep respect for the separation of powers, and he has shown a willingness to tackle the difficult legal issues of our day head-on. Judge Gorsuch is not known for using ambiguous or broad language that fails to settle the question before him. Rather, his decisions provide meaningful direction for district court judges, as well as businesses and ordinary individuals who may be affected by that law moving forward. Like their larger counterparts, small business owners want and need certainty. They need bright-line, easy-to-understand legal standards. If small businesses don't know what is expected of them, what the rules of the game are, they may be hesitant to undertake actions that otherwise would help their business grow. Judge Gorsuch takes seriously his obligation to provide that clarity whenever possible. Judge Gorsuch also has demonstrated that he truly respects and seeks to protect the separation of powers among the branches of government. This is important because NFIB is concerned about what we see as the rising tide of regulation promulgated by unelected bureaucrats. This trend over the last 30 years contravenes the fundamental principle that only Congress, as the elected and politically accountable legislative branch, should be able to enact and change statutory law. When it comes to regulations, small businesses bear a disproportionate amount of the regulatory burden as compared to their larger counterparts. That is not surprising since it's the small business owner, not one of a team of compliance officers, who is charged with understanding new regulations, filling out required paperwork, and ensuring the business is in full compliance with new and ever-changing federal mandates. The uncertainty caused by future regulation negatively affects a small business owner's ability to plan for future growth. For small business, the problem of overregulation has been further exacerbated by the broad deference federal courts give to executive agencies in their interpretations of statutes passed by Congress. This judicial deference to executive agencies, known as Chevron deference, has led to a breakdown in our constitutional system of checks and balances. Therefore, NFIB welcomed Judge Gorsuch's concurring opinion last year in Gutierrez, encouraging the Supreme Court to revisit the Chevron doctrine. In my written testimony, I referenced 3 cases where the Chevron doctrine has caused serious harm to small business. For example, in City of Arlington versus the FCC, the Supreme Court invoked Chevron to find that courts must defer to an agency's interpretation of its own statutory authority. By extending Chevron deference to agency determinations of its own jurisdiction, the court set a dangerous precedent that encourages agency aggrandizement of regulatory authority with minimal judicial oversight. By abdicating its responsibility to determine the scope of the agency's statutory authority, the court signaled that agencies may intrude into the affairs of states and businesses with impunity, as long as their actions are justified as reasonable to the slightest degree. Our constitutional system of governing and our separation of powers doctrine play a large role in empowering the vitality of small businesses in the United States. When the system erodes or functions less perfectly, there is an adverse impact on small business and our nation's economy. Small businesses, like every American, have an important stake in who fills Justice Antonin Scalia's seat. NFIB is pleased to support the nomination of Judge Neil Gorsuch to the U.S. Supreme Court. Thank you.
Thank you very much. Our next witness is the former Deputy Assistant Attorney General for Civil Rights, who has specialized in disability rights. We're delighted to hear her testimony. Ms. Hill.
Thank you very much for inviting me to speak today. I'm an attorney with more than 20 years' experience implementing the laws protecting the rights of people with disabilities. I have serious concerns about Judge Gorsuch's approach to and acceptance of America's disability civil rights laws and the basic principles of disability rights. People with disabilities have long experienced what former President and then candidate George W. Bush called the soft bigotry of low expectations. Unfortunately, Judge Gorsuch bakes these very low expectations into his disability rights jurisprudence, in spite of Congress's bipartisan attempts to dismantle such prejudices through federal disability rights laws. Judge Gorsuch's decisions on the education of our children with disabilities are troubling, not just for their devastating human consequences, but also for their dismissiveness of the law as established by Congress. The Individuals with Disabilities Act, Education Act, or IDEA, requires public schools to ensure a free, appropriate public education for each student with a disability. In the Luke P. case that you heard about earlier, Judge Gorsuch read the IDEA to require only an education that is merely more than de minimis. That concept appears nowhere in the statutory text of the IDEA or in Supreme Court precedent. Judge Gorsuch adopted this standard in spite of Supreme Court precedent requiring educational benefits to be meaningful, in spite of statutory text requiring appropriate educational programs, and in spite of Congress's repeated updates to the IDEA explicitly calling for high educational standards for children with disabilities. Yet in Luke P., George Gorsuch substituted his own opinion for that of 3 decision-makers who had found that Luke's school did not provide an appropriate or meaningful educational benefit. Nor did 10th Circuit precedent require the merely standard. For a judge that claims fidelity to the principles of judicial conservatism, a decision to overrule the findings of 3 lower courts in a way that ignores statutory text and congressional intent is deeply troubling. Luke's records showed that he was failing in over 75% of the goals in his plan. Few parents in this country would find a 25% success rate to be appropriate or meaningful for their child with or without a disability. Yet Judge Gorsuch found that 25% success was a passing grade for Luke's school. Notably, a little over a year after the change in his placement, as you've heard this morning, Luke made significant progress in the goals that his prior school had failed in. It was Judge Gorsuch's expectations, not Luke's capabilities, that were de minimis in this case. Just yesterday, the Supreme Court explicitly and unanimously rejected Judge Gorsuch's merely more than de minimis standard. The court found Judge Gorsuch's standard mischaracterized the intent and language of both Congress and Supreme Court precedent. The court found in requiring an appropriate public education, Congress meant what it said. The court stated, when all is said and done, a student offered an educational program providing merely more than de minimis progress from year to year can hardly be said to have been offered an education at all. Unfortunately, it is likely too late for many of the children with disabilities in Colorado, Kansas, New Mexico, Oklahoma, Utah, and Wyoming who have been subjected to the soft bigotry of de minimis expectations for nearly 10 years. Judge Gorsuch's other IDEA opinions have shifted standards of review and created legal minefields of administrative processes to undermine the education rights of students with disabilities. And Judge Gorsuch's opinions on the rights of adults with disabilities also reflect, rather than challenge, the stereotypes that Congress enacted in federal disability rights law, rejected in disability rights law. Congress passed the Americans with Disabilities Act, or ADA, to open doors to the workplace for people with disabilities. But Judge Gorsuch, in 2010, held that an employee with multiple sclerosis did not have a disability because she was able to work. He made this holding in spite of both the ADA and the ADA Amendments Act of 2008, where Congress made clear that the ADA provides and has always provided protection to people with MS, and that disability is not defined, catch-22-like, as an inability to work. Federal disability laws are intended to address not just blatant discriminatory treatment of people with disabilities, but the ways the employment processes, benefits, and buildings have been designed in ways that inherently exclude people with disabilities. This is the basis for the central ADA requirement of reasonable accommodation. In the case of Wang versus Kansas State University, a professor requested a slight extension of her leave time to return to work when her Kansas experienced an H1N1 outbreak that could have risked her life. The university routinely allowed one-year sabbaticals for other professors, but Judge Gorsuch insisted that Professor Wang could only extend her leave if she was already entitled to such a sabbatical. The ADA asked not just whether an employee with a disability was offered what she was contractually entitled to, but also whether something more, a reasonable accommodation, is available. Judge Gorsuch ignored that test. Instead, he suggested that Congress was wrong to require leave as an accommodation at all, and that leave of over 6 months was inherently unreasonable, no matter what other employees were given. You may believe that a judge's role is to protect the dignity of all people, and especially those of disempowered minority groups, or you may simply believe that a judge's role is to remain faithful to the clear intent of Congress as expressed in statutes. Either way, Judge Gorsuch's opinions in disability rights issues do not meet that standard.
Thank you, Ms. Hill. Senator Hatch, do you have questions?
Yes, Professor Turley. I'm sorry. Professor Turley?
Yes, sir.
You've observed and written about the confirmation process for a long time. Some of my Democratic friends have been saying that the only way to find out what they need to know about Judge Gorsuch is to demand what Justice Ginsburg once called hints, forecasts, and previews about his future votes or opinions in cases that will come before the Supreme Court. Now, your testimony is very different. In your written statement, you insist that, quote, we have a very good idea of who Judge Gorsuch is and the type of justice he will be, unquote. Now, do you agree with me that results-oriented litmus tests based on specific issues are not the best standard for evaluating the fitness of a Supreme Court nominee?
Absolutely. And when I refer to knowing what type of judge this man is, I was referring to the fact that he has a well-known jurisprudence. He has a well-known view of the Constitution. He shares that distinction as a nominee with the man he would replace. And that's one of the reasons I believe he will have a lasting legacy. The reason that Justice Scalia has such a lasting legacy is that he's a rarity. He actually changed the court more than it had changed him because he came to the court with a clear understanding of his jurisprudence. Now, when I look at Judge Gorsuch, I see someone that, quite frankly, is going to follow his conscience. He's not going to be very predictable. I don't think he'll be robotic. I think that view, his jurisprudential view, will take him to the left and the right of the spectrum. What we do know is he's a textualist. That should come as no surprise, and I don't think that's a vice. But what his opinions also show is someone with an intense intellectual curiosity and also an intense independence. I could think of no better possible nominee than that. I don't want a blind date. I don't want someone who we know nothing about. What we have in Judge Gorsuch is someone who wasn't just a pedestrian, not participating in these important debates. He got involved, and I respect that. And I don't think we should penalize someone for being active in debating these issues.
That's a good point. The suggestion's been made in this hearing that concern about the Chevron doctrine, which requires deference to executive branch agency interpretations of the law, is just another way of opposing regulation in general. One Democratic senator even said that without Chevron, agencies will not have the authority to address problems at all. Do you agree with that characterization?
No, I don't. I share Judge Gorsuch's view on Chevron. We come from two different places, I think, probably politically. But I think how you view Chevron depends a lot on whether you view it from a constitutional standpoint or from an administrative law standpoint. I think I share Judge Gorsuch's view, or looking at it through the lens of a constitutional standpoint. Chevron is troubling because it does tend to usurp a traditional role of the courts. It also tends to usurp a role of this body. And I also don't think that the suggestion that if Chevron was set aside, that all of Rome would burn. I think that Judge Gorsuch made a very good point when he says, what do people think? In one of his opinions, he says, what do people think is going to happen if we don't have Chevron? What's going to happen is we'll be in the same position we were before Chevron, which wasn't a bad position. You had the Skidmore case, where Justice Jackson, someone that Judge Gorsuch really respects a great deal, said, look, we have to respect agency opinions. We have to give them great weight. The APA itself, I believe in Section 706, says that you have to defer to that. So there's not a cliff here that people are talking about. What it does by moving away from Chevron, I think, is to get the courts more heavily involved in the review of agency decision-making, and also to give more authority back to this body where I believe it should rest.
Great. I agree with you. Ms. Harmon, we often speak about the impact of court decisions on the parties in to a specific case and beyond. Now, I really appreciate your I really appreciated your response in this area and your comments because I think they provide an important perspective on this issue. And I'm sure you know from observing this process, my Democratic colleagues focus only on which party wins or loses or which narrow political interest is advanced by the decision in an individual case. Now, you seem to have a very different take. Your testimony emphasizes more broadly that clarity about the law and adherence to basic principles such as separation of powers have the most important impact. Now, that's why you have such a high praise for Judge Gorsuch's approach, not only to making decisions, but on writing the opinions that explain those decisions as well. Now, my view is that the law, not the judge, should determine the outcome of individual cases and the broader impact of those decisions. Do you agree with that? Well, that was a nice, quick answer.
Discussion, oh, sorry, a good discussion with Senator Tillis about this as well, which is the separation of powers is important because coming here before you is where my members, small business owners, are going to have the greatest impact. You are in the light of day with a true public discourse about what the law should be. They're not going to be in every courtroom in the country. They're not going to be in every agency walking the halls. And they need to know that once you all enact a law, the regulation is issued that is appropriately within that statutory framework. It's a law they can rely on because that certainty is the only way for them to be able to do business. Certainty is a critical component of small business owners' abilities to operate their business.
Thank you.
Thank you.
Senator Whitehouse.
Thank you, Chairman. May I ask unanimous consent? We have Ms. McGee here from Demos. May I ask unanimous consent that Demos's 2017 report titled Election Money Resulting Directly from Supreme Court Rulings, as well as a March 13, 2000 letter from 109 House members to Chairman Grassley and Ranking Member Feinstein, urging this committee to question Judge Gorsuch about money in politics, and a 2017 Demos report titled Money in Politics, Racial Equity, and the U.S. Supreme Court, and fourth and finally a 2015 Demos report titled Breaking the Vicious Cycle, Rescuing Our Democracy and Our Economy by Transforming the Supreme Court's Flawed Approach to Money in Politics, all be entered into the record.
Without objection.
Thank you very much. Ms. McGee, welcome. I appreciate that you are here and the work that Demos has done to shed some light on the problem of money in politics and the influence that it gives special interest groups. We have kind of an unusual circumstance here in that President Trump originally outsourced the creation of the list from which Judge Gorsuch was selected to a pair of well-known right-wing interest groups. And then the notification to Judge Gorsuch that he describes in his description of the selection process, the opening sentence is on or about December 2nd, 2016, I was contacted by Leonard Leo, who is the head of one of those same special interest groups. Then it's been reported in the news that the White House outsourced the political campaign on behalf of Judge Gorsuch to those interest groups. And indeed, we have seen reports of a $10 million political campaign to try to influence the Senate in Judge Gorsuch's favor through a front group. So we don't know who the real donors are. It's dark money that is behind that entire operation. And it was the same front group that spent a nearly equivalent amount of money trying to disrupt the nomination of Judge Merrick Garland. And finally, we have the Colorado reporting on Judge Gorsuch's friend and appears as patron in the quest for the 10th Circuit seat, Mr. Philip Anschutz, who is a billionaire who is also a very big political spender. And all of that, I think, causes concern to some of us that although the talk may be about Olympian detachment, the actual operation of getting Judge Gorsuch before us has been special interest, dark money politics. And I'd like to ask you to react to that.
Thank you, Senator Whitehouse. I think you're right to express concern about this, the same way that the American people, including 91% of President Trump's own voters, have expressed concern about the role of the Supreme Court in expanding our current big money system. Judge Gorsuch had the opportunity over the past couple of days to distance himself from the entire problem of Citizens United, either spoken of expansively in terms of the influence of the wealthy millionaires and billionaires and special interests in our politics, to even some of the more narrow concerns. I was particularly concerned in your exchange, Senator Whitehouse, with the judge when you gave him an opportunity to talk about something that is his potential predecessor's, one of his great North Stars, which is the importance of disclosure in our campaign finance system. And instead of saying clearly that there is a public interest in knowing who is spending millions of dollars to buy influence with our politicians, he was quite evasive. And in fact, to my dismay, raised the idea that disclosure chills speech, and even suggested that the $650 million in secret money from society's most powerful, which is what we've seen since Citizens United, would be on the same level as the brave civil rights leaders in the NAACP case, people who endured violence, bombings, and shootings for their political activism. And if you don't mind, I just want to read just one sentence from what Senator Scalia said in Justice Scalia said in Doe v. Reed about the importance of disclosure, which gives us a sense that he might even be parting with Scalia on this important piece. There are laws against threats and intimidation and harsh criticism, short of unlawful action, is a price our people have traditionally been willing to pay for self-governance. Requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed.
My time has expired, Chairman. Thank you very much. Thank you, Ms. McGee.
Thank you, Senator.
Thank you. Thanks to Senator Whitehouse and you for filling in when I had to go vote. Professor Solum, while many try to argue that originalism is inherently conservative, others have pointed out that originalism has been ascribed to by liberal judges and academics as well. Professor Cass Sunstein had, at Harvard Law School, for example, once described the late Justice Hugo Black as a liberal originalist. Would you agree that originalism is not by itself ideologically or political in nature?
Yes, I would, Chairman Grassley. And if I might just give an example or two, it's absolutely true that much of the interest in originalism at the beginning was generated by critics of Warren Court decisions, and originalism has been associated with conservatives to some extent. But originalism is the idea that we're going to enforce the original meaning of the United States Constitution. And the United States Constitution has implications that both conservatives and progressives, both Democrats and Republicans, can welcome. Let me give an example that relates to the question we've just been discussing, the rights of corporations. Justice Thomas, in his opinion, in the McDonald case, says that incorporation of the Bill of Rights can only be justified under the Privileges or Immunities Clause of the United States Constitution. The Privileges or Immunities Clause is different than the Equal Protection Clause or the Due Process Clause. Those clauses guarantee rights to all persons. The Privileges or Immunities Clause guarantees rights only to citizens, and corporations are not citizens. Now, this is not a result that corporations will welcome at the state level, where the 14th Amendment applies, but it is an implication of the original public meaning of the Constitution.
Okay. Thank you. Mr. Lampkin, you worked with the judge when he was in private practice at Kellogg Huber and you said you support his nomination to the Supreme Court. Do you think his experience as a trial lawyer would be relevant to his work on the Supreme Court?
Yes, I think it's highly relevant. As somebody who was a trial lawyer for many years, the judge has, from what I see it, great respect for the record, great respect for the factual development, whether that record is one that's developed by this body in support of the statutes that it enacts, or it's a record created by the parties at trial. And I think when you are a trial lawyer and you're involved in those, you've developed that type of great respect that's critically important to really understanding what's going on in the cases, to understanding not merely what the abstract principles of law are, but how they're affecting people, and then how the process plays out in the trial courts. I think practical experience as a trial lawyer is something that is not as common among our Supreme Court justices now as it should be, and I think that's a good perspective he would bring to bear.
Okay. Ms. Harned, my last question. We've heard a lot during these hearings about the rule of law. We've heard in particular about how it's the role of judges to enforce laws as they've been written by the Congress. Can you explain why it's important to your clientele, small business men and women, for judges to interpret statutes according to the text?
Right, because small business owners need to know what the rules of the road are, what is expected of them, and not have to worry that because of one judge's decision, a practice that they had been doing that they thought was perfectly legal one day is now unlegal or illegal. And so that is why small business owners are so committed to the way that the separation of powers works, where legislators legislate and judges tell us what the law is, and that is why we have so much respect for Judge Gorsuch's work.
Okay. Thank you. I yield back my time.
Senator Coons. Thank you, Senator Flake. Ms. Hill, if I might, earlier today we heard testimony, compelling testimony from Jeff Perkins about his son Luke and about the consequences for Luke and his family of Judge Gorsuch's perspective in his opinion in the 10th Circuit. And then pointedly, the Supreme Court disagreed with Judge Gorsuch's reasoning. I believe the goal of laws passed by Congress like the ADA and the IDEA is access, opportunity, and participation, not isolation and segregation. I'd be interested, Ms. Mill, both Judge Gorsuch yesterday and Judge Tacha today insisted that Judge Gorsuch was bound by precedent, both Circuit and Supreme Court, to set the standard under the IDA as merely more than de minimis. Are they right?
I don't believe so. Of course, the Supreme Court yesterday indicated that it was not correct to approach Rowley or interpret Rowley as meaning that the standard was merely more than de minimis. Rather, the standard was for meaningful and appropriate education, just as Congress had said that it was. In addition, I looked more closely at the Urban case. That was the case that Judge Gorsuch cited for the de minimis standard, which, by the way, still did not use the word merely. In Urban, there was no dispute about whether sufficient services had been provided for this child. There was a dispute about whether a procedural requirement of the IDEA had been followed, and whether that failure to follow the procedural requirement had created a substantive violation. To the extent that there was no argument over whether the free appropriate public education had been provided, any argument about what the standard for free appropriate public accommodation was is largely dicta.
Thank you, Ms. Hill. Mr. Gallagher, if I might, in a 2013 case, I think it's New Mexico off-highway vehicle versus U.S. Forest Service, the Sierra Club attempted to intervene in a case attacking this Forest Service rule, and the court allowed you to participate. Judge Gorsuch dissented and wouldn't have allowed Sierra Club participation in the case, even though none of the litigants opposed your participation. In another case in 2011, Judge Gorsuch voted to block another environmental group from litigating to assert its interest. Why do you think it's important that interest groups like the Sierra Club be allowed to participate, and how do you think Judge Gorsuch's position would affect advocates' ability to be engaged on litigation around the environment?
Thank you, Senator. Right now, when President Trump and his advisor Steve Bannon are threatening to dismantle the EPA, and when we have a new administrator of the EPA, Scott Pruitt, who essentially eviscerated environmental enforcement while the Attorney General of Oklahoma, it's critical that citizens be able to enforce environmental laws. This body legislated citizens' rights to enforce environmental laws. There are citizen suit provisions in all of the major environmental laws. If we can't get access to court, and Mr. Trump and Mr. Pruitt are not going to protect our drinking water, who are we going to call?
Thank you, Mr. Gallagher. Ms. Graves, in Strickland versus UPS, Judge Gorsuch's 10th Circuit colleagues found that a woman had shown enough evidence of discrimination based on sex to have a jury rule on her case. The woman had multiple coworkers testify she was treated worse than her male coworkers. Though the law required the court to look at the evidence in the light most favorable to the woman, Judge Gorsuch, again, dissented. Can you tell us more about this case and what it says about Judge Gorsuch's approach to deciding these opinions?
Sure. Thank you, Senator Coons. I think that the Strickland case is a good example here of the concern that we have when Judge Gorsuch says he just applies law to facts. Because here, the real issue was that there were a lot of facts, and these facts were disputed, in fact. And when facts are disputed, the thing to do is have the jury decide, have the jury determine and resolve the facts. Here, despite a lot of evidence that she should have been able to continue her claim, Judge Gorsuch said, no, that's not enough. And so in that case, that's an example of, yes, he was applying the law to the facts, but the jury itself is the one who's supposed to resolve the facts.
Thank you, Ms. Graves. Thank you, Mr. Chairman.
Thank you. Senator Kennedy.
Thank you, Mr. Chairman. Ms. McGee, is it McGee or McGee?
McGee, that's
McGee.
Thank you.
Tell me, I listened to your testimony about your criticism of Judge Gorsuch and Citizens United. Tell me what your complaint is with respect to Judge Gorsuch and Citizens United, just briefly.
Sure, absolutely. First of all, we believe that based on his record in two cases, Hobby Lobby and Riddle v. Hickenlooper, that you have a recipe for striking down some of our last remaining protections against big money. He went out of his way in Hickenlooper.
I don't mean to interrupt you, but I only got 5 minutes.
Okay.
I understand now. Do you really expect a nominee for the United States Supreme Court, whether he or she is nominated by a Democratic president or a Republican president, to come before the United States Judiciary Committee and talk about what's good policy or bad policy?
Fortunately, he doesn't have to get into policy to just talk about enduring democratic principles. And I also think that the Heritage Foundation, the number of right-wing organizations that are anti-campaign finance reform that have backed his nomination for the court would be surprised to learn that he was at all ambiguous about Citizens United, which is one of the most important court cases in recent memory, and where all of the principles around grandly interpreting the First Amendment to give and protect the rights of millionaires and billionaires to spend unlimited amounts was just a continuation of a set of ideological jurisprudence that I would be surprised to hear him part from, and he didn't when he had the opportunity.
I understand how you feel about Citizens United, but I want to understand your criticism of Judge Gorsuch as a nominee for the United States Supreme Court. You're criticizing Judge Gorsuch for not coming before this body and offering a policy preference in terms of campaign finance in elections in America?
I'm not criticizing the judge. I am saying that he had an opportunity to say basic principles about our democracy and upholding an interpretation of the First Amendment that would protect a vision of one person, one vote. He was asked multiple times about many different issues concerning campaign finance reform, including cases where he went out of his way to write concurrences on majority opinions that put into doubt his opinions in future cases about issues such as the scrutiny level for campaign contributions, which is, to date, we believe a matter of settled law, and the very possibility of moving into corporations giving direct contributions to candidates based on his concurrence in Hobby Lobby.
And you would prefer to have a nominee who agrees with you on those policy issues?
I would prefer to have a nominee who was open to considering the facts. And we have seen that since Citizens United, the facts have shown that some of the basic premises, the idea that independent spending is actually independent and can't corrupt, the idea that disclosure is real, have been proven false.
All right, I'm going to put you down as doubtful on Citizens United. Okay.
Thank you, Senator.
Ms. Hill, how do you think judges ought to decide cases? Could you turn your mic on for me?
I keep doing it. I think judges should decide the cases based on the law as expressed by Congress, interpreted by the agencies, and applied to the facts in front of them.
What if the agencies got it wrong?
If the agencies got it wrong, there are administrative procedures processes through which to go through to challenge those incorrections.
Okay. Do you think that a party's wealth or status or power should have any effect whatsoever on the outcome of a case?
No, I do not.
Okay. Thank you, Mr. Chairman. I yield back my time.
Thank you. Before going to the next panel, let me just ask a couple of questions. Mrs. Harned, tell me, your organization promotes small business, obviously, and regulation has a little to do with the success or failure of small business. What have you seen over the years with regard to decisions by the Supreme Court or other courts that has impacted the ability of small business to succeed?
Right. Well, that has been really over the last several decades. We continue to see an increasing regulatory state, and in large part, that is because of agency deference that courts are giving to agencies, the Chevron doctrine. And we have seen this firsthand with a number of cases in which we've gotten involved. I have several referenced in my testimony where, because of that agency deference, small business owners, the interpretation of the regulation by the agency governs, and as a result, a small business owner is sued and out millions of dollars in one case, the Knack versus Wahlberg case that I talk about here. But more importantly and more broadly on the regulatory state, generally, small business owners do bear the disproportionate burden of regulation on their business as compared to the larger counterparts. It's been a primary concern, the reason they have not been able to grow over the past 9 years. And so we are, that is why we are so committed and so encouraged to see that Judge Gorsuch recognizes, as he said in his testimony, raised his hand to the Supreme Court and said, look, Chevron deference, this may be a time where we need to revisit that, because we do think it is responsible for increasing the regulatory state in this country.
Right. Thank you. Mr. Turley, I'd like your thoughts kind of on that similar theme. With Chevron deference, certainly Judge Gorsuch has expressed some skepticism about it, to put it mildly, I hope. But with regard to technology, which is an increasing percentage or share of our economy, what we've seen over the past several years is you have one administration whose agencies will regulate in a certain way. The new administration comes in with maybe a completely different idea. We just dealt with a Congressional Review Act on certain tech regulations, internet regulations, just a few minutes ago on the floor. And then the next administration might come in with something completely different. One thing that small business and large business, any business, cannot stand is uncertainty moving ahead. Is with Chevron deference, looking back for the Congress to have maybe a more balanced or more predictable application of statutes which will govern regulation, is that a better way? What do you say?
I do think it's a better way to move beyond Chevron. I've been a critic of Chevron for many years. I'm a particular critic of Brand X, which is the subject of one of these opinions. I thought the judge was right on that one. He raised this issue. A lot of people don't realize that Brand X says that an agency can essentially negate the legal interpretation of a federal court. And he appropriately said, I thought that courts interpret the law after Marbury versus Madison. But that's how Chevron works. It's sort of the Marbury of the administrative state, saying that they can be the final word. And I think what you're seeing in our system is a dangerous shift of the center of gravity. This is a system, a tripartite system, that was designed to have three branches held together sort of by inverse pressure in a fixed orbit that Madison set. And we have this rising fourth branch of administrative agencies. I happen to identify with many people in those bureaucracies because they're dweebs like me. You know, they have advanced degrees, they're sort of wonky. But the fact is that we have a fourth branch that I think is a dangerous change in our system, one that we're not having a debate over. And Chevron has fueled that change. If we didn't have Chevron, we would largely go back to the conditions of cases like Skidmore, where the courts gave a lot of deference, even without Chevron. You have the APA, which requires deference to agencies. But what it would do is allow judges to rule on what the law means. I also know, by the way, that apropos of your question, Chevron was actually a case that was a victory for Judge Gorsuch's mother, and this was actually a victory of Republicans that were trying to reverse measures that were put into place by a previous Democratic administration and used administrative authority to do that. So I would caution those that have suggested that this is going to be an apocalyptic moment. What it would do if we went beyond Chevron is return us to a position closer to the design of our government.
Well, thank you. My time is up, and I believe time for the panel. We'll go on to the next panel. Thank you for your service. And we'll call the next panel. If they want to set the nameplates, it will consist of Ms. Clark, Ms. Kirsanow, Ms. Warbelow, Ms. Fisher, Ms. Miller, Ms. Smith, Professor Marshall, Professor Meyer, Ms. Phillips, and Professor Jaffer. If you'll please stand and raise your right arm. Do you swear that the testimony that you are about to give before the committee will be the truth, the whole truth, and nothing but the truth? So help you God. Thank you. Thank you. Please be seated. Kristen Clark is the President and CEO of the Lawyers Committee for Civil Rights Under Law. Peter Kirsanow is a partner with the firm Benich Labor Employment Practice Group and is serving his third term on the U.S. Commission for Human Rights, or for Civil Rights, I'm sorry. Sarah Warbelow is the legal director for the Human Rights Campaign. Alice Fisher is a partner in Latham and Watkins, Washington, D.C. office, and is a member of the firm's executive committee. From 2005 to 2008, she served as Assistant Attorney General in charge of the Criminal Division at the Department of Justice. Amy Miller is the President and CEO and founder of Whole Women's Health. Sarah Smith is a senior counsel at Beckett. She clerked for then Judge Alito on the Third Circuit Court of Appeals, for Justice Clarence Thomas, and then for Justice Alito on the Supreme Court. Professor William Marshall is the William Rand Keenan Jr. Distinguished Professor of Law at the University of North Carolina. Tim Meyer is the former law clerk for Judge Gorsuch from 2007 to 2008. He's now Professor of Law and Enterprise Scholar at Vanderbilt Law School. Sandy Phillips is the mother of Jessica Guani, who was, thank you, Gowie, got it. Thank you, who was tragically killed in the 2012 shooting at the Aurora, Colorado movie theater. Jamil Jaffer is a former law clerk for Judge Gorsuch from 2006 to 2007. He currently serves as adjunct professor, National Security Institute founder, and director of the Homeland Security Law Program at the Antonin Scalia Law School at George Mason University. I welcome you all to the committee. Look forward to hearing your testimony. This will be 5 minutes each, if you can summarize that way. We'll proceed after that with 5-minute rounds. But let's go ahead, Ms. Clark.
I want to thank the distinguished members of this committee for the opportunity to testify today on behalf of the Lawyers Committee for Civil Rights Under Law. We are one of the nation's historic, nonpartisan civil rights organizations with the unique mission of mobilizing lawyers across the country to provide critical pro bono support to advance our work. The Supreme Court occupies a central place in American democracy, and for African Americans and other minorities, the court has been a crucial forum for seeking equal justice under law. Historically, minority groups have looked to the court to vindicate their constitutional and civil rights. We have reviewed the civil rights record of Judge Neil Gorsuch as we have done for all Supreme Court nominees for the last several decades. We do not believe that the record is sufficient to conclude that he meets our standard, which requires demonstration of a profound respect for the importance of protecting civil rights afforded by the Constitution and the nation's civil rights laws. Judge Gorsuch's views reflect a very narrow definition of what constitutes a civil right, and he has deep skepticism about the importance of protecting those rights in the courtroom. Our concerns are especially pronounced with respect to the question of whether he will fairly interpret and apply one of our nation's most important civil rights laws, the Voting Rights Act. In 2013, the Supreme Court issued a decision that gutted the act in Shelby County, Alabama v. Holder. At issue in Shelby County were the Section 5 preclearance provision of the act that helped identify and successfully block hundreds of unconstitutional and discriminatory voting changes, and the Section 4 provision that determined where the law applied. A closely divided court ruled that Section 4 was unconstitutional, a decision which eviscerated the heart of the Voting Rights Act. Witnesses have drawn parallels between Judge Gorsuch and the late Justice Scalia. During oral argument in Shelby County, Justice Scalia referred to Congress's renewal of the Voting Rights Act as the, quote, perpetuation of racial entitlement. That was a startling perspective on a law that has ensured that millions of American citizens have not, merely because of the color of their skin, been unlawfully deprived of the most sacred right in our democracy. What is most troubling about the court's decision in Shelby County is that the carefully considered judgment of Congress was set aside. In 2006, the Senate voted to renew Section 5 by a vote of 98-0 after documenting overwhelming evidence of ongoing discrimination against minority voters. It is unclear whether Judge Gorsuch appreciates Congress's broad enforcement powers under the 14th and 15th Amendments, and unclear whether he brings awareness of the widespread voting discrimination and voter suppression that we continue to face today. The right to vote is too important. We must understand whether Judge Gorsuch is committed to fairly interpreting and preserving what remains of the Voting Rights Act. Equally important are questions concerning Judge Gorsuch's tenure at the U.S. Department of Justice between 2005 and 2006, when he occupied the role of Principal Deputy Associate Attorney General. As a career attorney at the Civil Rights Division of the Justice Department during that time, I am personally aware of issues that led to the politicization of the agency's civil rights work. Those views were substantiated in a July 2008 Inspector General's report, which found that politicization of the Civil Rights Division's hiring practices and its work violated federal law and Justice Department policy. We must not turn a blind eye to the fact that Judge Gorsuch had some responsibility for overseeing the division during this time. The materials provided by Judge Gorsuch, together with his Senate questionnaire, do not clarify or elucidate the extent of his involvement in the significant problems that tarnished the work and integrity of the Civil Rights Division at this time. I urge the Senate to seek answers to these important questions. Before I conclude, I want to say a brief word about Judge Gorsuch's record on criminal justice issues. Criminal justice concerns remain at the forefront for many African American, Latino, and minority communities. Our review shows that he takes an unusually narrow view of the constitutional rights of defendants, particularly under the Fourth Amendment. Judge Gorsuch has also shown extreme deference to police officers in excessive force decisions. In closing, I must observe that this nomination arises at a tumultuous moment in our nation's history. We have seen intensifying efforts to restrict the rights of minority voters, unconstitutional policing practices, rising xenophobia, religious intolerance, and other circumstances that make clear the fragile state of our democracy. Our nation deserves a Supreme Court justice who will interpret the Constitution and civil rights laws in a way that recognizes that discrimination is both ongoing and a threat to democracy, and who is committed to ensuring equal justice under law for all Americans. Based on the record to date, I am not able to support the nomination of Judge Gorsuch to the Supreme Court today. I respectfully request that the Lawyers Committee for Civil Rights Under Law's report on the nomination of Judge Gorsuch and accompanying letter signed by more than 100 of our board members expressing concern regarding the nomination be entered into the record.
Without objection.
Thank you.
Thank you, Ms. Clark. Mr. Kirsanow.
Thank you, Mr. Chairman, members of the committee. I'm Peter Kirsanow, member of the U.S. Commission on Civil Rights and a partner of the Labor Employment Practice Group of Benesch Friedlander. I speak as one member of the Commission on Civil Rights, not necessarily on behalf of the Commission as a whole. The U.S. Commission on Civil Rights was established pursuant to the 1957 Civil Rights Act to, among other things, act as a national clearinghouse for information related to discrimination and denials of equal protection, and in furtherance of that clearinghouse function, and with the help of my assistant, I've reviewed the nearly 200 cases related to civil rights that Judge Gorsuch had authored or participated in at the 10th Circuit. These opinions relate to, among other things, Title VII, ADA, ADEA, IDEA, Equal Protection Clause, and a host of other provisions related to civil rights. And our examination reveals that Judge Gorsuch's approach to civil rights cases is consistent with generally accepted textual interpretation of the relevant statutory and constitutional provisions, as well as governing precedent. His opinions are squarely within the judicial mainstream when it comes to civil rights. Of the opinions we examined related to civil rights that Judge Gorsuch participated in, he was in the minority in only 5% of those cases. In 43 cases, he was on a 3-judge panel in which the 2 other panel members were appointed by presidents of the Democratic Party, and in 94% of those cases, he joined the majority opinion or concurred in the result. A useful example of Judge Gorsuch's mainstream textualism, mindful of the limits of the judiciary and the prerogatives of the legislature is his dissent in Trans Am Trucking versus Administrative Review Board, where a majority of the panel found that a statutory provision that provided that an employer may not discharge an employee who refuses to operate a vehicle where that employee has a reasonable apprehension of serious bodily harm actually meant that the employee may not be discharged if he operates the vehicle contrary to employer instructions. Judge Gorsuch applied the plain text of the statute in a very precise manner and noted that the employee in question had done the opposite of the statutory privilege. That is, he had operated the vehicle, not refused to operate the vehicle. Similarly, Judge Gorsuch's reasoned deference to precedent and his interpretation of the text of the governing statutes yields cases and a record on civil rights that's consistent with prevailing civil rights norms. For example, Carrera versus Tyson Foods. Judge Gorsuch upheld summary judgment against a plaintiff in a hostile environment sexual harassment case where there was no evidence that there was a hostile environment. The evidence proffered was that supervisors were standoffish. That standing alone does not constitute a hostile environment. Moreover, the defendant had immediately discharged the employees who had made provocative gestures and immediately transferred plaintiff upon her request. Similarly, in Gaff versus St. Mary's Regional Medical Center, Judge Gorsuch upheld summary judgment in a retaliation claim where there was no evidence that the hospital had fired the plaintiff for reporting sexually explicit remarks made by a coworker, as opposed to firing plaintiff because the plaintiff had threatened to shoot such coworker. As pertains to religious discrimination cases, Judge Gorsuch's record shows that he takes First Amendment issues soberly and seriously, regardless of whether or not the issue at hand may be trivial to some, may be obscure, or the plaintiff is unsympathetic, or the plaintiff's beliefs may be at odds with prevailing societal norms. An example is Yellow Bear versus Lampert, in which Judge Gorsuch upheld the free exercise rights of an unsympathetic plaintiff who had murdered a little girl, which plaintiff had been denied his right to access a sweat lodge pursuant to his religious beliefs. Judge Gorsuch has also noted that RFRA protections might be available to individuals and families who are given the Hobson's choice of either abiding by their sincerely held religious beliefs or saving their business. In sum, Judge Gorsuch's approach to civil rights cases is consistent with the norms in this jurisprudence. His record shows that he's a careful and exacting judge who has great respect for the constitutional order, the rule of law, the role of Congress, and the corresponding limits on judicial authority. He is consistent with mainstream textual interpretation of the governing statutes, and in addition to that, all of his record shows that he will faithfully and carefully apply the law to protect the civil rights of all Americans. Thank you, Mr. Chairman.
Thank you, Mr. Kirsanow. If you're wondering where my colleagues are, there's a vote going on right now. Chairman Grassley will be back in a minute, and I'll go and vote, but I assume some other members will come in as well. Ms. Warbelow.
Thank you. On behalf of the Human Rights Campaign, the nation's largest civil rights advocacy organization for lesbian, gay, bisexual, transgender, and queer people, I'm honored to be here before you today, representing our nearly 2 million members and supporters nationwide. Unfortunately, I'm disappointed that the topic for discussion is President Trump's nominee to the Supreme Court, Mr. Neil Gorsuch. LGBTQ people are no strangers to the Supreme Court. We understand the power of the court to affirm or deny our most basic rights. Jim Obergefell and his partner John Arthur had to be medevaced to a tarmac in Maryland in order to marry before John died from ALS because their home state of Ohio refused to allow them a marriage license. Their heartbreak didn't end on that Maryland tarmac. The state of Ohio attempted to erase their marriage by refusing to place Jim's name as a surviving spouse on John's death certificate. By a narrow 5-4 ruling, the Supreme Court validated Jim and John's relationship and extended marriage equality nationwide. By his own words, Judge Gorsuch admitted he would have forced same-sex couples to pay the price of inequality for decades to come. This is why Judge Gorsuch cannot be given a lifetime appointment to the Supreme Court. Time and time again, Judge Gorsuch has employed a dangerous brand of originalism that ignores the essential context and values of each case and the lives that they touch. His record and statements place him squarely in the mold of Justice Antonin Scalia, who consistently demeaned and denied the dignity of LGBTQ people from the bench. Judge Gorsuch has directly questioned the court's recognition of the fundamental right to personal autonomy that has served as a keystone for multiple LGBTQ rights cases. Distressingly, Judge Gorsuch accepted a quote from Justice Scalia in its entirety, equating marriage equality to bestiality, and made no effort to distinguish marriage, one of our society's most sacred traditions, from criminal antisocial behavior. Despite records that Judge Gorsuch is personal friends with LGBTQ people, his choice to embrace this line of reasoning reveals a level of indifference to the LGBTQ community that should be disqualifying for an individual to be appointed to the United States Supreme Court. During his time on the bench, Judge Gorsuch ruled against Rebecca Castle, a transgender woman working for a community college. After being rehired for a second term, Rebecca transitioned and began to use the women's restroom. Halfway through the semester, the school informed her she would have to begin using the men's restroom based on safety concerns. Rebecca was terminated because she refused to subject herself to the dangers of using a men's restroom. As Justice Kennedy made clear in Romer versus Evans, false justifications may never be used to cloak bare animus. That's what happened in Rebecca's case. The Supreme Court justices must be able to discern legitimate government interests from clear hostility to vulnerable communities. Judge Gorsuch's other rulings, such as Hobby Lobby, while not directly addressing the LGBTQ community, have been used to blatantly defend discrimination against LGBTQ people. Amy Stevens is one of these people. After working for a for-profit funeral home for nearly 6 years, she informed the owner she would be transitioning when she returned to work and would be dressing consistent with the women's dress code. Ignoring the employee's strong record, the funeral home owner stripped her of her job based on his belief that it's unacceptable to be transgender. In providing the funeral home a pass from complying with Title VII, the judge in this case adopted Justice Gorsuch's views regarding moral culpability, which callously disregards harm to real people. If this reasoning is widely adopted, it will undermine our core civil rights laws, allowing pervasive discrimination not only against the LGBTQ community, but Americans widely. Areas of law that the majority of Americans view as settled, including marriage equality, are being litigated and debated by groups who are emboldened that a justice like Gorsuch will reopen settled law. The Supreme Court will be asked to hear cases such as those that could decide whether a public school counselor from Mississippi can turn away LGBTQ youth in need, whether City of Houston employees may be stripped of their spousal benefits, or whether moms like Marissa and Tara Pavan must both be listed on their daughter's birth certificate. We might not agree with every decision a Supreme Court justice may make, but we must believe that their commitment to reaching impartial judgments based on fact, not political ideology or bias. And they must agree that LGBTQ people have a fundamental rights protected by the Constitution, and that we, as individuals and a community, are entitled to equal treatment under the law. We need a justice who recognizes our basic equality and shared humanity. Judge Gorsuch has never met this bar, and that is why the Human Rights Campaign opposes his nomination to the Supreme Court.
Thank you, Ms. Warbelow. Ms. Fisher, and I'll have to excuse myself to vote, but Ms. Hirono is here. Thank you.
Thank you, Senator Flake. Thank you. Thank you, Senator Hirono. It's an honor to be here today. It's a privilege to be able to testify in support of my friend and former colleague, Judge Neil Gorsuch. It has been a privilege over the years to watch his career unfold. I had the pleasure of meeting him in 1991 when we both had our summer jobs in law school. He was in his 3rd year of law school. I was getting out of my 2nd year in law school, and we worked together as summer associates that summer in 1991. It may make me the longest person that knew him today that's testifying. Of course, I was struck by his brilliance and his keen intellect, but what was more striking was his character and his integrity and his courtesy and his kindness. Every day he would walk into work and he would stop and he would talk to people, everyone in the office, ask them how they were doing, ask them about their lives, about their troubles, and he would spend so much generosity with his time and his consideration for others. It was almost like it was an unlimited reserve of courtesy, kindness, and good humor to boot. I was the beneficiary of this, and I am forever grateful of the time that he took with me early on in my legal career to spend time counseling me, mentoring me, helping me. It was almost if he cared as much about my success as he did about his own, and I was not alone in the way he treated people. I will be forever thankful for his support, and that's just the man that he is. He's been through the years, as you can see, driven by his devotion to his country and his devotion to public service. And he comports himself with deep humility when he comes into public service. And I can remember our conversations about when he was entering public service and how much that meant to him to have the ability to do that. He has a keen intellect, of course, but he holds himself to the highest standard of excellence and his unwavering commitment to the law, and you've heard him talk about that and many others. Of course, he is an adoring husband to Louise and a devoted father and a devoted friend to many. As I have watched Judge Gorsuch, for many years, I find him a man of the highest personal integrity. He has a commitment to fairness and decency that will serve the Supreme Court well, and I am hopeful that he is confirmed. Thank you.
Thank you. Next we have Amy Miller. Ms. Miller.
Thank you. Chairman Grassley, Senator Feinstein, and members of the committee, I'm very honored to speak with you today. My name is Amy Hagstrom Miller. I am the founder and CEO of Whole Woman's Health, a group of women's health clinics that provide comprehensive reproductive services, including abortion care. I am here today on behalf of abortion providers, women's health advocates, and the people we serve all across the country who deserve access to quality health care delivered with dignity and respect. We are gravely concerned about the nomination of Judge Gorsuch to the U.S. Supreme Court. In fact, Whole Woman's Health joined 54 other reproductive health, rights, and justice organizations in a letter to the Senate opposing Judge Gorsuch's nomination. In our clinics, we offer holistic care for women that includes caring for their heart, their mind, and their body. We envision a world where every woman who has decided to end a pregnancy will be respected and where she will have the information she needs and the quality care she deserves. We were the lead plaintiff in last year's landmark Supreme Court case, Whole Woman's Health v. Hellerstedt, and witnessed how decisions made at the High Court directly impact the lives of women. I know what happens when politicians find devious ways to deny women's constitutional rights, and why it is so important to have independent jurists who respect precedent and the rule of law. Roe v. Wade, the 1973 decision that guaranteed the right to abortion and the right to privacy, has been settled law for more than 4 decades and is being reaffirmed repeatedly by the Supreme Court. Nevertheless, that hasn't stopped legislators across the country from putting roadblocks in front of women seeking abortion care. More than 330 have been passed since 2010. Nowhere was the impact of these laws more evident than in the state of Texas, where anti-abortion legislators passed a law in 2013 that forced over half of the state's clinics to shut down. The law forced women to drive hundreds of miles, even across state lines, to access their right to safe and legal abortion. In some cases, the hurdles were so high, women simply took matters into their own hands. I will never forget the woman who called from South Texas right after the law went into effect. We told her our clinic was shuttered, and she now had to drive 250 miles each way to San Antonio. She told us there was no way she could take 2 days off work, find childcare and the money to drive that far. She said, and I quote, "I will tell you what is in my medicine cabinet, and can you please tell me what to use to do my own abortion?" In our country, where abortion has been legal for more than 40 years, no woman should be forced to take matters into her own hands, nor should she fear criminalization or jail time if she does. We need justices on the bench who oppose unnecessary obstacles to our constitutional rights. Neil Gorsuch is not that judge. I also remember the woman who called from West Texas, where every single clinic had been shut down. She was a single working mother with 3 children. We helped her to find a clinic, raise money for her abortion, childcare, transportation, and lost wages. By the time she made it to a Dallas clinic 8 weeks later, it was too late for her to have an abortion in the state of Texas. We need judges on the court who support our constitutional rights no matter our zip codes. Neil Gorsuch is not that judge. Last year, we took Texas to the Supreme Court, and in its ruling, the court called out these and other clinic shutdown laws for what they are: sham laws that create obstacles to care with no medical basis behind them. Women need to know that if their rights are once again on trial, they will be decided by justices who are independent and not beholden to an ideological agenda. Judge Gorsuch has refused to answer basic questions about his stance on Roe, whole woman's health, or the right to privacy. Yet we know in the Utah Planned Parenthood case, he sided with politicians using misinformation and false claims to defund women's health services. And in the Hobby Lobby contraception case, he supported the notion that corporations are people. Judge Gorsuch's positions raise concerns about his ability to be open-minded, fair, and guided by the Constitution, and not his own ideology or personal beliefs. Your decision on this nomination will have profound impact on all your constituents. Everyone loves someone who has had an abortion, and we all want the people we love and treated to be safe and treated with respect, compassion, and dignity. I urge you to keep this in mind as you consider the awesome responsibility of entrusting a lifetime appointment to the United States Supreme Court. Thank you very much.
Thank you. And Senator Hirono, thank you for filling in so we keep it going. Thank you very much. Now, Ms. Smith.
Thank you, Mr. Chairman, Senator Feinstein, and members of the committee. My name is Hannah Smith, and I am senior counsel at Beckett. Our firm is dedicated to protecting religious liberty for people of all faiths. As Judge Gorsuch has said, religious liberty, quote, doesn't just apply to protect popular religious beliefs. It does perhaps its most important work in protecting unpopular religious beliefs, vindicating this nation's long-held aspiration to serve as a refuge of religious tolerance, end quote. To prepare for this hearing, I have reviewed all 40 cases related to religious liberty in which Judge Gorsuch either wrote an opinion or cast a vote. My assessment is that Judge Gorsuch, as an Associate Justice of the Supreme Court, would be a jurist committed to protecting this vital freedom. None of his religious liberty opinions has ever been reversed by the Supreme Court. In fact, every time the Supreme Court reached the merits in one of these cases, it vindicated Judge Gorsuch's position, even where he had dissented. An examination of these cases reveals that Judge Gorsuch is also a remarkable consensus builder. When he sat together with judges who were appointed by a Democratic president, those judges unanimously agreed with him in 80% of those cases. Overall, he was part of a unanimous decision almost 90% of the time, and when he actually authored the religious liberty decision for the court, he produced a unanimous decision every single time, 100%. This is a striking record of coalition building in an area of jurisprudence that can be quite contentious. I'll focus my remarks on 2 areas. First, Judge Gorsuch's prisoner cases, and second, his decisions involving the Religious Freedom Restoration Act. First, Judge Gorsuch has demonstrated repeatedly that he applies the law fairly to protect religious minorities and incarcerated persons, some of the most politically powerless in our society. For example, in Yellow Bear against Lampert, Judge Gorsuch addressed a case where a Native American prisoner had requested access to a sweat lodge for religious purposes. For a unanimous panel, Judge Gorsuch authored an eloquent opinion in which he said, quote, "While those convicted of crime in our society lawfully forfeit a great many civil liberties, Congress has repeatedly instructed that the sincere exercise of religion should not be among them, at least in the absence of a compelling reason," end quote. Here there was no such compelling reason. Judge Gorsuch recognized that especially in the prison context, it is, quote, "easy for governmental officials with so much power over inmates' lives to deny capriciously one more liberty to those who have already forfeited so many others," end quote. Therefore, he wrote that the government must prove it has a good reason for denying religious liberty by offering much more than the government's, quote, "bare say-so," end quote. On this point, Justice Sonia Sotomayor quoted Yellow Bear in her concurrence in another prisoner case, Holt against Hobbs. There, a unanimous Supreme Court ruled in favor of a Beckett client, a Muslim prisoner who sought to grow a religiously required beard. In two other prisoner cases, Judge Gorsuch voted in favor of a Muslim prisoner seeking access to religiously required meals and reversed a lower court decision failing to adequately consider a pro se prisoner's request for a kosher diet. Second, regarding his RFRA cases, in Hobby Lobby and Little Sisters of the Poor, the government tried to force religious ministries and family-owned businesses to change their health plans in a way that would violate their faith or else pay millions of dollars in IRS penalties. Applying RFRA, Judge Gorsuch voted in favor of the religious objectors, and the Supreme Court vindicated his position in both cases. Now, some have tried to frame these cases as an irresolvable conflict between religious liberty and women's rights. Not so. In the Little Sisters case at the Supreme Court, the government conceded that it could still achieve its interests by allowing women to access contraceptive services on the government's own exchanges, through another government program, or through other insurance plans. The government's concessions exposed an important truth. No real conflict existed between contraceptive access and religious liberty. In closing, Judge Gorsuch has a consistent record of carefully applying the relevant statutory and constitutional provisions, as well as governing precedents, without regard to a particular ideological outcome. His jurisprudence demonstrates an even-handed application of the principle that religious liberty is fundamental to freedom and to human dignity, and that protecting the religious rights of others, even the rights of those with whom we may disagree, ultimately leads to greater protections for all of our rights. Thank you.
Thank you very much, Chairman Grassley and members of the committee. It is an honor to appear before you. My purpose here today is to not pass judgment on Judge Gorsuch, but rather to discuss the subject of originalism and constitutional interpretation. The term originalism is new, dating back essentially to the 1980s, but it has not had only one meaning. At first, it was said to be original intent. Then it was changed to original public meaning. Then it was changed by some to original public meaning abstracted to allow for technological change. Then it was changed by others to say semantic meaning that might be completely different from the common public understanding. Nevertheless, despite their lack of consensus on what originalism means and what the theory requires, those who support the theory argue that originalism should be the governing mode of constitutional interpretation. First, they suggest that originalism promotes fealty to a written constitution and is therefore consistent with the framers' design. But the early courts did not see that way. Chief Justice John Marshall wrote in McCulloch that we must never forget it is a constitution we are expounding, intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. This means that constitutional interpretation is to give meaning and substance to enduring principles over time in new contexts. The fact that the framers did not envision this approach is also evidenced in the text of the Constitution, which uses very broad words such as freedom of speech, equal protection, due process of law. Those terms are not conducive to fixed meaning, and the framers likely intended that they would be interpreted and given context over time. Third, the framers came from a common law tradition. They understood that law changed to adapt to new circumstances. It is incorrect to suggest that that was inappropriate for that to do so because the framers knew otherwise. And finally, the framers were visionaries. They were not concerned only with addressing the issues of the day. They were concerned with setting forth broad principles that would guide future generations. The irony of originalism is that while it purports fealty to the framers, it actually demeans their framers' enterprises because it suggests they were more concerned with solving the problems of 1787 than in developing a constitution that could solve the problems of 2017. Originalists also err when they suggest that their theory limits the ability of courts to insert their political preferences, at least the way originalism has been practiced by conservative jurists. For example, there is no originalist theory that can support striking down federal affirmative action, as the conservative court did in Adirondack. The text of the 14th Amendment's Equal Protection Clause does not even apply to the federal government, and history during that period indicated that there were special programs that advantaged only African Americans. Originalism does not support Citizens United. The framers did not give much credence to corporations. They distrusted them. They were very limited charters. It does not support the expanded property rights that exist in the regulatory takings doctrine. And it is worth notice that Justice Scalia, when he wrote on that, suggested those cases was supported not by text or history, but by constitutional culture. Now, in my written arguments, I suggested some results that originalism might lead to that would be troublesome. The end of one person, one vote, the overruling of Brown, the idea that there would be no equal protection for women, the abolishment of the United States Air Force. Now, to their credit, many originalists will not go that far, would not take us back to the way of life of the 19th century, and some have gone out of their way to argue that Brown can be reconciled with originalist principles, which would be news to those who drafted the 14th Amendment and also segregated the schools of the District of Columbia, and would also be news to the Brown court itself, which looked for original spaces and couldn't find it, and expressly disavowed originalism as the basis for the holding in that decision. Now, but what does this say about originalism? I think it suggests two things. I think it suggests that originalists know in their hearts that originalism is fundamentally at odds with who we are as a nation. And secondly, it also demonstrates that originalism can be used to manipulate the particular results that you want to get to, so therefore does not give the fixed meaning that those who support originalists say that it does. Originalism then is a doctrine of false promises. It suggests a fealty to the framer's design when it is actually antithetical to the framer's vision. It purports to offer jurisprudence with fixed and predictable results when its application is nebulous and variable. It claims value neutrality when it has been erratically deployed in order to achieve specific results. Certainly, text and history are important in constitutional interpretation. But the claim that constitutional interpretation should be controlled only by history and text was one that was rejected in McCulloch versus Maryland in 1819. We should learn that lesson.
Mr. Chairman, members of the committee, thank you for the opportunity to testify today. I'm a professor of law at Vanderbilt Law School, and I had the honor to clerk for Judge Gorsuch from 2007 until 2008. I am here today to enthusiastically support his nomination to the Supreme Court. Judge Gorsuch is a brilliant, fair, principled, and independent jurist. He is also the epitome of a gentleman. You will never in your life meet a kinder or more charitable public servant. One of the biggest risks a judge takes each year is inviting a few recent law school graduates into his or her chambers. Judges use law clerks as sounding boards for ideas, to spot flaws in arguments, including their own, and to find and help analyze precedent. This requires a judge to put quite a bit of faith in these recent law school graduates, and it requires them to invest quite a bit of time in teaching these recent law school graduates to be competent assistants and competent lawyers. More than that, though, working side by side in close quarters every day for a year or more makes the relationship between a judge and his or her clerks especially intimate. Judges thus often become the most important mentors young lawyers have. This mentoring role is not the most important that judges play, but it does provide a window into a judge's temperament and their approach to the law. I could not have hoped for a better mentor than Judge Gorsuch, and the country could not hope for a better teacher for its brightest legal minds. I could say a lot about Judge Gorsuch, about how he welcomes his clerks to Colorado and into his family, about how he hosted a birthday party for my one-year-old son in chambers when we didn't know anybody in Colorado. I could talk about his love of being a lawyer, the joy he takes in the back and forth of legal argument, or his concern for the integrity of our judicial system. But instead, I want to spend my time today talking about what Judge Gorsuch has taught me about writing. By the time I arrived in Judge Gorsuch's chambers, I had been in school for about 21 years, and I had probably written thousands of pages, including most of a doctoral dissertation. But I didn't really learn to write until I worked for the judge. Through conversations, reading the judge's work, reading his careful comments on my work, I learned the importance of clarity in legal writing. The judge spends hours and many drafts on just the introductory paragraphs to his opinions. These sentences, he taught the clerks, are the most important. Lawyers need to know how the court thought the Constitution, statutes, and regulations apply to the facts of a case. But even non-lawyers, the judge taught us, should be able to understand the stakes in a court case and the basic reason a case came out the way it did. The litigants themselves deserve an explanation that does not require a lawyer to interpret. I've taken this lesson with me at each stop on my legal career. Judge Gorsuch's care for writing is important in its own right because the written word is the primary medium through which judges communicate. But the judge's emphasis on writing is part of his broader concern for the process due litigants who seek the protection of our courts. As a clerk, I had the opportunity to observe over and over again Judge Gorsuch's respect for litigants and the care he took to make sure that he fairly and fully evaluated and addressed each of their claims. I have a number of examples in my written testimony, but by way of one brief example, the federal courts receive a very high number of pro se petitions from prisoners. For many of these petitioners, the Anti-Terrorism and Effective Death Penalty Act, passed by Congress in 1996, sets a bar to relief that they cannot clear, and consequently, many courts summarily dismiss these petitions. Not Judge Gorsuch. When I worked for him, he insisted that each petitioner receive a written decision on his petition. Each inmate, he told me, is entitled to an explanation he can understand, no matter how far off the mark his claim. And to be frank, many of the claims we received were prepared without the aid of counsel and were difficult to understand. No matter, the judge reminded we clerks that the court had a duty to liberally construe, that is, to give the benefit of the doubt to those who appear on their own behalf seeking the protection of the courts. The judge's concern for fair notice also underlies his deep respect for precedent. I can recall many times that Judge Gorsuch wrote that while he might have decided a case differently, a prior panel of the 10th Circuit had already addressed the question. Indeed, I had the chance this morning to look back at the 10th Circuit decision in Andrew F., which is the case that the Supreme Court decided yesterday, reversing the 10th Circuit. And in that case, the court expressly noted that the more than de minimis standard that Judge Gorsuch had applied in Thompson is actually from an earlier 10th Circuit case in Urban, and a line of cases that stretch from Urban until Thompson. I'll end by noting that in both of these instances, prisoner litigation and disabled students, Judge Gorsuch has ruled on both sides of the issue. He's come out both ways. Equally importantly, though, he has advocated for better representation for prisoners who are seeking the protection of our courts and for disabled students. Judge Gorsuch believes that access to the courts and a fair opportunity to be heard for all is a critical component of our judicial system. And with that, I will look forward to your questions.
Thank you, Mr. Meyer. Now, Ms. Phillips.
Chairman Grassley, Ranking Member Feinstein, and members of the Judiciary Committee, thank you for the opportunity to speak with you today. My name is Sandy Phillips. I am a registered Republican, a gun owner, and I live in Texas, but I now vote a straight Democratic ticket. I am a mother, and I am here to speak on my efforts to stop other families from experiencing my nightmare. I am here to speak on the gun violence that takes 33,000 American citizens' lives each year. On average, 91 Americans are killed each day, 8 of whom are children. My daughter, Jessie, was one of them. 5 years ago this July, my beautiful 24-year-old daughter, Jessica Gowie, was slaughtered in the Aurora, Colorado theater massacre, along with 11 other beautiful souls. 70 others were wounded, many with wounds that will shorten their lives. I know them. I know their struggle. I know their pain, both physical and emotional, and I understand it. My daughter went to a movie and was slaughtered. I use the word slaughtered because the killer chose to use a weapon designed for the battlefield by the military as part of his arsenal and ambushed people that could not escape. He was able to purchase 4,000 rounds of green-tip .223 high-velocity bullets over the internet without even showing his driver's license. These steel-jacketed bullets were designed to rip through bone, tissue, flesh, seats, and walls. When we sued that online seller to change their dangerous business practices, our case was thrown out because of the PLACA law. The gun lobby brags that this law was their crowning achievement because it protects the industry from being sued in civil court and denies the constitutional rights of gun violence victims to have their day in court. The night Jessie was murdered, I was texting with her. I was due to go visit her in just a few days, and we were very excited to be able to spend some mother and daughter time. The last thing she wrote to me was, "I can't wait to see you. I need my mama." I wrote back, "I need my baby girl." Minutes after that text, my phone rang. It was the young man with her that we have known for many, many years, and we think of as family. What I heard on the other end of the phone changed our lives forever. I could hear horrific screaming. I asked what was wrong. He said that there had been a shooting and it was random. I asked if he was okay. He said, "I think I've been shot twice." At this point, I grew alarmed, since he was the one calling and not my Jessie. I said, "Where's Jessie?" He answered, "I'm sorry." I asked, "Is she okay?" And he said, "I tried." I said, "Brent, oh God, please tell me she's not dead." And again, he said, "I'm sorry." Brent is a firefighter and a paramedic, so I knew at that very moment that my daughter was gone. I started screaming, I'm told, but I have little memory of my husband catching me as I collapsed on the floor. Our little girl had been hit 6 times with the .223s that sprayed the theater in mere seconds. One bullet tore through her leg and entered into the other leg, making it impossible to escape. 3 more ripped through her abdomen. 1 hit her clavicle and shattered it. And 1 exploded through her left eye, leaving a 5-inch hole that blew her brains onto the theater seats, floor, and people. I live with that image every day of my life. This preventable pain and suffering of victims and survivors has changed my life. I can no longer remain silent on the sidelines. Our Second Amendment begins with the phrase, "a well-regulated," but guns are not well-regulated. Our lack of strong federal laws let people who should not have them acquire guns too easily. People like Jesse's shooter, who showed clear signs of severe mental illness that made him dangerous to himself and others, was still able to get his hands on military-style weapons and over 4,000 bullets he bought for his attack. Since this shooting, Colorado has put restrictions on the kind of magazine he used and passed new background check laws. But over the past few years, a small number of extremists have been pushing courts across the country to accept and endorse a gun lobby-backed radical version of the Second Amendment that would call into question basic public safety law like those in Colorado. This version is the one that Justice Scalia rejected, understanding the Second Amendment is not unlimited. As a mother and an American, I believe it is critical that any Supreme Court justice understands this as well. Cases pushing these radical views could make their way to the Supreme Court in the months and years to come. This committee must know. Does this nominee believe the Second Amendment has limits? Does this nominee recognize that it does not override any other constitutional rights, like my daughter's right to live in a safe community? Does this nominee understand that as times change, laws must change, and responsible regulations to protect communities from gun violence have been recognized as and are constitutional and necessary? To be confirmed, any Supreme Court nominee must answer these questions clearly and convincingly. If not, the public's safety is at risk. Thank you for the opportunity to speak with you today.
Thank you, Mr. Chairman, and thank you to the committee for having me here today. I want to say, obviously, a very painful story for Mrs. Phillips and her daughter, Jessie. I think what I want to say to Mrs. Phillips and to the members of this committee is that Judge Gorsuch, I've known him for 13 years. Judge Gorsuch is the kind of judge that Mrs. Phillips and that Jessie would want on the bench. He's the kind of judge that applies the law fairly and even-handedly to all litigants before him. He's the kind of judge that doesn't rule based on a policy preference or a preference for an outcome, but on the law as it's written by the members of this body, the Constitution our framers wrote. He's the kind of judge that applies the law in the way we want the law to be applied. He's a judge's judge. I've known Judge Gorsuch since he was a private practice attorney at a small law firm here in Washington, D.C. I then followed Judge Gorsuch to the Justice Department in a different office, but I saw him there as a senior Justice Department official. I then went with him to the 10th Circuit when he was confirmed to the bench and spent his first 4 months with him on the bench as he became a judge. I watched him transform from a passionate, strong advocate for his clients into a passionate, strong advocate for justice under the rule of law. He's the kind of man that cares about people, that cares deeply about his family, his friends, the parties that appear before him. He feels what the litigants before him feel, and he applies the law fairly to each and every one of those litigants. Today we've heard from a lot of individuals on this panel about what Judge Gorsuch, if he were to confirm by this body to the Supreme Court, may or may not do on the court. But what I would direct you to is his real record in the 10 years he's been on the bench. This is not a judge that a short period of time on the bench where we can't tell what kind of judge he's going to be. We can look at his record and determine exactly what kind of judge he's going to be. Now, over the last few days, you've heard about a handful of cases where people feel like he hasn't ruled for the little guy. Well, let me tell you about some of the cases where he has ruled for the little guy. Avila v. Jostens, where he voted to allow a Hispanic employee to bring a claim of race discrimination, reversing district court. Dasgupta v. Harris, where he voted to deny qualified immunity to a university official accused of discriminating against an Asian American professor. Orr versus City of Albuquerque, where he held that 2 female police officers could bring pregnancy discrimination claims and reverse the district court there also. Gadd versus Kansas State, where he allowed a professor's sex discrimination claim to proceed. All-state sweeping, where he allowed 2 female contractors to bring a gender bias claim against a male Denver airport employee. Chapman versus Carmike Cinemas, where he voted to reverse the district court and allowed a female employee who had been sexually assaulted to bring a hostile work environment claim against her corporate employer. Dasa v. Wynn, where he voted to allow a female employee to sue her employer for gender discrimination. WD Sports, where he reversed the district court and allowed a female employee's sexual harassment suit to proceed to trial. Eisenhower v. Weber County, where Judge Gorsuch voted to allow a female court employee to bring claims against a male judge who had sexually harassed her. Ridgel Boltz v. Colvin, where Judge Gorsuch voted to reverse the district court's dismissal of a female worker's hostile work environment claim. Lauber versus City of New Cordell, where Judge Gorsuch ruled that a female employee could sue a city government for sex discrimination, again, reversing the district court. In case after case after case, Judge Gorsuch has applied the law fairly and even-handedly to litigants before him. Yes, it's true. In the occasional cases, the 3 or 4 you heard about over the last few days, Judge Gorsuch has ruled for a corporate employer. But time and time and time again, he's ruled for the little guy, the woman, the sexually harassed, the discriminated against, the disabled. So the notion somehow that Judge Gorsuch is not capable of being an even-handed, fair judge, the kind of judge that Mrs. Phillips and that Jesse deserve, is absolutely wrong. He is a judge's judge. He will be a credit to our nation and to this body, and he should be confirmed swiftly. Thank you, Mr. Chairman.
Thank you. I'm going to call on Senator Coons because he has another assignment.
Thank you very much, Mr. Chairman. I'd like to thank this entire panel. I'll take just a few minutes and ask 2 questions, if I might. Ms. Warbelow, over the course of the entire several days of hearings, Judge Gorsuch repeatedly said that he respects precedent and follows settled law. And I questioned him about critical cases, Casey, Lawrence, Obergefell. The judge also wrote that judges should, and I quote, apply the law as it is, focusing backward, not forward, and looking to text, structure, and history to decide what a reasonable reader at the time of the events in question would have understood the law to be. But these 3 critical cases, as I questioned him about, Casey, Lawrence, and Obergefell, don't merely look forward. They applied a more inclusive and modern principle of liberty and its understanding to protect the right to privacy, relationships, and marriage. Can originalism, as Judge Gorsuch defined it, protect the freedoms the Supreme Court has now recognized for LGBT individuals based on the Due Process Clause?
If we press the pause button at the exact moment in time when either the Constitution was written or any single statute was written, we miss the broader context and how it affects and applies to people's lives. It's not a surprise to anyone in this room that in the 1700s, LGBTQ community was a stranger to the law. And if we continue to advocate for a view of the Constitution that is stuck in that time period, we will always be strangers to the law. And Judge Gorsuch himself made very clear that he thought the LGBTQ community should only have recourse through the legislature, that marriage equality was not appropriate topic for the courts and should be left solely to the legislatures. But the role of the court is to recognize that minority populations are often disadvantaged when it comes to the tyranny of the majority. And a good justice looks to how people's lives are affected and how the rule of law will apply in the day-to-day.
Thank you, Ms. Warbelow. Ms. Miller, there's been a lot of discussion in the course of these hearings from President Trump's campaign promise about what kind of justice he might nominate through questioning of Judge Gorsuch this week. And the potential overruling of Roe versus Wade seems to always hover in the middle distance in these hearings. I'm concerned, however, that there's many ways that courts can and would limit women's access to health care without explicitly overruling Roe. And as you heard perhaps in my questioning of Judge Gorsuch, I had questions for him about what his standard of complicity meant and where it came from and what its consequences would be. In what ways could the court limit access to reproductive care without overturning Roe? And what does Judge Gorsuch's record say to you about how he might approach these cases?
Thank you for the question. I'm very concerned about his record and his ability to set aside personal beliefs and rule in a fair-minded, independent way. What we have seen since 2010, like I referenced in my statement, is 330 laws that have been passed to restrict women's access to abortion services, even with Roe being stable. We've seen waiting periods. We've seen requirements that close physical plants. We've seen really women, with undue burden having to travel hundreds of miles and encounter, lots of obstacles. So what we really have is a situation where a right exists on paper, but it's not the ability to access it in the real way people live their lives.
Ms. Miller, if I might, though, just to clarify, you're talking about legislatures acting. Why isn't that an appropriate venue, and what's the court's role in this?
Well, what you might, in our case, Whole Woman's Health, we brought to the Supreme Court, we were able to illustrate that legislators went too far, and the court ruled in our favor, saying you can't just pass laws willy-nilly to block people's access. They need to be substantiated by medical fact and medical evidence, and that that it put an undue burden on women's ability to access their rights to privacy and their right to safe abortion as guaranteed by Roe.
Thank you. I'd like to thank you both, and I appreciate your consideration, Mr. Chairman, and the opportunity to talk with you both about legitimate concerns about the scope of the right to privacy and its impact on people's lives. Thank you.
Thank you.
Thank you, Mr. Chairman. Let me ask Mrs. Smith some questions. I want to thank you for your work defending our first freedom, religious freedom. As you know, I'm one of the authors of the Religious Freedom Restoration Act, one of the prime authors, and also I'm the author of the Religious Land Use and Institutionalized Persons Act. Now, these statutes make it difficult for the government to substantially burden the exercise of religion. And your organization, the Beckett Fund, uses these statutes to vindicate the fundamental right to exercise religion for men and women of many faiths. Your written testimony quoted from Judge Gorsuch's concurring opinion in Hobby Lobby Stores versus Sebelius that RFRA, quote, does perhaps its most important work in protecting unpopular religious beliefs, vindicating this nation's long-held aspiration to serve as a refuge of religious tolerance, unquote. In Hobby Lobby, Judge Gorsuch's court concluded that RFRA can apply to a corporation. My guess, however, is that in your practice, the most frequent use of these statutes is to defend the individual, the little guy, if you will, since we've had talk about that we've heard so much about. It is to defend the weak and the powerless and the disfavored. Now, I have two questions about Judge Gorsuch's record in this area. First, do any of his decisions or opinions in such cases go beyond interpreting statutes the way Congress enacted them and implementing those statutes as Congress intended? And second, how critical is it to faithfully interpret and apply statutes like these when it might be controversial as well as when the plaintiffs are more sympathetic?
Thank you very much for that question, Senator Hatch. So your first question was, are there any decisions that go beyond the correct interpretation of these statutes in Judge Gorsuch's 10 years on the bench? And I've looked at a lot of his opinions that he has written where he has interpreted RFRA and its sister statute, RLUIPA, which you also mentioned. And I think his jurisprudence very clearly shows that he understands the limits of these statutes. He understands the balancing test that Congress put into these statutes, and that he has found in favor of religious parties some of the time, but he's also found against parties who are religious litigants in other cases. Hobby Lobby and Little Sisters are two examples where he was in favor of the religious objectors, and he found that there was a substantial burden on their religious exercise in those cases, and the government even ultimately conceded that they had alternative ways to meet their interests without forcing these religious objectors to violate their faith. And I think, those two cases show very clearly that there was no conflict to begin with between religious liberty and women's rights. But there's some other cases where he has held that the religious parties were either insincere or that they didn't suffer a substantial burden under RFRA. There was one case I spoke about in my written testimony where a couple had set up a fake church created to distribute marijuana, and they sought the protection of RFRA for their drug running. And Judge Gorsuch said, sorry, that's an insincere claim, and RFRA is not going to protect you there. So I think, Judge Gorsuch's ability to really require the government, as he has said over the last few days, to square its corners, to prove its case, to show that it has a good justification for what it's doing, along with his ability to really impose and recognize these reasonable limits on religious liberty where there are meritless claims, shows that he has a very balanced and thoughtful approach to applying these statutes, as he has done so over the last 10 years on the 10th Circuit. And how critical is it that these statutes be faithfully interpreted and faithfully applied? Well, it's absolutely critical. And as you know, Senator, RFRA has been used to protect religious minorities around the country, and certainly many of Beckett's clients are religious minorities. I'm thinking here of Pastor Soto, who is a pastor of a Native American church out in Texas, and the government created Operation Powwow and went in undercover and invaded his religious circle to confiscate eagle feathers. Now, it was because of RFRA, and I might also add the Hobby Lobby decision, which the court cited, that he was able to get those precious eagle feathers back and use them in his religious ceremonies. It was also RFRA who helped another of Beckett's clients, Captain Simmer Singh, who is a devoted Sikh, to be able to ask the Army to give him an accommodation so that he could wear a religious beard and a turban according to the requirements of his faith. And eventually, he was able to get that accommodation thanks to RFRA. And then eventually the Army was actually willing to change its regulations so that now all Sikhs can faithfully serve in the Army and not have to deny their faith in doing so. So I appreciate the question, Senator. I think it's a really important point that we make here, that RFRA and RLUIPA protect religious minorities around the country and do this vital work of preserving religious freedom.
Well, thank you so much.
Senator Franken.
Thank you, Mr. Chairman. Ms. Phillips, thank you for your testimony honoring your daughter.
Thank you very much.
So sorry for your loss.
Thank you. I appreciate that. I'd also like to ask Senator Grassley if he would please make note in the record that this gentleman next to me does not speak for me or my dead daughter.
You just made that point, and we accept it.
Okay, Ms. Clark, thank you for being here today. I'd like to talk about voting rights. Now, as Judge Gorsuch and I discussed yesterday, the Supreme Court's Shelby County decision gutted the preclearance provision of the Voting Rights Act, which required certain states with a history of engaging in discriminatory practices at the polls to get the federal government's approval before making changes to the voting laws. Shelby County struck down the provision that determined which states were covered by preclearance, meaning that none are. I'm not sure that people fully appreciate just how quickly some of the states previously covered by preclearance reacted to Shelby County, the Shelby County decision. Let's look at North Carolina. The Shelby County decision was issued on June 23, 2013. North Carolina legislators had already teed up a photo ID bill in anticipation of the ruling, and within hours of the decision, a state senator indicated that it would start to move, and it did. Additional provisions were added, and the North Carolina Senate approved an omnibus package of restrictions on July 25th, 2013, 2 days later. No African-American member of the state Senate voted for the bill. The House approved the Senate's bill later that same day. The governor signed it on August 12, 2013. Now, after Shelby County, Section 2 of the Act remained in place, but where preclearance stopped discriminatory measures before they could do any harm, Section 2 allows plaintiffs to challenge restrictions after they have been enacted. So even though litigants successfully challenged North Carolina's restrictions under Section 2, even though the Fourth Court found that the law, quote, targeted African Americans with almost surgical precision, the Fourth Circuit didn't strike down that law until July 29, 2016. That means that some of those restrictions were on the books for years before a successful Section 2 challenge could work its way through the courts. In the meantime, these restrictions kept people from voting. According to the NAACP Legal Defense Fund, hundreds of North Carolina voters, disproportionately people of color, were not counted in the 2014 primary election because North Carolina eliminated same-day registration and allowed provisional ballots to be thrown out if they were cast at the wrong polling place. So I mentioned this to Judge Gorsuch. I wanted to know whether Judge Gorsuch was bothered by the consequences of the Shelby County decision. He said that Section 2 was still available. I responded by pointing out that bringing a challenge under Section 2 can take time. And in the time it takes to bring one of those challenges, people are robbed of their right to vote. We went around the barn a few times on this. He told me that voting is a fundamental right. I know that, but didn't answer my question. Ms. Clark, I was not reassured by my conversation with Judge Gorsuch. Now, I understand that he can't weigh in on certain policies or proposals, but as a judge who makes decisions based on the facts and the law alone, as he says, I think it's important to know whether he takes proper measures of the facts, and the fact of the matter is that Section 2 is not adequate on its own. Do you agree?
Thank you for the question, Senator Franken. Section 2 of the Voting Rights Act is no adequate substitute for the strong protections that had long been provided by the Section 5 preclearance provision of the Voting Rights Act. I believe this is an important area for the Senate to focus on. The right to vote is the most sacred civil right in our democracy. And I listened to Judge Gorsuch yesterday in response to your question. I listened to his response to Senator Leahy, who asked for his view about Justice Scalia's statement in the Shelby County argument, where he referenced the Voting Rights Act as a racial entitlement. And he refused to disavow that statement or distance himself from that statement. And I find that deeply troubling. I believe our nation deserves justices on our nation's highest court who appreciate that the right to vote is central in our democracy and understand and appreciate that that right remains under attack. You point to the example in North Carolina, and sadly, we have seen the floodgates of voting discrimination and voter suppression open all across our country since the Supreme Court's 2013 ruling in Shelby County, Alabama versus Holder. Texas is another example. On the day that the court issued its ruling, it put in place a discriminatory and burdensome photo ID requirement that on the day it went into effect, disenfranchised more than 600,000 legitimately registered voters who were without one of the forms of qualifying ID. I listened intently and carefully to Judge Gorsuch's response to questions on the right to vote and on the Voting Rights Act and remain incredibly dissatisfied. Again, our nation deserves justice who will take the bench and understand that grave challenges arising under the Voting Rights Act and other controversies concerning voting will come before the court, and we need a justice who will be prepared to ensure that what remains of the Voting Rights Act is fairly interpreted and applied.
Mr. Chairman, may I just ask consent, thank you, by the way, ask consent that the NAACP Legal Defense and Education Fund report entitled The Civil Rights Record of Judge Neil M. Gorsuch be entered into the record?
Without objection, that will be entered in. Thank you, Senator.
Thank you.
Senator Crable.
Thank you, Mr. Chairman. I don't have any questions.
Okay, then Senator Hirano.
Thank you, Mr. Chair.
Am I beginning to pronounce your name right?
I think you've been doing okay so far, otherwise I would have corrected you.
He's actually, it's a
Thank
Hirono.
you.
Hirono.
Okay, you have to add another 10 seconds to my time for that.
Add 15 seconds to her time.
Thank you. So, Ms. Clark, let me continue with Shelby County, because we talked about what happened in North Carolina and in Texas, where not only did they pass a voter suppression law, but they made it very plain their discriminatory intent. So generally, these kinds of laws do not have that kind of intent, and it is very difficult, isn't it, to prove discriminatory effect under Section 2.
Senator Hirono, it is indeed difficult, but sadly, we are seeing states and localities put voting restrictions on the books that not only have a discriminatory effect on protected minority groups, but we're seeing evidence of discriminatory purpose animating the laws in North Carolina. Texas's photo ID is one law that we believe clearly was adopted to disenfranchise African Americans, Latinos, the elderly, and students.
So the very thing that people were concerned about, because you argued the Shelby County case, the people were concerned about what happened after the court eliminated Section 5. What happened did happen, and some 13 states and maybe more are passing various kinds of laws that disenfranchise, in effect, voters. So, well, I know that you were listening to Judge Gorsuch's testimony yesterday and the day before, probably all of you were, and it was very difficult to ascertain what his judicial philosophy is, because he basically said that he would apply precedent. Let me ask Ms. Miller. You founded Whole Women's Health, and I commend you for that. Thank you for the work that you're doing. I think you're probably familiar enough with the Hobby Lobby case, where the access to contraception coverage for some, well, there are thousands of Hobby Lobby employees, and to have Hobby Lobby be referred to as a family-owned business when they basically had over probably 30,000 employees is a stretch to me. But nonetheless, there were thousands of Hobby Lobby employees whose right to contraceptive coverage was given very short shrift or no consideration at all. Ms. Miller, do you consider Judge Gorsuch's position on Hobby Lobby? Do you see Hobby Lobby as indicative of where Judge Gorsuch would be on issues relating to a woman's right to choose?
Thank you for the question. I absolutely do. I think that women have a right to health care that covers all of our health care needs, whether it's contraception, preventative care, abortion services, pregnancy, everything. And I don't think that we can be sort of set aside because of who we work for.
Professor Marshall, there are a number of ways to describe originalism, and I've come to the conclusion that originalism is used as a tool and a justification to restrict the rights of vulnerable Americans. So let me ask you this. If originalism had been applied, would the Supreme Court have would the Supreme Court's decisions have been what it was in the following cases? And I want to cite the cases to you. Griswold v. Connecticut. If they had applied originalism, would the court have come up with that decision?
No, Your Honor. No, Senator, sorry. Yes. But it would be great by me if they were appointing you to the Supreme Court.
Thank you for that. Loving v. Virginia.
No.
Virginia v. United States.
No.
Lawrence v. Texas.
No.
Obergefell v. Hodges.
No.
Thank you. So basically, you did write that it's basically a philosophy or an approach to construction that conservatives use to restrict rights.
I think it was mentioned earlier today that originalism took hold as a reaction to the Warren Court. So that might give a little bit of sense of the direction that it took. There was just some discussion of Shelby County, which I would happen to agree is one of the most important cases decided by the Supreme Court in the last 100 years because of its effect. And yet the originalist case for striking down the preclearance provisions of Section 5 is very weak. It was recently A recent article in the Harvard Law Review pointed out the fallacy behind the notion of equal dignity that the court relied on in that case. So yes, it has been selectively used. And as I pointed out in my testimony, in cases like federal affirmative action, when an originalist decision would clearly uphold federal affirmative action, the originalists slid away from that decision.
Mr. Chairman, I just wanted to express my profound sorrow for Ms. Phillips. We all share that feeling. Thank you very much for being here and testifying. Thank you, Mr. Chairman.
Thank you, Senator. Senator Kennedy, do you have any questions? Proceed.
Ms. Miller, I think I understand your position on abortion. I went to your website, and which is it's a well put together website.
Thank you.
And it's an issue that divides many Americans. Would you ever support a nominee for the United States Supreme Court that didn't agree with you on abortion?
Senator, whether the nominee agrees with me, to me, is not what's at issue here. It's whether they can uphold the precedent and the rule of law.
Let me rephrase it, and I'm sorry to interrupt, but
it's okay.
They don't give me much time.
I know.
Would you ever support a nominee to the United States Supreme Court who wouldn't declare in front of the United States Senate on the judiciary that he or she supported Roe v. Wade?
I think what we've seen Judge Gorsuch do is acknowledge.
I'm asking you.
Yeah.
Would you ever support a nominee that wouldn't do that?
I'm trying to answer the question. I'm sorry, but what we've seen him do is acknowledge that Roe exists, but I haven't heard him affirm that he's
I'm
going
not
to
asking
uphold
about Judge Gorsuch. I'm sorry. I'm probably not being clear. Would you support any nominee for the United States Supreme Court who didn't come before this panel and say, I support Roe v. Wade?
I believe that Roe v. Wade is precedent and that it's important for the justices to uphold precedent.
Okay. Is that a yes?
Yes, it is.
Okay. And look, that's your right. You're an American. I mean, you can believe what you want. I do have to ask you this, though. You made a charge that Judge Gorsuch decides cases purely on the basis of his personal policy preferences. And that's a pretty serious charge. What's your basis for saying that?
So what I said is I'm concerned that he won't be able to set aside his personal beliefs and rule independently.
Why do you say that? What's your evidence for that?
Because I have seen him in the Hobby Lobby case and the Planned Parenthood v. Utah case. I think that he ruled in favor, as you guys say, of the big guy. I would say of the, I tend to side with the little gal, and I'm concerned that women's rights were set aside in favor of big business.
Do you think judges ought to decide cases based on the wealth or status or power of the parties, based on the identity of the parties?
Absolutely not.
You just said you always support the little guy, whatever that is.
I'm concerned that women's rights were set aside in favor of a large corporation.
And
in the Hobby Lobby case.
What's your evidence for saying that?
The Hobby Lobby case?
Now, what's your evidence for making the statement about the judges in that case decided it purely on their personal policy preferences?
Because I think the beliefs got I think personal beliefs and religious beliefs got in the way of objectivity when women are trying to access health care.
And what's your evidence for saying that?
Reading the Hobby Lobby case?
The result?
Yes.
Okay.
Yes.
Professor Meyer, how do you like Vanderbilt?
Very much, Senator. Thank you.
Yeah, you go to the basketball games?
Sometimes. We probably shouldn't talk about how the first round ended at the NCAA tournament. Yeah, thank you. Thank you for bringing that up.
You spent a year with Judge Gorsuch.
I did, yes.
Yeah. You saw him when he was tired?
I did.
Saw him when he was under pressure?
I did.
You probably saw him more than you saw his spouse that year, didn't you?
Yes.
He works pretty hard, does he?
He does work very hard.
Works you pretty hard too, doesn't he?
Yes, he did.
You ever see him decide a case based purely on his personal policy preferences?
I didn't ever see him bring his personal policy preferences into chambers at all, ever.
You ever see him walk in and say, okay, Mr. Clerk, don't show me the briefs here. We'll look at those later. Let's go do some research on who the parties are.
No. That never happened. He pays scrupulous attention to the briefs.
You ever seen him decide a case based on a litigant's wealth?
No.
You spend, how long did you spend with him?
I worked for him for about 14 months.
14 months. You ever see him in 14 months decide a case based on a litigant's status or power?
No,
Did you ever see him succumb to political pressure?
not at all, not once.
Okay. Did you ever see him sit down and use a tick sheet to say, okay, I've decided this many cases for the little guy, whatever that is, and this many cases for the big guy. So we need to give one to the little guy? Did he ever, is that his approach?
Absolutely not, Senator.
I'm out of time. Thank you. Thank you, Mr. Chairman.
Thank you, Senator.
Senator Blumenthal is next, but I'm hoping that if no other members come in who haven't asked questions, that I'll ask my questions and then I'll close. Senator Blumenthal.
Yes, thank you.
Yeah.
First of all, Ms. Phillips, there's nothing anyone can say here to ease the pain or close the hurt. And I know from having worked with families of Sandy Hook and many, many others around Connecticut and the country, how senselessly and needlessly you suffer as a result of gun violence. And all I can do is pledge to you that more than saying anything, I will continue to work as hard and long as possible for common sense measures that will stop gun violence in this country.
Senator Blumenthal, you know you are my hero.
Well, thank you.
And the work that you are doing in Connecticut, the whole country should look to as the leadership that you have given there to emulate throughout the country. So thank you.
I deeply appreciate those comments, but much more important, I deeply appreciate the work that you are doing day in and day out. And I know that every day, as you said so eloquently at the opening, the work you do reminds you of your loss. And all I can do is stand in awe and admiration of what you are doing. And that is partly the reason why I asked Neil Gorsuch yesterday about exactly this topic and about his reading of the Heller decision, which in my view perfectly well allows measures to stop gun violence, including stopping the kind of weapon that was used to kill your daughter. The fact that this country has failed to stop the sale of such weapons and impose common sense measures like universal background checks is absolutely reprehensible. And I was disappointed in Judge Gorsuch's response to me when I asked him these questions, because he failed to agree with me in my reading of the statute and used the same kind of disclaimer that he did in response to numerous other questions that I put to him, that he wouldn't answer about a particular case or controversy, wouldn't state his personal views. And I think that a person's stance on these issues is a matter of core beliefs and principles and values that a judge brings to the bench. No matter how objective and impartial he or she may be, every judge is a flesh and blood human being, not an automaton. And I was looking to what was in his heart, as one of my colleagues put it. So I just really want to thank you for being here today and for giving a face and voice to this profoundly important American issue. Thank you very much.
I'm honored, sir. Thank you.
I want to ask Ms. Miller, I want to thank you for the great work that you're doing at Whole Women's Health and the service that you provide for women every day. And as you may know, yesterday when I asked Judge Gorsuch about Brown versus Board of Education, he said, in effect, that that decision was correctly reached, that the result was correct, that he agreed with it. But he was not willing to say the same about the cases underlying the constitutional right to privacy, which underlies the work that you do every day. It's not just the results of those cases, it's the core constitutional principle underlying them. Why is the right to privacy so important for people facing the very personal, private decisions that they do in coming to your clinic, and why is apprehension or doubt about that right so hurtful?
I appreciate your question, and I'm very thankful for your support. I can't get over the fact that candidate Trump and President Trump has been very clear that there was a litmus test for this nomination. And in addition to that, we haven't seen Judge Gorsuch affirm his support for Roe. He's acknowledged it exists. And the women's right to privacy is a fundamental right for our ability to realize our full humanity and for us to participate in society as equal citizens. We have to be able to control our reproduction, and via contraception and sometimes via access to safe abortion care. And I think that is a fundamental right that has been approved and reaffirmed by the Supreme Court for over 40 years.
Thank you. My time is up. I really want to thank all the members of the panel for being here today. This is a profoundly important proceeding for the nation, and you're making a great contribution. Thank you so much.
I've got 3 questions I want to ask, and I'd like to have my time start now, but I want to yield a few seconds to Senator Kennedy because he asked for that. Go ahead.
Thank you, Mr. Chairman.
Out of my time.
I'll be lightning fast if it's coming out of your time. Professor Jaffer, am I saying that right?
Yes, sir.
I just want to clear up the record. Did you mean to speak for anybody today other than yourself?
Thank you, Senator Kennedy, for the opportunity to clarify. I certainly did not, and I wanted to apologize to Mrs. Phillips. I did not mean to suggest that I was speaking on behalf of her or her family.
Okay. I didn't take it that way, but I appreciate you clearing the record. Thank you.
Yeah. I bet Mr. Kirsanow thinks if I ask him a question that it's because he hasn't spoken lately, but I do have a question for you. You have watched the last 2 days of testimony. A lot of it has focused on Judge Gorsuch's record on civil rights. I'd like to focus first on the cases that he decided alleging discrimination on the basis of race. What conclusions can you draw from his record in this area?
The conclusions are, as I testified, that when it comes to the application of the law, that Judge Gorsuch is precise, he is a faithful applicant of the law to the facts, and if you're looking for an outcome-driven judge, he's your wrong judge. If you're looking for someone who will apply the statutory text as written by this body, that's your judge.
Okay. Now, Ms. Smith, now while Hobby Lobby seems to get the most attention, Judge Gorsuch has applied federal law protecting religious freedom, specifically the Religious Land Use and Institutional Persons Act. I think you referred to that already, to protect the First Amendment rights of other Americans as well. For example, could you tell us a bit about Calbone? And then I think you already mentioned Yellow Bear, but say it again for the benefit of responding to me, and then how, so it really does, I think it's going to show that Judge Gorsuch, depending on your response, has applied these statutes to protect Americans of all faiths.
Thank you very much, Chairman. Yes, so the first case that you mentioned was Abdul Hasib against Calbone, and that was a case, I think, that really demonstrates just what a fair judge Judge Gorsuch is, because he was on that panel and they had a pro se prisoner bring this claim for a religiously required diet. and it was a Muslim prisoner. And the panel decided that there would be potentially some merit to some of the claims that he had brought. And so the panel decided that they were going to appoint counsel in that case. So they appointed counsel so that this Muslim prisoner would have the benefit of a real lawyer who knew what he was doing to help him argue his case effectively before the court. They also gave an extended schedule, so they extended the briefing schedule so they had more time to really dig deeply into these claims. And ultimately, that panel decided that this Muslim prisoner was due a religiously required diet under the Religious Land Use and Institutionalized Persons Act, and Judge Gorsuch agreed with that decision of the court. And then in Yellow Bear, the case that I discussed in my opening statement, it's a very significant case involving a Native American prisoner who had claimed that he was being denied access to a sweat lodge, which was essential to his religious practice, being a Northern Arapaho Native American. And Judge Gorsuch, in a unanimous opinion, wrote an eloquent opinion saying that, you know, prisoners are denied so many of their civil liberties when they go to prison, but religious exercise should not be one of them. And he went on to find that the government had not proven its case, that they had not shown that they had a compelling reason to deny him access to this sweat lodge. And so, again, in that case, the little guy, the Native American prisoner, prevailed in that case. And I think both of these are really important cases to show that, you know, Judge Gorsuch applies federal statutes as Congress has written them to protect the religious liberty of, in these two cases, a Muslim prisoner and a Native American prisoner.
Thank you very much. Now, Mr. Meyer, my last question. Since you worked with him for a year, I think you can touch on this issue. What does he look to get out of advocates during oral arguments? Have you ever witnessed him change his mind about a case during oral argument?
Thank you, Senator. Oral argument is incredibly important to the judge. It's part of the basic notion that the litigant should have a fair opportunity to be heard. And yes, I have seen the judge change his mind based on oral arguments. The briefs, of course, are the fullest presentation of the parties' arguments. But what oral argument does is it gives you the opportunity to interact and pose some questions to counsel that they may have not actually addressed in their briefs. And I've seen in a number of cases that the judge's thinking has been shaped on certain questions by the exchanges he's had with counsel. His preparation for oral argument is incredible. I mean, the number of hours he devotes to the briefs and then thinking through all of the issues in the briefs and background research is really incredible. It's a huge amount of time.
Okay. Senator Blumenthal, I was told you'd like to ask one more question.
I have one more brief question.
Go ahead.
Mr. Chairman.
Please proceed.
Professor Marshall, I was struck in your testimony by your reference to Brown versus Board of Education. And as you'll note in my discussion with Ms. Miller, I mentioned the distinction that there was in Judge Gorsuch's comments on the privacy cases versus Brown in the way that he acknowledged that the privacy cases were decisions of the court, and he declined to say whether or not he thought they were correct, and Brown versus Board of Education, which he said, in effect, was correctly decided. So my question is, when I saw the reference to Brown, it reminded me of a question that I did not have time to raise yesterday with Judge Gorsuch, which is whether Brown versus Board of Education is somehow distinguishable because it is an originalist case. I don't believe it is, but you're the professor, so let me ask you.
No, it's not an originalist case, or at least if it was, it would be a surprise to the framers and the drafters of the 14th Amendment who supported segregated schools in the District of Columbia. It would be a surprise to the justices who wrote and signed on to the Brown case. They looked for an originalist backing. They specifically requested information on whether it was supported by originalism. They were told no, and they decided the case anyway. So it is very difficult to get to that point. Some originalists try to get there, and the reason why they try to get there is because of how difficult it would be to say we have a theory of the Constitution that doesn't support Brown versus Board of Education. But my answer would be the problem isn't with Brown versus Board of Education. The problem is with the theory that, if honestly applied, doesn't get there.
And just by way of historical enlightenment, I think I remember correctly, it's been a while since I looked at the history. Actually, Chief Justice Warren asked Justice Frankfurter to find an originalist justification for Brown. He went to one of his law clerks, I think it was Alexander Bickel, who then wrote about it subsequently, and Bickel couldn't find anything, Frankfurter couldn't find anything, and Warren said, well, we're going to reach the result anyway. We'll write the opinion without an originalist justification. Am I roughly correct in that?
You're absolutely correct.
Thank you.
Yeah.
I'm sorry I'm not in your law school class.
If you want to,
I think you could teach it.
if you want a review or a view of a farmer after that discussion, I would say that you very clearly say that it's not originalist. Gorsuch said that it wasn't, and I think you backed up what he said, because he said yesterday that he didn't consider that part of, or that you can call him an originalist, at least on that point. Okay, I want to thank
you, Mr. Chairman, for your courtesy and being able to ask a question.
Yeah. So it's my opportunity for the third time today to thank the panel for participating. I know it takes a lot of work for time to be here, your presentation and your preparation, and it's all part of a very important part that Congress doesn't get, and thank God doesn't get involved in very often, because we do have continuity on the Supreme Court, but it's very important for all the testimonies. So I want to thank you for that. And then for the benefit of the committee, I said earlier this week, so this shouldn't come as a surprise, questions for the record are due by tomorrow at 5 p.m. The record will also remain open until tomorrow at 5 p.m. The hearing is now adjourned. Thank you all.
Is it?